They can become nocturnal when they have a lot of pressure, but as I said before, we've shot a lot of hogs in the daytime.
Sure.
You can ride up on them and yeah.
But has anybody testified they were out looking to shoot hogs that afternoon?
I don't know what all the testimony's been in this
Okay.
trial.
All I'm saying is there seems to be some implication they would not ride around the property without an AR or some sort of blackout.
Hello, everyone.
That,
Great.
right?
The alt volume's working.
cannot.
Fantastic.
Okay.
That's nice.
So let's talk a little bit about what you heard from Alec the night of June 7th. You would agree with me that, well, let's ask it this way. What your practice is primarily personal injury, is that correct?
It is.
Catastrophic injuries.
Well, I handle a lot of catastrophic injury cases.
Cases, for instance, where a husband and wife are riding down
He's
the
Attorney
road by a
Tom.
tractor trailer. And by way of example, maybe you could give me something more specific. Husband's killed, wife's severely injured. That kind of thing.
Yeah.
Now, is it your experience in people who undergo, maybe they're not hurt, but their loved one is hurt, maybe killed, in that situation, that's a traumatic experience for the surviving person,
No,
correct?
that's not going to work.
To see their loved one killed?
There we go.
Yes.
Okay. And so when you sit down with those folks and begin to recount with them what happened that night, oftentimes, I do a little work like you do, oftentimes those folks misremember or get times wrong, or because they went through this very traumatic experience, and the closer to that experience, the more likely they are to get some things wrong. Times, for instance. Is that your experience?
They can, but I also find that people who have been involved in traumatic experiences try to be very accurate with the details because they know it's important to me representing them.
And typically, you don't go out to the scene of the crime and interview, or the scene of the accident and interview them that night, do you? Typically?
Well, typically you don't because you don't know that it's happened.
Well, sometimes in the old days they used to do that, but they don't do that anymore, right?
That would be very rare.
So you're seeing them in your office weeks later?
It can be days, can be weeks.
Okay. And in that atmosphere, it's a little more conducive to them being as accurate as possible, right?
It is, but oftentimes we also have the benefit of recorded interviews when there's a catastrophic injury. Typically, the highway patrol will try to interview people as quickly as they can, and they will. We oftentimes have it on video off a dash cam or sometimes body cam, but and a lot of times written statements.
And written statements from witnesses who saw it happen.
Correct.
And so when you interview those people, they have the benefit of reviewing whatever you have to help them get a better recollection of what happened, correct?
That's correct.
Okay. So the instance you're talking about where Alec told you he turned him over before he made the 911 call, whatever it was, I'm not quite sure. Before, I think is what you said. If that would be inconsistent with something he says later on, after having reviewed other people's statements, looking at video, that would not be unusual in your business. I think you just said it would not be unusual, correct?
What was the question?
Strike that.
You're trying to take me somewhere that you probably don't want to.
Oh, no, I think I want to.
Answer the question.
Withdraw the question. Let me ask you this question. Maybe let's get to the meat of matter here. Have you had to come out of pocket to pay back the money he stole?
Yes, and if you,
How much?
and
Don't tell me you don't know.
well, we're still counting, Mr. Hartpootlian.
Well, how much have you paid so far?
We have had to borrow millions to pay back.
No, how much have you
President
had to come out of pocket?
Well, when you borrow it, you got to pay it back, and I couldn't tell you how much has exactly been paid back as of we sit here today. But yes, and if you're implying that I would come in here and somehow shade truth in any way because of that, that's I would take high offense with that, Mr. Harpootlian.
I bet you would.
High offense. Are you angry at him for stealing your money?
I have no feeling one way or the
I
other.
don't have any feeling about Alex Murdaugh betraying you and stealing your money. I admire you. I don't know that I could look beyond that.
Objection, Your Honor. Objection. It's sustained. It's not a question. The jury is to disregard the argument.
You are not angry with Alex Murdaugh?
I have had anger with him, extreme anger, Mr. Harpootlian, because of what he did to my law firm, my partners, my client, his clients, our clients, what he did to his family, what he's did to so many people. Yes, I experienced a lot of anger. But you can't walk around with anger. You have to find a way to deal with it and move forward. And I have done that. And if you suggest
I can
you are
definitely tell you
dead
don't have
wrong,
any
if you
anger,
think I've
sir.
come in here and told this jury
Wow,
something
your
because of
anger
money,
levels, wow.
when
I mean,
we're
you know,
talking about
you
two
have
people
let it
who
go.
were brutally
Let it
murdered,
go.
then you're headed in the wrong direction.
Do you think he did it?
You always like.
I don't have an opinion. I don't have the benefit of
You don't
the
have an
materials
opinion,
you
really.
have.
Sure you don't. Okay, great.
You're angry with him, stole millions of dollars from your firm. You admit your firm's not even called the Murdaugh firm anymore, right?
It is not. I don't admit that I'm angry right now. I told you I've gotten away from that. I don't have any feelings because you can't walk around with anger. I have been very, very angry about it because of what he's done. And he did it in a very callous way, a very deceitful way.
And you carry no. I'm sorry.
No, you don't have to hit the point. I think the jury's got it.
No, you keep trying to push a question and don't want to accept my answer, which is what it is.
That you've just given your Zen, your Nirvana, your whatever.
Zen, that's nice.
Mr. Harpootlian,
Forgiven him?
I came to the scene of these murders to support my partner. I was there. I saw things that hadn't even been talked about in this courtroom. I was there. I love Paul very much. I thought I knew who Alec was. I did not. And it's hard to you might not understand, but it's hard to walk around with anger, and hard to even walk around with it when it's with somebody who you didn't know and didn't understand. So you might have be that way, but you know, I've got to function, I've got a family, I've got to move on with life.
Were you aware that he went to rehab in 2017?
I was not,
Really?
other than what was said by Alec in this courtroom.
You never were aware he had a drug problem?
I was unaware.
Okay. Sort of.
And if I would have been known, I would have tried to help him.
You indicated that he could be emotional in trying a case, correct?
He could be. He was theatric, much like his father and grandfather had a courtroom theatrics, and he could be emotional.
Any of your other partners that way? Johnny Parker?
No, Johnny's quite the opposite. Johnny's very
Laconic, I believe, is the best way to describe it.
he doesn't show emotion.
Nobody else in your firm was theatric or emotional?
Not to Alec's level.
You don't know any other lawyers in the state that go to that level?
You're asking me a question right now. I don't know. You might yourself. I don't know. I don't know what other lawyers do. I'm usually trying cases against defense attorneys, so I don't get to see plaintiffs' lawyers anymore.
Okay. Well, I want to thank you for. Let me ask you one last thing. This Bullware guy that he stole all the money from, Mr. Bullware, remember him?
Yes, I remember him.
How much money did you steal from him? Do you remember?
He stole 70-something thousand in June of 2018. Mr. Bulwer died in September, I believe, of 2018, and I believe another 270-something thousand after Mr. Bulwer's death, sometime in or around February of 2019.
Have you and your partners paid Mr. Bullware's estate or his folks back?
Yes, I met with them personally.
Okay. And even though it's cost you your firm and it's cost millions of dollars to you, you have forgiven him? You bear him no ill?
I didn't say I forgave him.
You're just not angry about it anymore?
I said I have no feelings. And I had to work on that, Mr. Harpootlian. You know, when you go through what we've gone through, not only the trauma of losing people
Former
love
partner in
in
a
a
law
double
firm had to pay
homicide,
millions of dollars out of pocket. He
seeing
has
the
no feelings about
aftermath,
it.
and then
Wow.
learning that someone you worked
How do you feel
with
about Murdaugh?
for
Do you
more
have
than
any
20
feelings about
years had
that?
been stealing throughout a period of time and deceiving us. There's a lot of emotion there. And yes, it was bad in the fall of 2021, and I have found a way to have no feelings. It's not
I can
forgiveness.
tell you
it's
found that
just
way.
I don't have
not
any
angry
I'm
here
signing
today.
up for
You're
his
not
yoga
angry at
classes,
all.
guys.
I'm not angry. If
He's
I
gonna be
raise
my
my
yogi.
voice, it's only because of
He is
the
clearly the
implication
path.
that you were trying to
The
make out.
implication
feeling it.
that you might not want to help him in front of this jury here today because let me finish the question, because he destroyed your firm. He stole millions of dollars you had to pay back. He deceived you. All that's away and is not influencing your testimony here today at all. If you'd answer that yes or no, then you can explain.
All those things happened, and it does not influence my testimony. I take the oath that I just took very seriously. And if you've got any indication that anything I said was inaccurate, I'll be glad to address it with you.
Well, the jury can judge that. Thank you.
Well, guys, we're off to a spicy start on the state's rebuttal.
How long did you know Alec?
Since the late 90s.
And knowing what you know now, was he able to look you in your eye and lie convincing to you day in and day out?
He did.
And was he able to look juries in the eye and display emotion?
Objection, Your Honor. That is not appropriate redirect, and it's leading.
The objection is sustained.
Mr. Harpootlian asked you about some of the things that you have gone through. And is your issue with Mr. Harpootlian's questioning the implication that you would come in and shade things in front of this jury?
Objection, leading.
What is your concern with Mr. Harpootlian's questioning of you? Can you express that to the jury, please? All that he just went through with you, sitting up on the stand, having to deal with this, what is your problem with what he was trying to say?
Well, I fortunately, to start with, I took an oath to tell the truth. But we as lawyers also have oaths and obligations to a court. And it goes a lot deeper than just that oath. We are bound by rules of professional conduct, ethical rules that I take very seriously as a lawyer. To my knowledge, I enjoy a very good reputation as far as being a person of integrity. And that's what I took issue with, is him attempting, because he cannot impugn my integrity.
That's fair. Would you take a 22 if you went out looking for hogs?
Possibly a .22 Magnum, which is a long rifle.
Which is a long rifle?
Yes.
You take a long rifle, not a pistol, is that correct?
Yeah, I would never. I'm not a good shot with a pistol, but I would never take a pistol.
And what was Paul's favorite gun for shooting hogs with?
I knew he always had a .300 Blackout, but I don't know if he shot him with anything else.
Thank you. Nothing further.
Anything further?
I'm sorry, Your Honor, I just can't leave this alone.
Oh, you apparently can't. You probably should.
Is the .300 Blackout that's in evidence his favorite? The .300 Blackout with a thermal scope on it.
Yes.
Okay, thank you.
Wow. What? Wait. You haven't been excused. Did you? Did he say you're excused?
We're on the state
I
call.
remember that happening.
Reamer.
Maybe we didn't hear it, because I'm like, whoa, you're just getting off the stand. Apparently, because I don't remember the judge saying you're excused, or... Okay, I'm sorry. Who's talking
Swear
now?
affirm the testimony that you give today will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Can you have a seat on the witness stand? You will state your full name again, please, and spell your last name for the record.
Yes. It's Dr. Ellen Reamer, R-I-E-M-E-R.
And just to advise the gallery, if everybody could seal the monitors, please, and the media be advised of that. Dr. Reamer, I want to move through this. Yes. And Dr. Reamer, I don't know if I'm necessarily even going to put them up on the screen. I am going to show you some images. I know the jury have seen these, and I don't want to belabor the point, and I want to move quickly. But just very quickly, you've been previously qualified as an expert in this trial in forensic pathology. Is that correct?
Yes,
And you've done how many autopsies? Remind the jury, please.
around 5,500. Since I was last here, I've done a few more.
You've done autopsies since we've been talking? That's okay.
Okay. I haven't put anything up yet.
Have you done an autopsy in anyone in this court building? When did you perform your autopsy?
You
on
actually conducted the autopsies of Paul and Maggie in this case?
Yes, I did both of the autopsies at the request of the Colleton County coroner, who called MUSC Forensic Pathology, requesting autopsies on 2 individuals that died under his jurisdiction. I was not asked by the prosecution to perform an autopsy. It was an independent autopsy.
Your autopsy is independent. You're not hired by the prosecution or law enforcement or anything
No,
like
it's
that?
just at the request of the coroner.
All right. You've had a chance to hear the testimony of the pathologist for the defense that testified yesterday?
Yes.
All right. I want to ask you a couple of general questions and then move specifically to some of the conclusions that individual reached. But just very quickly, with skin tags, can you tell me the reliability of that in determining directionality just as a general matter?
Yeah, well, we look at these things, but just like every other thing at, finding at the autopsy, we take it in the context. So sometimes skin tags support your findings, and sometimes they're not really so reliable. So, skin tags don't tell you necessarily the direction of a wound, especially going through very soft tissue.
All right. And I'm going to show you a couple of exhibits that have been previously introduced in this particular case. I'm going to try to be very careful with these. I'm going to show you what's been marked as exhibits, defense exhibits, 159, 160, and 161. And if you could take those out and just tell me if you recognize those. And again, please be mindful of the direction in which those images are presented. Excuse me, I'm sorry.
Yes, I've seen these.
All right. And what are those images of?
They're autopsy photographs of Maggie.
All right. You heard the testimony of the defense pathologist who testified yesterday that the directionality of the injury to the side of Maggie's head with the associated injury to the breast and the abrasion actually was coming from the top down as opposed, and I say top down as if somebody's standing upright, as opposed from going towards the bottom of the body up, correct?
Yes, that's
All
what I
right.
said.
And can you please look at the images that you have and explain to the jury your conclusions and why that defense pathologist is incorrect, and who didn't conduct the autopsy to begin with, why he's incorrect?
Okay. Do you want me to show the photos?
You can, and let's just go ahead and put them up on the screen. So I'll take them. And if you could step down, please, if that's okay with your honor. And first, I'm going to show Defense Exhibit 160. Are we secure? We good? All right. All right, and that's Defense 160. And Dr. Reamer, if you can again explain to me your specific findings and how they relate to the testimony from yesterday.
Yes. So we have the abrasion on the left shoulder, clavicle area, and then we have an entrance defect in this left side of the face. We can see a hole there. It's a hole. And there was a defect in the left temporal lobe of the brain, which was included in my autopsy report. That could only have happened from that being an entrance wound.
Okay. And you mentioned during your testimony the concept of a diastatic fracture. Does that in any way relate to your conclusion in this regard?
Yeah, well, a diastatic fracture is when there's a separation of skull bones along suture lines which solidify during childhood. And usually it takes a lot of intracranial pressure to fracture a skull along the suture line.
All right. And does that relate to the conclusion that this had to be an entry wound?
Yeah, well, that's a finding. That doesn't prove that this is an entrance wound, but what I do, I have a path through the left temporal lobe, and there's, that it was associated with the diastatic fracture because of the increased pressure in the brain.
All right. And one of the things you're telling this jury is you who actually...
Objection leading.
Were you actually able to observe a hole associated with an entry wound when you physically performed this autopsy?
Yes, I physically performed the autopsy, and the way I determine direction is I have a hole.
Thank you, Sahar, for that
left
nice
ear,
comment.
which went into the brain.
I'd hope to hit
and so that's not going to
125 by
happen
the end of
in
this
opposite
trial. I
direction.
don't think that's
And
going to
I
happen.
understand that people can look at pictures.
I need about 1,500 subs.
That's like a two-dimensional
Hit 125.
view.
Maybe
but
if we get
doing
lucky.
the autopsy makes certain information available to the pathologist
see.
that is not available to an individual not performing the autopsy. And I have
You haven't hit
that
subscribe, by the
information
way.
in my report, which
Make
was
sure to hit
not,
subscribe. Tell your friends.
which was,
Retweet the
I guess,
pinned tweets.
overlooked.
Overlooked by the defense
Right,
pathologist.
yes, I'm sure.
Share on your
Right.
social media
I'm going to show you now Defense Exhibit 161.
and so forth and so on.
And there was some testimony from the defense pathologist about trying to determine directionality from this particular image. And can you please
Yeah.
tell the jury why that pathologist is wrong?
All right. Well, when we have tears of the skin, and this is a lot of tears of the subcutaneous
the like.
tissue, especially
113
in
of you
the very
get like. That's
soft
nice.
area of the body where there's a lot of fat. There's a lot of stretching, and it doesn't necessarily. We can
Smash
move
the like.
the tissue of the breast, and
Smash the
sort of
like
you can
button.
even
Do
get
it
the points to going to a different direction. This is not very impressive. It's not even really worth observing any of the skin tags. It's really very non-specific, and I think he has a very good imagination for
My chin's up. I'm in good spirits
seeing that
today.
in this photo. And it's, skin tags can be there. Sometimes they support your
That's a
findings,
good
sometimes
point,
they don't
Suzanne.
support, but they
That's a good
don't
point.
take
The way
the
they're directing us
place
out, we may
of
have to-
determining the path of the wound by
Give it
actually
a try.
following it
Let's
through the body.
Oh, Lord.
Finally, what's been marked as
Yesterday it was
Defense
4 to 5 on
159,
Today it's 7.
and is
So
this
apparently
also
4 to
a
5
representation,
means 7.
sort of the hole that
So
you
here's the
determined,
question.
and we're able to physically
How many is
observe
7?
as a entrance wound on the side of Maggie's head?
Yes.
Does anyone know? Because I don't think we do. If 4 to 5 is 7, how many is 7?
All right, let's talk a little bit
Did you count
about
to 7? Are you sure?
Paul, and you heard the defense pathologist and their subsequent expert talk about there being a contact wound to the top of Paul's head. Is that correct?
That's what he said.
All right. And you, of course, have already testified during your direct testimony that there's no way for this to be a contact wound, but now you have specific observations about the defense
Yes.
conclusions.
Well, I didn't think it was necessary for me to point out every physical
4 to
feature
5
of the
witnesses.
wound
I'm sorry
that
if I missed
demonstrates.
Yeah, yesterday
that
the state
entrance
said they were going to call
was
4 to 5
the
witnesses.
top of the left shoulder and then went
Today
into
it's
the left
7.
side of the head before exiting
what
the
will
top
be
of the
tomorrow?
head. Now, before I go on, I do want to say that I agree with the book that keeps being brought up, that when there is a contact shotgun wound to the head, there's massive gas expansion within the cranial cavity, within the skull. And what that does, it doesn't just create a hole with some, bones. I understand this was like the most severe thing you have ever seen. And you probably can't imagine that the damage to the head could be any worse. But a contact shotgun wound to the head with the associated gas expansion to the skull would not have, his face was basically intact. We would have had tears of the skin, and his eyes would have been either displaced from the orbital bones. The orbital bones were intact. Anytime there's massive gas buildup within the cranial cavity from a contact shotgun wound to the head, which the book does say is when we have the worst gas expansion, the entire face, he would have not even had a face left.
I appreciate her use of gestures.
I know what you saw was
very
awful,
animated,
and it was absolutely
which is
awful.
probably very
But
helpful,
the
to be
damage
honest.
would have been a lot worse. He would have had, like, the
She
sides
really
of his head
wants
would have
to,
gone, he would have had,
flex
his
her
entire
community
face would have
theater
been split open. Because
skills.
there's no way all of that gas expansion could occur and not cause fractures of these delicate bones in the face. His forehead was even still there. So, I agree with the book that a contact shotgun wound would cause severe gas expansion and damage to the head. What we have here is not consistent with a contact shotgun wound to the head. The damage to the head would have been much worse, even though this was already horrible. Okay, that being said, there are photographs. Okay.
Yep, and I'm going to put up what's already been admitted into evidence.
I'm ready to
State's
cast her,
Exhibit
maybe.
6.
I'm ready to cast her in whatever
And
community
if you
production
could,
we're hosting.
Doctor, just talk a little bit about
She's
this
great.
image as it illustrates what you're talking about with the face, but also, if you could, we'll go ahead and talk about with the face, and then I want to talk about the shoulder a little bit as well.
There's no skin, like torn apart of his face. His eyes are still in their correct locations. It's hard to imagine that, anything could be worse than a hole at the top right side of the back of the head. But in my 20-plus years of experience doing autopsies and seeing contact shotgun wounds to the head, which are associated with massive gas expansion in the skull, this entire face, he would have had tears, the eyes would have been either hanging down or lost, blown out. There's no way that these features are consistent with a contact shotgun wound to the head.
All right. Now, there was some discussion about the defense pathologist about shaving the top of the head for stippling or checking for stippling. And can you comment on the necessity of that in your actual autopsy that you conducted?
Okay. So, he also said that sometimes we actually don't see the soot, but he said, if Dr. Weimer shaved the area, she would have had the opportunity to see the soot. So suppose I didn't see soot, or I did see soot. First of all, I'm confident there would not have been soot because the features of this wound are not consistent with a shotgun wound to that location. First of all, the damage to the head and face would have been far more severe than it was. And then also, the wounds to the shoulder and left side of the cheek have all the features of entrance wounds.
All right. And one of the things discussed by the defense experts was sort of the large sort of oblong shape of the shoulder. Can you explain how that does not contradict your findings of that shot coming this way, that we see this injury here? And I'm going to actually put up Defense Exhibit 162 to illustrate what we're talking about.
All right. Well, so we've got basically an oblong wound here, and that's because the wound is entering at an angle along the top of the shoulder. It's not hitting the shoulder at a perpendicular angle. So it kind of grazing along the top of the shoulder. Okay, now is this, okay. So, and actually, he said that the pellets are going down. Okay, well, if you look at it as an entrance wound, they're actually going up. So it depends where you're looking at it from. If he's thinking that this is an exit wound, that this is, that the end of the wound path, then it would look to him as if the pellets are going down.
I definitely can see that.
We can see this is actually
I could definitely
an
see
entrance
she
wound
had
for
some
a
hippie
few
phases in
reasons.
her life.
First of all, if it were an exit wound, do you remember all those pellet exit wounds on Paul's left arm that came from the chest? The pellets are not just going to stop in the shoulder. There's like no resistance there. The pellets are going to continue going until they exit the left side of the arm. Okay, so they don't just stop there. The reason they're there is that's because they started there. Okay. In addition, you see all of this white material here on the edge of the entrance wound. That's styrofoam packing material that's between the pellets. So the pellets are contained within wadding, and there's styrofoam packing material between. And that would never have been deposited there. So I did not think it was when I was telling you the direction, my determination of the direction of this wound. I did not have to necessarily, it was my expert, I'm an expert at determining, forensic pathology includes establishing the direction of wounds. And because of all of these things, this was my determination. Okay, now there's another feature of this photograph. Do you see that this is coming into the left side of the, this is what I determined, left side of the cheek, and we've got all sorts of abrasions around here. Now it doesn't have the classic, what we saw on Paul's chest had those little petals, so we knew that the wadding was starting to open up. But in this case, there was wadding that was probably open as well. So we have some pellets already starting to come out. It's not entering within the wadding, but the wadding is going along and entering them. And we have all this abrasion around the left side of the cheek, the chin neck area. And that's consistent with, we're not going to have that abrasion if it's coming out. It's going to push the skin out. We're not going to have an abrasion. So, all that but even just common sense, we have that styrofoam packing material on the outside of the arm. My determination, this went up through the left cheek, out the right side of the top of the head. If it were a shotgun entrance wound, contact to the head, I don't care whether there's no way his entire facial bones and skin, his ears would have been flopped down. There's so much gas expansion that the damage to his head would have been much worse. So that's based on my experience for doing this. And, I just don't know how, I didn't mention that styrofoam packing, but that's from when the pellets are coming in. And he said, oh, you can see they're going down. That's because he's looking from above. So but if you look at where I believed and I determined by doing this autopsy that the entrance wound is, it's actually going up. So it depends which side of the pellets you're looking at. And if just logically, if this was an exit, the pellets wouldn't have just stopped there. They've got a huge amount of energy. They're going to continue through the arm and have individual pellets. They wouldn't have all just been concentrated right there. So, we can use our powers of logic, which I think, we all have, to understand how this is an entrance wound that exited the right side of the top of the head.
Dr. Reamer, having specifically, and you can take a seat now, thank you very much. Having specifically addressed the specific criticisms of the defense pathologist, in your expert opinion, having actually done the autopsies in this case, is there any way that could have been a contact wound to the top of the head?
No.
All right. And having addressed the specific concerns of the and testimony of the defense pathologist as it relates to Maggie, is your conclusion still that the shot went in the direction as you described before?
Yes, I disagree with his conclusions.
All right, thank you very much, Dr. Reamer. Please answer any questions the defense counsel may have.
Bittner v. U.S. What is Bittner v. U.S.?
Dr.
Wow.
Reamer, good to see you again.
Hello.
We got 2 Supreme Court
So,
decisions that just came down this morning, so we'll discuss that at some point today, too.
You took pictures,
fun.
correct?
I took pictures. I wish I took more pictures now, but I took pictures.
I'm sorry.
Yes, I would have. I wish I took even more pictures.
So do we. So, you made notes, which you converted into an autopsy
Yeah,
report.
it's a standard operating procedure.
Yeah, no. But so, and that's done so that somebody else can look at your work and see if they agree or disagree with you.
No, the notes are a work product for me while I'm preparing, doing my examination. I don't always, I take notes, I write numbers, but that is really for me so I can incorporate findings into an autopsy report that I'm going to write. And I don't write it the same while I'm at the table. I need to go away. Maybe I'm going to do it the next day, that night. So, but it's not done. People say, oh, can I have a copy of the autopsy diagram? Well, these are not autopsy diagrams that are meant for other people to look at, and sometimes they're not even completely accurate because I mark things on the outside of the body that later on during the course of the autopsy I determine, I'm like, oh, well, that's what that is. And it may not be what I initially wrote down. But by the time the autopsy's over, I've put it all together. And that
So you write down
diagram
bullshit?
or notes do not necessarily reflect everything, that I concluded.
You still have your notes in this case?
I imagine they would be in the file, but as I told you, this is my notes are not necessarily the conclusion that I came to.
Did you produce them to the state?
I don't know what I did. I personally, if they were asked for, I'm sure I did.
Did you produce them to us?
No, I don't remember producing them at all. I don't have a request for those notes in my file.
But those notes would be your present sense impression as you're doing the autopsy, correct?
Well, they can have a lot of things written down on them.
But we don't know because we didn't get them, right?
Well, they're not important. What's important is they're my notes.
Sure.
They're for me. They're an aid to the pathologist.
Notes are important.
Even if I thought something initially,
of my
and then
observations
while I do the autopsy,
important in any way.
by the time I get to
I
the
thought
end,
it
it
was
could
this, but then I
disagree.
concluded
I don't
it was
necessarily
this,
go
but
back and change
it's
the
not
diagram.
important.
It's my work product. It's for me to aid me in writing my autopsy report.
Mm-hmm.
It's not for public view. It's not a statement of my conclusions.
Okay. Did you review those notes before your testimony previously or today?
No.
Okay, so you just go with your report.
Well, I reviewed my report, correct.
Right. But you don't go back and look at your notes.
No.
So let me ask you some basic questions here. You've previously testified that the muzzle of the shotgun for this wound here that goes through his neck and out the top of his head was about 3 feet away.
That would be about right.
Okay. Now, you're familiar with this page from, I believe you've described the...
Oh, yes, I've seen it many times.
Okay. And as you see, the gas comes out, right, in the first shot, the top
Yes.
shot. And then actually there's sort of a blowback of gas as the, as we can see right here, the projectile, which is the pellets, are extruded from the barrel, right? I mean, the gas pushes the pellets out.
Well, there's
Yeah,
gas
that doesn't
expansion,
work.
and that helps propel the pellets, yes. I agree with the book. This was not a contact shotgun wound to the top of the head.
Okay, well, the book doesn't say that. But what the book does say is that as the pellets come out, at some point they begin to, the container opens and the pellets expand or move out in a pattern, a circular pattern. It becomes bigger as the further away you get, correct?
Yes, and that's what we have here.
Okay,
But this is actually demonstrating specifically a contact shotgun wound to head. But we do have splaying outward of the pellets. We can see on the left shoulder, they're fairly clustered together because they're first starting to be released from the wadding. And they did spread out. We have some of them down in the neck, some of them in the brain, and so they are spreading out. I don't see how, yes, it's a respected treatise, but this is specific to a contact shotgun wound to head. This is what this is describing.
Really?
Well, it's fine. It doesn't matter. I can look at my photos. I can look. If you're going to talk about theory, the photos.
Doctor, Your Honor, I would ask you to tell the witness to be responsive. She is going on a diatribe. Excuse me. I'm asking the court to instruct her to answer the question as specifically as she can. She goes off on tangents, and I'm sorry.
You may continue answering the question.
You remember what the question was?
No, that's your question.
Is this series of shots from the book
Spicy.
depicting a contact
Spicy morning.
I think that's what I understood.
Yes.
Yes. Okay. So where, if you step down here, show me, please, where the contact is with the body or the head. Here, let me give you this pointer.
Well, the contact would be at the first area.
Right here?
Yes.
Well, what's it contacting?
It's not. It's just a theoretical depiction. It's a theoretical.
Is that what the book
depiction.
says?
Yeah. Well, go ahead. I don't recall the exact. Why don't you read it to me?
Well, why don't you tell me, is that a contact wound?
I don't know what this is. This is.
That's a shotgun.
That's a shotgun.
That's a shotgun being fired. Those are the pellets coming out.
Object
Those are the
counsel
pellets.
testify.
Yeah, I think this is a book showing the series of steps after a shotgun is fired. But it has nothing to do with what I found in the body and does not help me determine the direction of the wound.
All right. So.
And I'm not going to describe to you. You can read it in the book. I don't remember how he says all of this.
The book isn't testifying. You are. You've testified that depicts a contact wound. Yes?
Well, I don't know what this is depicting. It could be that this is a contact wound. I don't know where you're going with this.
Well, here's where I'm going. Is that barrel in contact with anything?
It's not in contact with anything. It looks like it's just blowing into the air.
Okay, and you've been. That's fine. And your testimony is that barrel is at least 3 feet away from Paul's shoulder. Is that correct?
It could be, depending on the weapon, it could be, it's not closer than 2 feet because we don't have the slip ring. But we do have packing material.
Okay. So, as we see here, these pellets are beginning to separate. Is it your testimony that those pellets had separated when they hit Paul's shoulder at all?
They are starting to separate. We don't have the complete, widening of it. They're still relatively clustered together, but they're not as close as they would be if they were still contained within the widening.
Okay, now, at 2 feet, is there any gas left, or is it all dissipated like this picture shows?
Well, what we have here, if there was more gas, if there was a contact wound to here.
It's not a contact wound.
I understand. The gas, you're wanting me to say yes or no, and
yes
I can't
no.
because I have the knowledge to explain how this relates to examining the body.
Okay,
I don't give theoretical talks or I don't start looking up in this book while I'm doing an autopsy. I use my practical reasoning and my experience and knowledge of things.
If there had been gas in the wound, or when it hit his shoulder or his neck, would you expect to find some physical manifestation of that?
Well, there would have been, a lot more expansion, shoulder expansion. This was fairly contained on the left shoulder.
So your testimony is there would have been little or no gas going to his shoulder, to his neck?
Well, there is always some gas, but it's not the kind of gas that we get in a contact shotgun.
Exactly. So, and you can go ahead and take a stand again, please.
This is the spiciest medical testimony I can
No, not
recall
that one.
seeing in a while.
Paul.
This is interesting, to be sure, on some levels.
Paul William family.
I don't remember the number off the top of my head.
I've done 5,500 autopsies. I've done autopsies since this trial started.
Ladies and gentlemen, have you
Possibly
taken
on members
for
of
a
the
break?
jury.
Please do not discuss
The
this.
boredom of it all. Wow, yeah. I believe in the book. And why you read it to me? Oh, Lord. Spicy, spicy. Wine mom over here is definitely going to need some wine o'clock today, baby.
Down, please do not discuss your testimony with anyone. It'll take about 10 minutes.
Oh, Lord. What a interesting day. We're off to a great and promising start here, guys. Oh, Lord. Welcome back, everyone, to Uncivil Law. Hope all is going well. Hope you all are just having a great day. I'm in positive spirits. I'm feeling good. I hope you're feeling good. Life is good. So let's talk a little bit about I 500 confirmed autopsies around. Yeah, listen here, you little shit. I'm a confirmed sniper with a blah blah. Yeah. I definitely feel Navy SEAL Coppa Pasta vibes definitely coming off this a little bit. Yes, that's for sure. It's a good one. Oh man, yeah. So first of all, yeah, yesterday the state said we have 4, maybe 5 rebuttal witnesses, right? That's what the state said yesterday. It's like we have 4, maybe 5. It depends whether we can get our 5th. We're not sure if we can get them, but we're thinking 4, maybe 5. And then today, apparently, it was 7. So yesterday it was 4, maybe 5, and today it's 7. So that leads us to the fun question: how many is 7? Can you count to 7? Are you sure? I'm not sure. Not anymore, right? That's where we're at today. So yeah, and then it's like we have Mr. I'm not angry, right? I was his law partner forever. He took money out of my pocket. He destroyed my firm, and I can't even begin to imagine what an absolute total pain in his ass this has been on every possible level. Right? I can't even begin to contemplate how much of a complete and total pain in the ass this has been for this law partner. Right? My law partner in my law firm stole $10 million from the clients. Is a level of annoyance minimum that I can't even begin to contemplate. Because somehow I have to fix all that. So I have to figure out what happened and go through that and document all that. And then I'm going to have the bar right up my ass trying to figure out whether or not I did anything wrong in all this or am doing anything wrong now. So I'm going to have the bar right up in my ass. And then I'm going to have law enforcement all up in my ass, right? I'm going to have everyone just staring at me, doing the most thorough proctology report in the history of time, trying to fix this. It is going to be a nightmare. Possibly having to change tax reports and filings with the government in terms of business filings, right? Tax filings. Because I'm just going to, the numbers were wrong. Because, the fraud. So maybe my taxes are wrong. It's possible, right? Because, how much income I did or didn't have might have been influenced in some way by this. So my taxes, my personal taxes might have to be fixed. The reporting to the government for the franchise, the taxes for the business, my clients, the feds, right up in my ass, right? So the level of annoyance would be catastrophic, right? It would be an absolute fucking nightmare to try to deal with this. But it's okay. I'm not angry anymore. Okay. Sure you're not. I'm angry just thinking about it. But it's okay. I learned how to get past my anger because we can't hold on to anger. We got to let it go. Despite, incidentally, the money I personally had to pay out of my pocket in order to make my clients whole. Right? Because that's the client's money. I thought it was my money, but it's not. So, but it's okay. I'm totally not angry because I am just that zen. Okay. And I'm not sure what he's trying to accomplish because, like, I'm angry and infuriated beyond all hope, but still I'm testifying honestly because it's my job is a pretty easy line to sell. That's an easy line to sell, right? I'm an attorney. I'm a good attorney, unlike my former client, unlike my former partner, who turns out to be the world's biggest SOB ever. But I'm a good attorney. And so I, of course, have done all the good attorney things I'm supposed to do, including making my clients whole, because I'm a good attorney. And one of my things is as an officer of the court is, I have to testify truthfully. And so I'm testifying truthfully. So I'm completely angry at my former partner for his massive deception and massive inconvenience to me personally. Right? But it's okay. I'm beyond all that because I'm just that good. I could tell. I could tell that you feel nothing. I could tell you don't feel any anger in any way, whatever. Okay. So that was a whole line of testimony that I don't really know what that was supposed to accomplish, but fine. Then we have autopsy expert over here who really loves her job, and she was doing this as also when she was on the state's direct. She really loves her job. She's really enthusiastic and would like to tell you using all the skills she learned at community theater. Now, I'm not against community theater. I think community theater kicks ass. I did improv class last night. It was my first improv class in like 3 years. It's been too long, but I did improv classes for like a year and a half, 2 years before I moved to Austin. And then, of course, I moved to Austin and the entire world shut down. And then also, I was dealing with depression and a lot of other things. But I did my first improv class in like 3 years last night, and it kicked ass, and I love it, and it's awesome. And I can totally see myself doing some community theater and acting and stuff like that because I think that would be fun. I'm going to be an artiste, guys. Not to mention also that the skill set, one would imagine, would help translate to what I'm doing here, right? So it makes me a better YouTuber. That's one of the reasons I'm doing it, incidentally. It's like skills as an improv actor would help. Skills as a stand-up would help. Skills as an actor would help. So I can use those skills and translate them and make myself a better YouTuber. Plus, it's fun in its own right. Anyways, moving back to my original point. So she is definitely using, if you told me that she does community theater, I would believe it because she has got all the tropes down. And if not, she's a natural and should totally do it. She is a natural for community theater. She'd be great. So all those things. So, but she really loves her job, and she'd like to let you know that she really loves her job. But she really does not like being contradicted, which I understand. I understand. But, she's been doing this a long time, and it's not her first time testifying. So I'd be a little bit more sympathetic to her if it were like her first time testifying as an expert. Because, being questioned and having your professional conclusions challenged can be an experience. You know, it would be experience like I know what I'm doing. Like I'm the expert. You're not the expert. You know, you're not really in a position to contradict me. I understand this, right? And I've had this to some degree, even personally, with this channel, and I've gotten better at this, incidentally, as well. So I can speak a little bit from personal experience, right? And I'm not saying I'm necessarily perfect at it now, but I'm getting better, right? Where I've had people on chat contradict me, and I get really mad because, like, I know what I'm talking about, and you don't, and you're contradicting me, and it's annoying. I'm better at this, right? But she should be even better still, because she's done 5,500 autopsies, don't you know, and been an expert witness for however long she's been doing this, and being questioned a lot. So the fact that she gets so flustered is a little less understandable. She really loves her job, and she really hates being questioned. You know, okay. But she believes what's in the book. All right. So, yeah. So there's definitely a skill set there to be had. Yeah. I'll probably do a video on it later and talk about it more, but I'll give you some initial thoughts on Vegas. Because as many of you know, I went to Vegas to do the Nick Rekieta experience thing. I'll tell you a little bit about it. It was first of all, the event itself was held in a very nice venue. It was held in a Ahmed Hotel. I'd have to double check. But there was an event space, and it was just for us, you know, private space with its own bar. So it was, I'm not sure how I describe it exactly. It was a room, and there's kind of like a bar in the middle of the room. So that kind of worked, right? And then, you know, there was a stage where they did the event, and there were probably, if I had to guess, 100 or 125 people there. I'm not sure if there's official numbers or something, but that would be what my estimate would be. In terms of the number of people that were there, about 125, 150 maybe, something like that. Iron sounds right. Iron sounds right. Yeah, something like that. And the event itself was kind of like it was just basically like a live show, like he would do. It was basically the same that he would do for like a non-legal show, where he has people on that don't do law. So he had you know, he was just doing like a non-legal show kind of thing, and just talking, and just basically just making up everything on fly. It was just like a live show, basically, is what it kind of turned out to be, and sort of his thing. And it was really nice, just because, well, Iron, yeah, something like that. Not Aria, no, not Aria, no. It was Iron, something like that. Yeah, Camelot. Yeah, Camelot, Dick Masterson, that's right. Yeah, Camelot, Dick Masterson, that's right. And then also Ty Beard got up there for a little while, which was cool. It was nice to meet him in person. I think he's lost weight since I last saw him on stream. He looked good. Anyways, but it was really, really nice because, well, it's nice being validated, and I got validated a lot. I had lots of people come up to me and shake my hand and want to take my picture and tell me they enjoyed my work. Having people come up to you for like 2 hours straight, basically, and tell you they like what you're doing, ignore the haters. You're doing great. I really enjoy your content. I enjoy having it on stream. You know, I enjoy listening to it. You're doing good. So 2 hours of validation is pretty nice. I'm not gonna lie. Yeah, so it's like, you know, so it was a very, very positive experience. And I saw people doing basically the same thing to the other lawyers who were there. I saw, you know, who was there? Andrew was there from Law of Self-Defense. He was crushing it. Of course, Nick is there. Ty Beard was there. Ani Direct was there. I didn't know she was going to be there, but it was nice meeting her in person. Ty Beard was there. Didn't know he was going to be there. That was cool. Ron Coleman was there. So that was really nice. It was and there were no haters there. There were rumors. There were rumors that the Kiwi Farm contingent was going to show up and, be disruptive or whatever, but they were not there. So it was nice. Ian and Lawn Lumber were not there. They were too busy attending the Gundys because Ian was nominated for and won an award. He won an award for Breakout Creator. So that's cool. So they were in Uvalde, where the event was being held, near San Antonio-ish, nearish San Antonio. And they were too busy. They were too busy shooting all the guns and riding in tanks to attend our event in Vegas. So, okay. I think they had a good time. They did have a gun awards show in Uvalde, yes. Did I see Ian's tie, the Canadian tie? Yeah. Yeah. So they were too busy. They were too busy riding in tanks in Uvalde to attend our lowly show in Vegas. Ian did win. Ian did win for Breakout Creator. So he won an award for Breakout Creator. So he didn't win the award for the Second Amendment Advocate Award. He didn't win that, which would have just been too hilarious. But he won Breakout Creator. So he bought barbecue at a gun store. Excellent. Excellent. So Ian had a taste of freedom. That's nice. Yeah. So the event itself was pretty good. I think they're releasing the video for it. So they filmed it and there was sound equipment, and so I think they got a good recording of it and they're going to release it, which will be interesting because I wasn't really able to hear the event itself due to the background noise. And also I was just talking to people. So I wound up talking to people pretty much the entire time rather than the show itself, which, so. But people seem to enjoy it. People had a good time. If he didn't go to Buc-ee's, I don't know whether or not he went to Buc-ee's. I hope he did and had the Buc-ee's experience. If that's the gas station he went to, if he went to Buc-ee's and had barbecue there, Buc-ee's does a really good job. I thought you meant something a little bit more fly by night than that when you said barbecue in a gas station, because I've seen some barbecues in gas stations that are a little bit more sketchy, but Buc-ee's is definitely the experience. Yeah. What's that? Buc-ee's is a gas station. Sort of. It's an experience. The event is on YouTube. Excellent. I'll have to watch that later. Yeah, I'll have to watch it. It wasn't Buc-ee's. Oh, that's disappointing. So the event in Vegas was fine. The weather wasn't so great though. It was cloudy and chilly. It actually rained when I was there, which, it's like my second or third time in Vegas, and I think every time I've been to Vegas, it's rained. So apparently Vegas is a very rainy city. But it was fine. It was a fine event. It was really nice meeting people and really nice getting my photograph taken. Really nice being validated. People said they love me. Some women said they loved me and then also told me that they were married, but they loved me. I was like, damn. Some of them were quite pretty. Oh well. I don't gamble. And I paid as you guys know from my YouTube comments section or my YouTube community section, I paid $6 for a club soda at a casino bar, which seemed a little ridiculous. But yeah. $12 for beer, $6 for club soda. How do you justify these prices?
All right, you may continue.
We'll also deviate to tell this story. You guys will like this. So to save money, I was staying at this kind of motel kind of thing. That's a little bit off the strip called Mardi Gras Hotel and Casino. It's fine. It's just it's a very sort of, it's a little fleabaggy, but it actually is kind of nice. I had trouble actually getting to the event for the Nick thing. I had trouble getting to the event because someone decided to stab a bus driver immediately outside my hotel. The bus, as I walk directly out the front door of my hotel, the city bus is right there, like right in front of my hotel, directly. Okay, and someone decided to stab the bus driver, which made it a little difficult to get to the event because the police doing the police thing blocked off the streets for like 4 blocks in every direction. So it made it a little bit difficult to get an Uber. So I had to walk. I had to walk like 1.5 miles to get to the event. So that happened. All right, trial time.
Shotgun wound to the left shoulder area.
Okay, and you a moment ago said something about packing material. What is packing material?
Yes. So there's foam that is frequently within, between pellets.
I'm sorry, just a moment. Your Honor, I can't hear her because of the noise coming through the door. I apologize, but I just need to understand what she's saying. I apologize. May I begin?
Yes, sir.
Packing material. Let's start over again. Tell me again.
Yes. So it's frequently present in the wadding along with the.
On the plus side, I was able to walk the 1.5 miles. And I got there and I wasn't completely drenched in sweat and out of breath hideously. So, hey, I'm making progress in my fitness journey. Because the fact that I was able to walk the 1.5 miles and not be completely winded and out of breath and completely drenched in sweat, we're making progress. So that's plus.
With a little bit of packing material that would, as we have pellets going into the shoulder and some of the packing materials depositing on the skin.
And is this a picture of the packing material?
There is some of the white material, yes, on the skin correct.
Did you note that in your autopsy report?
No, it was just a general observation.
Okay.
On the plus side, the club soda
Is it
at the Mardi
important it
Gras
was there?
Hotel was free.
It didn't matter to me whether it's there or not,
So-
but it does reinforce that it is an entrance wound.
But you concede it was not in your autopsy report.
Well, all the totality of my findings, I don't always write every little thing in my autopsy report. I could go on, that it could be 50 pages, an autopsy report. I include the findings, my determinations, and I could have mentioned it, but I did not,
And why not?
because it's not always necessary to mention that kind of thing.
Is it evidence of anything?
Well, I do believe that supports an entrance wound, although I don't require myself to see it in order to make that determination.
But you agree with me, it supports your conclusion, correct?
Yes,
And you didn't put in your autopsy report.
that's correct.
Would it be in your notes?
No.
Okay. So, and could you step down here and show me what the packing material looks like? And there's a pointer right over there behind you. You probably want to stand over here so the jurors over there can see it.
Yes.
Or whatever.
This is what I believe to be consistent with packing material.
And did you remove any of that to be analyzed or forensically examined?
No, I did not.
Okay, and while we're looking at this picture, you can actually see some shot in there, right?
Yes.
And that shot is that, I mean, that's pretty, that area right there is much wider than this entrance wound in his cheek, is it not?
Yes, this entrance wound is larger than this re-entrance wound here. And I believe I actually went over this last time. Frequently, there's enlargement of wound as it goes along. But in this case, we have a wound going along the top of the shoulder, so it's going to be oblong. As it enters the left neck area, it's entering more at a right angle, perpendicular to the jaw, so it's going to appear smaller. And that has nothing to do with spreading of pellets.
Okay, well, let's pursue that a little bit more. You see that pellet that's clear, I mean, clearly there. You
This
see,
pellet?
right, and then you see a pellet above it. You see that? Right.
Where?
Right. Let me put my glasses on. Is that a pellet?
Yeah, it may be a pellet. Yes.
Okay. So we have, if you step back just a little bit so this juror can see, we have pellets coming in like this, correct?
Well, they're kind of banging against each other. We have the wound track is from left to right, and we do have pellets that are in there. They stopped in there, so they're not all continuing through.
Okay. How many pellets were captured in his shoulder?
I captured. I don't know how many I captured. I collected a sampling of the pellets that were along the wound.
You don't know how many
But
pellets you
you
captured?
took X-rays.
You didn't write that down?
Yeah, but that's not necessarily the total amount, because some of them, exited and some were in the brain. So
That wasn't the
X-rays were
question. The
taken
question was
out
how
the
many
brain,
did you
the head,
capture
the
from
brain,
him?
things like that.
Okay, but you
That's
did.
not
They
the
did
total
send you
amount,
the
but
brain.
because someone
Yes.
exited.
Did you take X-rays of the brain?
No, I did not.
Why not?
I didn't take X-rays of the brain
And the
because I
reason- oh, go ahead.
determined that wasn't
I didn't,
necessary
okay?
for me at the time.
I didn't, okay?
To support your conclusion.
I didn't take X-rays of the brain. I guess hindsight is always 20/20. I could have taken X-rays of the brain. I could have taken more photos. I could have taken a photo of the brain at the autopsy. I did not, and I would have liked to. But I can tell from the examination of the body that I had an entrance wound along the left shoulder, and it's exiting at the top of the head. It's not a contact wound to the top of the head.
Okay.
That's my determination.
Okay, but the reason you didn't take X-rays of the brain was you'd already reached your conclusion, correct? that you didn't need it because this was an entrance wound.
Well, I did not, because I felt comfortable with my determination.
And decided therefore not to take x-rays of the brain.
Well, I don't always take x-rays of every organ. I was comfortable I would be able to recover some pellets on the brain, and it wasn't necessary to show the spread.
How many cases have you been involved in where the brain literally exploded out of the head? I mean, that weren't suicides.
Where the brain exploded out of the head?
Well, as the book describes it,
Well, I think that the determination that an entrance wound to the top of the head, contact range, all of that gas
Thank you, Alan,
expansion
for the gift
would
memberships.
not have-
50
the brain
gift
would not have
memberships. That is a
escaped that.
generous
There would have
donation.
been a
Thank you, Alan,
defect,
very much.
cavity or fragmentation of the brain, which was not there. You can see the brain actually.
do you remember what my original question was?
What was your question?
Okay, my question was, how many cases have you done an autopsy of a contact wound to the top of the head which wasn't a suicide?
Very, very few.
Less than one?
I don't remember exactly, but it's not a tip. Usually contact shotgun wounds, are suicides.
And typically it's in the mouth.
They can be under the
Under the
chin,
chin.
in the mouth, sometimes they're to the side of the head. There are people that do shoot themselves to the top of the head as well. And I can't recall exactly if, I remember any of those.
And in all those cases of the brain that explode out of the cranium?
No.
Okay. So you would agree with me that the way that well, strike that. Let's go a little bit further with where we're going here. Could you put up the X-ray of the shoulder? You can go ahead and take your seat and testify from up there. Okay, tell us what this is.
Yes, they are pellets, and I have his shoulder, kind of out when I take the wound. We have some pellets remaining in the shoulder area. We have some disruption of the shoulder tissue here, some of the bone, and then we have some. We actually have less. We have more spread. They're more spread out as they're going closer to the neck.
So there are pellets in the top of the arm, the shoulder. Where is this? Right up in here?
Yes.
Okay. And then there's additional pellets, it looks like, down below that, like near his ribs, correct?
That's because it's starting to spread, yes.
And it's starting to spread to get to this place right here.
What place?
Is this where
No, it's in the neck.
It's in the neck. Okay.
And indicated that I recovered. It's over here, then some of it is actually in the trachea as well. So that's the windpipe of the neck. So we have some in the neck. This is the chest area. It did not go into the chest.
Okay, let me see another X-ray, please. What was that exhibit? I'm sorry, I didn't announce it.
112.
112. Okay, let me see the next X-ray. Okay, and where is that?
That is the top of the left shoulder and the left arm.
Okay. And you see a number of pellets there.
Yes.
With
That
your
would be
50 gift
right in
memberships,
this area right here?
you helped
Yes.
pay for
Okay.
some club
Next,
soda
there's
in
One
Vegas.
more X-ray. Okay, and are there any pellets here?
I can now
Are those
afford
the same
like 6 or
pellets down
7
there?
club sodas in
At the
Vegas.
bottom?
Yeah, well, we
see-
have, you can see, there are pellets here. You can see them in the head, There's some pellets in the head. The brain is not within the cranial cavity, but we do see some of the pellets ended up over here on the right side. See, R for right. There's the hole at the top of the head, and some of the pellets they're spread out on the right side of the head.
How many?
Well, I can see there's 3 here.
3?
On the right side of the head.
Okay.
Yes.
So if how many pellets are there in a 12-gauge shotgun shell, and these are used primarily for duck hunting?
I don't know. I don't know the answer to that. I'm an expert at examining human bodies and determining the injuries that occurred, and I don't know how many pellets would be. When I took my boards, I may have had to actually know that, but I don't. I don't use this information in order. You can ask your ballistics expert.
Well, we did, and I think they said something like.
I don't really know the answer to that. I'm not going to disagree with the ballistics expert. I do have a trajectory an exit wound on the right side of the back of the head.
How many pellets were in the body?
I did not count them. I just collect a representative sample of it. I don't collect all of them, and I don't count all of them.
And we know you don't know how many were in the brain because you didn't X-ray the brain, correct?
That's correct.
But if there were 70 pellets or 75 pellets in his shoulder, his chest, and his neck, and hypothetically there are anywhere between 135 and 160 pellets in the normal duck shot, that's 40 pellets that travel on, for the sake of argument, correct?
Well,
my math.
I don't
use
really,
my math.
I don't feel comfortable answering these questions because it's not, the specific ballistics are not my area of expertise.
I'm not going to ask you about
I really don't
ballistics.
feel comfortable answering them. I examine human bodies and come to my determinations based on the wounds, and I can see I was correct that this is a shotgun wound to the left shoulder that's going up.
You're correct
to the
about
right side.
everything. You're correct
And
always forever.
questions about numbers I really don't want to I can't answer that because, I don't know everything. I'm an expert.
You don't?
I'm a
Are you sure?
physician. I'm an
I think you do.
expert
I think you do know everything
examining
because you're just that good.
human deceased individuals,
I think
determining
you know all
cause
the
and manner
things
of death.
forever.
Okay, let's go back to the original question, and assume.
I don't know the answer to the shotgun, how many pellets there would be.
We're not asking you how many pellets, but if there are 75 pellets, let's do some math here. This is simple math.
Okay, I can do math.
Okay, 75 pellets we can count in the body, the chest, the neck, and there's anywhere from 135 to 165 pellets in the normal duck shot, 12-gauge shot.
Right, so 75
what
plus
a day
60,
to come back
that
to
would be
being a streamer,
135.
man. What
And
a
then
day to
what did
come
you say,
back.
70 or 80?
75.
Okay, 75. So we started with 75, plus 75 is 150. So that's your answer. If your question is, you're asking me to do the math.
So my question is this. After those pellets have gone through the shoulder and hit bone, apparently, correct?
Yes.
And then they go through the neck. Do they hit
All
more
right.
bone there?
There was some damage to the cartilage of the trachea. It was in the tracheal wall and some muscle. There's not a lot of bone in the neck. The only bone really in the neck is the spinal column.
Neck
Well,
bone
I
connects
guess what
to
I'm
the
saying,
backbone. Backbone connects to the leg
when you were
bone.
talking about Maggie a moment ago, and you talked about a shot that I think grazed her skull, you said there was a lot of intracranial pressure. Is that right? Created a lot of intracranial pressure.
Yes.
Okay. So I'm trying to figure out, and maybe you can help me, your testimony is there was enough from the less than half the load
If we
that goes
found
through
75 shots
to,
in his
Was
body.
it one place it hit,
And the
Was it-
total amount of
it had to
shots
go
is
through the brain still.
150.
Yeah, well, you know,
What
I
time did
didn't
the train
say
depart
that
Union
less
Station?
than half the load went through. Some of it may have actually exited the top of the head. I don't know. Or went into the brain. I did not x-ray the brain, and so I don't know exactly how many, but we can tell that this is the direction.
Was the brain macerated?
No, it was largely intact. There was some maceration at the base of the brain where it was torn from the brainstem. Okay, the brain went up and torn from the brainstem, but it was pretty much surprisingly intact, you know, from a shotgun wound.
Have you looked at the crime scene photos?
I really didn't look at the crime scene photos with any kind of, you know, attention.
Okay, so, but you are aware that the brain was catapulted out of his head, probably hit the ceiling, and then landed outside.
Well, I could tell from examining the body that the brain catapulted out of the head, because I
Okay.
received the brain and a hole that was consistent with the brain leaving it.
Can you and I agree, and based on your testimony when you previously testified, that there would not be, that the gas from 2 or 3 feet away would not travel through the arm, travel through the neck, and then go into the brain?
Well, there's a lot of material that's going through, and plus we've got fragments of the brain, the skull, of the base of the brain, that can also, there's a lot of energy going in that direction. Whether it's gas or not, it's energy from portions of you know, ammunition propelling in that direction. So, you know, whether you want to call it gas or whether it's other things, I really don't know the theoretical explanation. I'm sure it's in the book.
It
But I
is.
examine the bodies and I make the determination on the direction and the type of injury from examining the human body.
The book seems to indicate that the primary cause for an explosion such as this, the brain exploding out, is the gas. You would agree?
Well, you know, I think each case is a little bit different. And the kind of gas that would cause the head to explode would also, I mean, I think the book is talking about gas, gas in a contact shotgun wound. So what is your question about the book? I would actually have to refresh my recollection.
Well,
Because I don't really I haven't read the book in a long time, but I know what I've seen on the body.
If I quote this to you, you would, and I can show it to you. The gas entering the closed chamber of the head expands rapidly, adding to the pressure waves acting on the bony framework of the skull. The only way for the skull to relieve the pressure produced is to shatter. Do
Yes.
you agree with that?
That actually must be describing a contact shotgun
It is.
wound. Okay, because that really makes sense for a contact shotgun wound.
And your reasoning for this, the same phenomenon that happened without the gas is?
Well, we've got injury coming from beneath. The skull is, like I told the jury, that is not shattered. We do have some horrible injury, but the shattering of the skull, much of it is still up intact. We don't have shattering of every bone. We don't have shattering of the face. So
Why didn't you shave the head?
why didn't I shave the
Right, were
head?
you looking for any, if much of the skull was still there?
Look, my determination, I didn't shave the head because I was confident that that was an exit wound on the right
Thank
side
you,
of the top of
Tasha,
the head.
for the 20
It wasn't
gift
necessary
memberships.
for me to shave
Always
an
appreciated.
exit
Thank you very much.
So, but if you had shaved the head, and again, apparently you'd already come to your opinion by this point, you could have seen whether it was soot or stippling or any distortion around, or taken samples of the hair and determined whether or not there was any sort of GSR in it, which would be more consistent with a contact wound.
Well, no, GSR can just be in, we know gunshot residue can deposit in, you know, I'm not, like, ballistics is not necessarily my strongest suit, but I know that GSR can deposit, you know, within a few feet. Somebody doesn't have to indicate a contact wound.
Okay, so did the shot penetrate the jawbone?
It went through the through that area. I believe it actually may have went underneath the bone.
So it did not connect with the bone? Correct?
Yes.
Are any of the pellets that you see in the shoulder, the left shoulder, heading down instead of up?
Well, there's probably kind of a billiard ball effect when these things are going through, and there could be some, directionality. But I didn't make that determination because it wasn't important to me to make that determination.
See which way the pellets were going?
What?
To determine which way some of the pellets were heading?
I can tell from the entirety of my finding at the autopsy. The thing is, if you look at something like, a postcard photograph, that doesn't necessarily tell you the whole story. I did my autopsy. I viewed all of the wounds. I was confident in the direction of this wound path. And I'm not trying to say, which direction are the pellets going? I can see that there's the entrance wound was to the top of the left shoulder, went through the left side of the neck, and out the top of the head.
And how many pellets made it through the brain to the skull, to fracture the skull? How many pellets?
Oh, well, there were some pellets in the brain. I don't know how many.
Because you didn't X-ray it.
Correct.
So since you don't count the number of pellets, tell the jury, please, how you know how many pellets hit the skull and fractured it and allowed this eruption to occur.
I don't know how many pellets. I never said that I did.
No, I didn't say you said it. I just want to know if you know it.
I don't know the answer to that.
And it's not important to you.
It doesn't really matter. It's really very theoretical. I examined the bodies, and I made my determination based on examination of the body.
Is it true that an autopsy report should be able to be read by an independent pathologist to come to a conclusion?
Yes.
Okay. Are you ready? Okay, how about put that up for us, please?
Or what is this happening now?
I'm sorry, sir?
Some strange noises. Who's talking? You're questioning the witness? Proceed.
I'm asking Doug to put up exhibit number.
I didn't hear you talking. I heard you were questioning the witness, and then a strange voice
I
comes from.
apologize. What's the exhibit number?
Stage 487.
Okay. So, how about step down here, please? And get the pointer for me, please. And stand over there, please, so the jury can see. So you indicated there were...
Gas goes in, brain
I asked
comes
you if you
out.
shaved the
You
head.
can't explain that.
You said no. You said there wasn't...
Hi, can you read my super
I think
chat? Well, let me see if I can
there was
find your
enough of the skull
super
there
chat.
to determine what happened. Is there?
Well, I know this is an exit wound from examining
See
the entirety
chops.
of the findings, and I did not
Today's 28th.
I did not need to shave the.
Normie says, have you seen the Netflix cities on the
That was my,
Netflix? Let's try this again.
opinion and determination at the time of it.
Yes, ma'am. We
I can
understand
speak
that.
words
but
good.
What, did you look at this
Normie
to
says,
confirm
have you seen the
or
Netflix
question
series
your
on the
opinion,
Murdaughs?
or have you
Just
already
watched it
come to
last
your
night. I think
Well, I
Austin
always
said, I have not seen it.
questioning
And Vincent
myself
said, could Paul
during the
shot mom
autopsy.
and then committed
It's
suicide?
not just, I
That
look at it,
doesn't seem
take
to
a long
be
time
what
to
anyone
look
is
at it
arguing based on the
before I
evidence.
reach a conclusion. Okay, so the totality.
No one
of
seems to be
findings
arguing that
here,
possibility.
Told me this was an exit wound. The brain came.
And also where he was
the
shot on
neck
the skull.
intact. It
I don't
was
think
the
allows
part
for
of the
that,
top of the- out of
because he
the
was
top
shot
of
in the
head.
back of the head and
I
with a long gun.
believe, and I'm confident that this is an
not
exit
really.
wound, and I did not do further investigation to rule out an entrance wound because I was confident it was not.
So you just said you were confident and you did not look further because you were confident you were right.
Well, I looked at it, and in fact, I took a photograph of it, and this is consistent with an exit.
Is what?
Consistent with an exit wound. The brain came out of that defect. If it were a shotgun entrance wound, there would be a lot more destruction of the head.
And again, you've never seen a contact wound to the head that wasn't in a suicide case.
I don't honestly remember.
So you don't remember, let me just rephrase, you don't remember having a case involving a contact wound to the head that wasn't a suicide
Yeah.
case. You just don't remember it.
I may have, it's possible, I did not survey, I may have seen one where somebody was shot at point blank range with a shotgun, and then the entire head is gone. So when I get that kind of, if there was a contact shotgun, whether it's suicide or homicide, the entire head would have been basically blown off.
And so in every case, well, there's no reason for us to go there because you don't remember ever seeing a case where there was a contact wound and to the back of the head.
Objection asked.
I think it's honestly, whether it's self-inflicted or inflicted by somebody else, the features of the body are going to be the same. So that's my answer, and I can't, whether I remember it or not, I've done a lot of autopsies. I don't necessarily remember how many or if I've done one, but I imagine people are shot
very
at close
defensive.
or contact range
For a
with
person who's
shotgun.
testified as
And
much as
in
she's
a
supposed to have
contact shotgun,
testified,
whether it's by suicide or
she's very,
homicide,
very
the
defensive.
entire head would have been basically blown apart. This is terrible, and I know it's terrible. It's probably the worst thing you ever saw, but there would be a lot more damage with a contact shotgun. And that's my professional opinion based on my experience. If other people disagree with me, that's fine. I don't have to convince them. This is my determination based on my education and multiple years of experience doing autopsies and being a forensic pathologist.
And I think in your testimony, whenever that was, weeks ago, you conceded that reasonable pathologists can differ, correct?
Yes, I think I said, you asked me if a reasonable person, you didn't actually ask me if a reasonable pathologist, you asked me if a reasonable person could have a different opinion. And I remember that because I was sorry that I didn't say, well, of course, reasonable people can think that. But a reasonable pathologist could also think that, but I would disagree with that.
Okay.
I don't think all opinions, a reasonable pathologist could have an opinion like that, but I think it would really be wrong.
Okay, go ahead and take the stand, please. Have you discussed you met and discussed with Dr. Kenny Kinsey, about his findings?
I did meet with him once when a couple of weeks prior to the autopsy. I really never, prior to this trial, I met with the prosecution's team. And I would have been available to meet with you if you called me as well. But Ken Kinsey was responsible for the crime scene. What he had to say was, I really wasn't, I had already written my autopsy report. I already came to my decision, my determinations based on my examination of the body. And whatever it was, he's going to do the crime scene. So I don't remember having any specific conversation.
You don't remember talking to him about vectors and where the blood spatter would have gone? And
yeah. Well, he asked me, he said, do you know anything about this? And I said, that's your department. I really am not a blood spatter expert. So I had nothing to offer, and I really didn't encourage listening to it because it's not my area.
And let me say a couple of things. One is, you indicated that you did not put that packing material in your autopsy report, correct?
Yes.
And today's the first time you've ever said anything about packing, correct?
Yes.
Okay. Secondly, let me just sort of summarize this and see if we can get this over with. There are certain things you did not do in this autopsy because you concluded it wouldn't be helpful in reaching your conclusion, correct?
I agree with that.
Like no x-ray of the brain?
I would have been, I did not x-ray the brain, right?
Okay. There were, and your belief is that the shotgun wound to the shoulder being so much bigger is because of the angle?
Yes,
Okay. And then it narrows down to, you would concede, as a hole in his neck?
yes,
Okay. Shotgun starts out wider. That shot starts out wider. I think we confirmed that.
the defect on the shoulder is
Right.
wider because it's kind of going across the shoulder, so it's going to create a defect on the shoulder that's wider than something entering at a right angle or perpendicular. So that's, and I think that makes sense to me. It's consistent with what I've seen in more than 20 years of my practice, and there wasn't anything that seemed odd about that.
And you would concede you're not a ballistics expert?
I know the kind of ballistics. Some forensic pathologists know a lot about ballistics. I know probably an average amount.
Okay. And so when you say it started out wider and then came down to this hole, have you discussed that with any ballistics experts?
It doesn't require, that's forensic pathology. That's damage to the body. I don't need to be a ballistics expert, and I've done enough autopsies on shotgun wounds to make that determination without requiring additional ballistics knowledge.
But we can see that the shotgun starts out, the shot starts small and then the pellets expand.
Objection asked and answered, Your Honor.
Objection is sustained.
Why are there no shot? Why there's no shot in his cheek if it's expanding? Why are there no pellet holes here?
Because they probably that's we have some wadding going in there.
Probably.
Yeah, I think that is consistent with the wadding. And there are, there's some pellets remaining in the wadding as well.
The wadding going where?
That's an entrance wound. Okay, it's entering perpendicularly. Why do we have the pellets? Did not terminate in the cheek. They continued upward.
But a number of them terminated in the shoulder,
Yes.
in the chest, up here, right?
Yes.
And then
Not
they-
the chest.
then they
the neck,
stop- they-
not the chest.
I'm sorry?
Not the chest. The neck.
But the neck, the shoulder and upper neck, right?
Yes.
And then, if they stop expanding here, so the cheek isn't, one of those pellets is,
Objection asked and answered to the former question.
Your Honor?
It's been asked and answered. I sustain the objection.
And you say these x-rays are consistent with your opinion?
Yes.
Beg the court's indulgence. Oh, let me ask you one question about the Maggie wound. Your position is that the tags don't indicate anything?
Well, they are not determinative. They are something we look at, but the tags on the breast are very non-specific. They're not very good tags. We happen to have nice tags on the back of the skull. Frequently, the tags are more reliable when the skin is tighter over an area.
So on Maggie, you're saying one shot's going up and the other one's going down?
Yes.
Okay. Beg the court's indulgence.
Feeling a little exasperated there, girl?
Holly, anything else? Thank you. That's all I have. Thank you, Doctor.
Just two questions. 5,500 autopsies, you said, correct?
Yes, and since I was here last maybe, I've done another dozen, so over 5,500.
And you rely on practical observations of actually observing the body, is that correct?
That's correct. I do my autopsies, and based on my experience and knowledge as a forensic
I would
pathologist,
I would
know about
think
the
your
bodies,
autopsies
examining
would be
the bodies. That's
based
what I
on
rely
observing the person.
you're-
Yes, I think that's how most autopsies are done. I've never done an autopsy, but I think looking at the person probably a large and significant.
In your
factor.
opinion, is there any way Paul's face would have remained intact if he had suffered a contact wound from the top of the head?
No.
And in your opinion, is this obviously a wound in this direction as you've described?
Objection, Your Honor. Repetitive. She's testified 5 times. That's her opinion.
The objection is sustained.
Further on.
Thank you. Nothing
Further.
Thank God
you.
that's
You may step
over.
down.
Thank you.
Thank God.
Your next witness.
Your Honor, state calls T.C. Smalls.
I don't know why she is so defensive. Like, again, I've been defensive and stuff, but I have not. I've had my own problems with being defensive and, learning how to YouTubes and stuff like that. But, I have. So I understand, like, being a professional and, being questioned and being disagreed with and being defensive and getting angry. And I understand all those things. My criticism is, like, why is she so that way? Because she's done this a lot. She's done this a lot. I would have thought, that he would have been calloused up right quick by now, but damn.
My name is Thomas C. Smalls. Folks call me T.C. Smalls. S-M-A-L-L-S.
Sheriff Smalls, how you doing today?
I'm doing good.
All right. Tell the jury just a little bit about yourself, and I called you sheriff, so if you could just kind of explain that to them a little bit.
Okay, in law enforcement for 39 years, 8 months. I retired in December. 16 years of those 39 years was, I served as sheriff of Hampton County. Been in Hampton County all my life. I'm a pastor.
He's a pastor and a sheriff.
Pretty much married, 4 kids, 7 grandkids, and just trying to enjoy some retirement. I retired December 31st day of December 2022, yeah.
Well, I'm sorry to pull you back in. You said you just retired, huh?
Yes.
All right. Do you know the defendant, Alex Murdaugh?
Yes, I do.
Have you known him for years?
Oh, yeah.
Did you ever have a conversation with Alex Murdaugh about him asking you permission or even telling you about installing blue lights in his private vehicle?
Oh my God!
No,
We're
sir.
doing the blue lights thing.
I
Really?
never had a conversation with Alex Murdaugh. Matter of fact, I never had a conversation with anyone in my 39 years about installing blue lights in their personal vehicles.
That's not something that's done, is it, sir?
Oh, no, no.
Did you know anything about the defendant claiming that you permitted him to do so until he testified to that last week?
Correct.
Didn't know anything about
Didn't
it?
know anything about it.
And he never approached you at any point about that?
No, sir.
Did he ever approach you about any threats or anything as a result of the boat case, the boat wreck case?
No, we never have.
Thank you. Nothing further.
Cross-examination.
Okay.
Well, it's 12:01. Good afternoon, Sheriff Smalls.
How you doing?
My name's Jim Griffin.
Okay.
I'm a little hoarse. This pollen's getting to me, but it won't take long. You've known Alex Murdaugh for many, many years, is that correct?
Correct.
And he was a volunteer solicitor in Hampton County, 14th Circuit, for a number of years, correct?
I realized he worked along with his father
Right.
as a, I don't know whether, I thought he was an assistant solicitor, but he worked along with his father as in Hampton County.
But he held the position of assistant solicitor of the 14th Circuit,
Yes, he did.
and he worked with his father
Right.
trying cases in Hampton County and perhaps Colleton County and other places. You aware of that?
Correct. Yes, sir.
And are you aware of him trying any cases when it wasn't with his father?
Not to my knowledge.
Okay. And his father was, we're talking about Randolph Murdaugh.
Correct.
and he was previously solicitor, is that correct?
Right.
And are you aware that Alex Murdaugh was issued a badge for that position?
No, I was not.
Okay. And there's some, you were questioned about permission that, whether you gave him permission to have a blue light installed in a vehicle, and you said you did not, correct?
Correct.
Do you know whether Anthony Russell gave him permission?
I can't answer that.
Now, who's Anthony Russell?
Well, during my time when I was sheriff, Anthony Russell was a captain in my administration. He later became sheriff after I retired. He ran and he won the office of sheriff, and he holds office now.
And he was maybe not your right-hand man, but he was pretty high up in your administration.
He was a captain.
Okay. And then Chauncey Solomon, what was his position?
Chauncey Solomon was a lieutenant.
And Perry Singleton, he was passed away, what was his position?
He was a lieutenant.
And you know that Deputy Russell, Deputy Solomon, Deputy Singleton were very close to Alex Murdaugh? Were you aware of that?
Well, I knew they knew him. I don't know how close they were.
Okay. And did Eddie Gibson install
Arm says you looked
the
out your
blue
window
lights
and
on the
thought it was
vehicles
raining, but it was pollen?
for the sheriff's department?
Been there before.
Not for
Yeah.
my cause. Most of my vehicles light was done with a company out of Orangeburg, and then later we started working with a gentleman by the name of Charles Mitchell that installed lights, and he out of, I think, Hardyville or Bluffton.
So you don't know who Eddie? Do you know who Eddie Gibson?
Oh, I
is?
know who Eddie Gibson. He worked for me at one time.
And when he worked for you, did he install blue lights? He worked on the vehicles, the fleet of vehicles.
No, not my vehicles.
Well, when he worked for you, what did he do?
He was a deputy sheriff. He patrolled.
And so like you're unfamiliar that at any point in time, Mr. Murdaugh had a blue light in his vehicle.
I never had any knowledge that he had blue lights in his vehicle.
Oh, thank you. That's all the questions I have.
Thank you for that.
Your Honor, can I approach, may we approach very quickly?
Okay. Well, we're getting into whether or not the blue lights exist or something. I don't know. What day of the week is it right now? Tuesday? Okay. Selena says, "Hi, Kurt. Loved to talk about the trial with you in Vegas, and thank you for taking a picture. Along with the maroon sparkly giraffe.
Smalls, when did you
You're so
retire
sweet.
again?
Love meeting you. Big
I
fan.
retired,
Thank you, Selena. That's very nice.
December the 31st, 2022.
2022, so just a couple
Was it
months
raining
ago.
when I was in Vegas? Yes,
Thank
it
you for
did
coming
rain.
in.
Thank you for that.
No, Your Honor.
Thank you, sir.
It was cold and chilly and overcast, and it definitely rained.
Call your next witness.
Who? He had blue lights. He's a murderer.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You would, sir, please be seated. State your full name for the record and spell it. Last name, please.
Paul McManigal, M-C-M-A-N-I-G-A-L.
All right. Good afternoon. Sergeant McManigal, correct?
Yes, sir.
All right. And you're employed at the Charleston County Sheriff's Office?
I am.
And you testified previously in this trial, correct?
Yes, I have.
Just briefly remind the jury exactly what topic you testified on earlier. Briefly, please.
I was tasked with redacting Alex Murdaugh's cell phone records to remove any possible client attorney privileged information.
All right. And during that testimony, you were not qualified as an expert, correct?
That is correct.
All right. But you have been qualified in previous trials?
Yes, I have.
And approximately how many times have you been qualified as an expert previously in other trials?
About 10.
10 times. Okay. And is that in cell phone forensics?
Part of it was about, refer to my notes. 1, 2, 3, 4. 6 times of that was in cell phones forensics. The other was crime scene investigation.
Okay. All right. And just let's briefly go down as quick as you can. Let's go through your training experience in cell phone forensics, please.
Okay. I'm currently assigned to the United States Secret Service Cyber Fraud Task Force, which is where I received most of my training. I have been trained in basic computer evidence recovery, advanced computer forensics, oxygen forensic suite training, blacklight examiner, advanced mobile device examiner, Celebrite physical and logical examination, XRY certification training, Macintosh triage and imaging, Apple iDevice forensics, Celebrite advanced JTAG extraction, network intrusion response, vehicle forensics, digital video recorder evidence and recovery, ransomware investigation response training, and several other webinars.
All right. At this time, State would seek to admit Sergeant McManigal as an expert in cell phone forensics.
So qualified.
All right. Sergeant McManigal, last week you were present when a gentleman named Micah Sturgis testified for the defense, correct?
That is correct.
And specifically, he testified about this feature in iPhone known as wake.
Raise to wake.
Raise to wake, correct?
Yes, sir.
And briefly explain to the jury what that function is and what it serves as in the cell phone, for the iPhone, excuse me.
Raise to wake is when the cell phone is laying down and you pick it up. It realizes that somebody is picking up the device and tries to assist by turning on the display so that you could possibly unlock it with your face unlock.
All right. Or read a notification, possibly, if there's a notification on the screen.
That's correct.
And so it's designed to turn on that screen when it thinks someone's picking up the phone to look at the screen, correct?
That is correct.
All right. There's been previous testimony, I think, by Mr. Sturgis and other experts in this case, that the iPhone, if the screen is off, it will not record an orientation change, correct?
If the screen is off, it will not record an orientation.
And you agree with that opinion?
I agree, yes.
Okay. And you were asked after Mr. Sturgis' testimony to investigate a little bit more about this raise to wake feature, correct?
I was.
And specifically, as demonstrated with the jurors, the screen is going to turn on when the phone is picked up gently, correct?
That is correct.
Because the phone thinks it's being picked up to be looked at, correct?
That is correct.
You're asked to investigate with a test device whether that screen lights up every time a phone is picked up in a more violent fashion or quicker fashion, correct?
Correct. When the phone is picked up more aggressively or moved more aggressively, the device will not turn on the screen.
And that's because the way raise to wake feature is based off of what in the cell phone? What's telling it to wake up?
The accelerometer primarily.
Okay. And so the accelerometer is sensing motion, correct?
Correct.
And so if it senses a slight amount of motion, it's going to turn the screen on because it thinks someone's picking up to look at it, correct?
Can't lead the witness.
And so if the cell phone only detects a slight amount of motion, what does it do? What does the iPhone do?
So if the iPhone registers a slight amount of motion, it thinks it's being picked up, so it will turn on the screen. But if it's being picked up more aggressively, it won't. And that's a battery protection feature. If you had the iPhone in your pocket and you were jogging, you don't want the screen to stay on the whole time. So when the phone is moving more aggressively, the screen does not turn on.
Okay. And so you're asked to do some tests in your lab with a test device, correct?
That is correct. I obtained an iPhone 11 Pro Max, which is the same make and model as the phone that Maggie had.
All right. And what software version was on your test device?
The software that was on my device is iOS 14.8. The one that was on Maggie's was iOS 14.6. So the iOS that was on my device that I tested was slightly newer.
Okay. And did you perform a series of tests and with various motions and various throws with this phone to determine, and were able to develop an opinion of when the screen might come on and when it might not.
Objection, Your Honor.
Basis for the objection.
Rule 5, this is an experiment performed on evidence, actually something seized, and we have not been provided this.
The objection is overruled. Rule 5 does not apply.
Thank you. So you did perform a number of tests, correct?
Yes, sir. Performed many tests over the weekend. I put pick it up and shake it, pick it up and throw it. I threw it off to my desk. I knocked it off of my desk. I tried to flip it end over end. I tried to throw it like a Frisbee. I did each one at least 10 to 20 times.
Okay. And were the results 100% conclusively? I mean, did the phone do the same thing every time?
No, not at all. Sometimes the screen would turn on. When I threw it, land face up, and then the screen would turn on. But a lot of the times I would throw it, and the screen would not turn on. It depends on how the accelerometer registered that movement.
So based off your test, is it your opinion that an iPhone of the same make and model as Maggie's could be thrown and the screen not turned on?
Can't lead the witness.
All right. Did you develop an opinion about whether the screen would turn on every time a phone was thrown?
If the phone is thrown, the screen does not always turn on. In my experimentation, I determined that when the phone is thrown more like a Frisbee, 9 out of 10 times, the screen does not turn on. The times that it did turn on most often was when I pick it up and tried to shake it, then the screen would come on briefly.
Okay. But 9 out of 10 times, when you toss a phone like a Frisbee, the screen would not turn on, correct?
That is correct.
Nothing further from the state.
Good afternoon.
Good afternoon.
When you performed these experiments, did you record them in any way?
I did not.
You didn't video record doing any of this?
I did not.
Did you consider video recording any of these experiments?
Actually, it never crossed my mind.
You just did the experiments and then just sort of orally relay when you could have had a video to show us?
That is correct.
If you were going to throw a phone out from a moving vehicle, wouldn't you need to pick it up, to toss it?
Certainly.
And if I understand the previous testimony, when you pick it up, the screen comes on.
When you pick it up gently.
So if you pick it up to toss it out the window while you're driving, you got to pick it up. Is that correct?
Correct. And if you pick it up aggressively, it will not.
But not always.
Not always.
Sometimes will, sometimes won't.
Correct.
According to the experiments that you conducted since, when did you do these experiments?
I started it Friday afternoon and into Saturday.
So you did these experiments this last weekend.
Correct.
You did not record any data.
I did not.
You just played with the phone and are coming here to express your observations.
That's correct.
Do you have the phone that you used to do these experiments with you?
Not with me.
Are you aware of how the phone in this, Maggie's phone in this case, how it, when it was located, what its position was? Have you seen the photos?
I have.
And was it screen up?
It was screen up.
Okay. Would you agree then that it had to be thrown from a screen up position, because if it was screened down and you turned it over to throw it out, the screen would come on?
Of course not. It can tumble through the air.
So if the phone was screened down in the car and it ends up screen up over here, it has to turn over, right?
At least one time, yes, sir.
And do you, I guess, disagree with the previous testimony and demonstration that when you take the phone and turn it over, the screen comes on?
No, when you pick it up gently, the screen does come on.
We say pick it up. If you rotate it on that axis so that it's screen down to screen up, does the screen come on?
If I pick it up gently and rotate it, the screen comes on. If I pick it up aggressively, it does not.
And if it's facing you and rotates 90 degrees, does the screen come on?
Only if you do it gently. Again, if you do it aggressively,
How
it will not.
gently? Did you measure any of these forces?
I did not.
You just threw the phone around in your office?
Absolutely.
So you didn't record what you were doing, and you did not measure any data.
I
Was
did
this
not.
because you were afraid that you would have to disclose that data if you recorded it?
Of course not, no.
Do you normally do experiments and don't record any data or video, record anything?
It never crossed my mind to record video.
Uh-huh.
Do you believe that you would have to have disclosed that data if you had recorded it?
Objection, Your Honor.
Overruled.
I believe so, yes.
So the reason you didn't record data was that it would have to be produced, and then we could examine it and discover whether or not it was accurate.
No,
you
sir.
avoided that by not recording anything, correct?
No, sir. That's not correct.
Uh-huh.
Why didn't you record any data?
It did not cross my mind to video record my experiments. I just did the experiments to determine whether or not
And
the
you
screen
didn't,
would
you
turn
didn't
on.
occur to you to measure how fast you were moving the phone, maybe to even find out what is that threshold you claim where the phone goes from turning on to not turning on? Exactly when does that happen? You have no idea, do you?
No, sir. It would take me much longer to do these experiments to determine the exact speed and force required to turn the display on versus not.
Did you discover any, or did you attempt to locate any documentation regarding the raised awake feature on the iPhone?
I did. I tried extensively. I reached out to several different forensic surface focus groups that I'm a part of, and we were not able to find any white papers on the subject.
So you were unable to find any actual data on it, so you resorted to throwing your phone around alone? Was anyone with you when you did this?
No, sir. I was alone in my office.
So you're alone in your office, throwing the phone around, taking no measurements, recording nothing over the weekend, and then you come in here and testify as an expert as to what the phone will do.
That's correct.
And testify that it's different than what we've seen it do right here in this courtroom.
That's correct.
Have you ever done this?
I'm an expert,
anything like
but
this
I have
before?
absolutely no idea what I'm
You've
talking
mentioned
about.
testifying 6 times before. Did you ever? Was this your expert testimony in any other case?
My expert testimony in other cases was always about cell phone reports and the data contained therein. I've never actually done physical experimentation to come up with a realistic result.
So your previous experience was extracting data from cell phones. Is that accurate?
Correct.
Is that what you're trained to do?
Yes, sir.
The training that was listed, it was to extract data from a cell phone?
Yes, sir.
Are you an engineer?
No, sir.
Do you have any certification in engineering?
No, sir.
Do you have any degree, academic qualifications in engineering?
No, sir.
Have you ever worked as an engineer?
No, sir.
You're trained in extracting data from the cell phone.
That's correct.
And when it comes to tossing it around and seeing how it moves, you don't know anything more than anyone else, do you?
No, sir.
So you had this. Your Honor, based on the previous answer, I would move to strike the expert opinion.
On what basis?
The witness just testified he has no expertise in this. That he just said he has no more knowledge about this than anyone else in the courtroom. That his expertise is in extracting data from the cell phone. And that this
He's
opinion
right.
is therefore outside of his expertise, and this is
He's right,
inadmissible
Your
opinion
Honor.
testimony.
Previously stipulated that he's an expert.
Yes,
cell
Your
phones.
Honor, in extracting data from the cell phone, which was before we got to this testimony
It
about
says
this.
state.
Your Honor, this witness performed a series of tests. He's reporting on, I'm sorry, Your Honor?
We know that. He's testified to that.
And he's expressed his opinion of what the phone will do in those series of tests. It's not an absolute opinion, but I think
not-
he can.
he
his
can't offer an opinion. It's
of when the
not
screen will
lay
light up,
testimony.
Something he tested and something he
It's
testified.
outside the experience of a layperson.
Anything further?
Your Honor, simply that.
The defense is right.
When he was proffered as an expert before this testimony, it was in extracting data from the cell phone, not in engineering, electrical engineering, which is where he's gone now.
Objections overruled.
Wow. Bad ruling.
So you just
Bad ruling.
testified you have no more knowledge about engineering the iPhone.
It's outside the knowledge of a
Than anyone
layperson,
here,
so he
correct?
can't offer
I
a
know
lay
more about how
he
the
can't offer a
iPhone
lay
works, but no,
opinion,
sir, I'm not an engineer.
and he
Not
doesn't
an
have the
engineer.
expertise, so he can't offer an expert opinion. So therefore, his opinion is
When you
garbage
said that
and should have
the
been stricken out.
accelerometers are what trigger this feature, how do you know that?
That's from data that's on Apple's website.
So you found something on Raised Awake that says that the accelerometers are what trigger this feature?
No, sir. That's the only thing that is capable of detecting motion on the phone, besides GPS.
And you have no idea how much motion is required because you didn't measure it, correct?
No, sir. I don't know the threshold.
Okay. You, this weekend, sat around your office by yourself, recording nothing, tossing the phone around here, and are now reporting those results as an expert in what?
In cell phone forensics. I understand how cell phones operate more than most people.
Do you understand the electrical engineering? Do you have any background in that?
I am not an engineer, no, sir.
Do you know how the accelerometers in the iPhone work? Can you tell us?
Not exactly, no, sir. But I know that they exist, and I know that's how the iPhone determines motion.
So there's an unknown device within the phone that detects motion in a way that you don't understand, and some amount of motion that you don't know how much because you didn't measure it does something that only you saw in your office this weekend. Is that correct?
No, I know what that is. It's the accelerometer.
I'm going to start throwing my phone around the room so I can testify in court, too.
That's what causes the iPhone to race to wake.
How does an accelerometer detect motion?
I'm an expert because I have a phone right here. I have a phone right here. I'm just going to start throwing it around the room.
Sir, you really haven't said anything you couldn't quickly find out on Google. Isn't that correct?
Probably, yes, sir.
So you have no expertise in this.
I have expertise in how cell phones work.
What do you mean by that, how cell phones work?
So I can tell you all about the knowledge C databases. I can tell you about the way iPhones, or not iPhones, I can tell you the way some software is written, what kind of code it's written in. I can tell you how data is stored on the cell phone, the programming that's involved with the iOS feature, and the different databases that are involved.
Can you tell us that if somebody was driving down the road, picked up a phone that was either on the seat or pulled it out of a pocket or something like that, and while continuing to drive, threw it out the window, that the screen would not come on if it landed face up?
I cannot tell you that it will not come on. I can tell you that it might not come on.
Wow. I can say that
Because
too.
when you were alone, throwing your phone around, you think it didn't come on sometimes.
Objection is sustained.
No further questions.
Anything further?
Just real quick, when Mr. Barber was asking about picking up a phone and then tossing it, about the raise awake, what Mr. Surgis demonstrated to the jury was a gentle pickup, correct?
That is correct.
You test a more violent pickup or a more aggressive pickup and then moving to a throwing motion, correct?
Yes, sir. I just picked it up and threw it.
All right, and based off of what you tested and you observed, the screen does not come on most of the time?
When you throw it like a Frisbee, it's most of the time. When you throw it end over end, it's more than half the time it will not come on.
All right. And Mr. Barber asked you several times whether you knew more than anybody else about these cell phones, correct?
Correct.
And in particular, in this instance, you do know more than most people because you performed a series of tests, correct?
Objection sustained.
You performed multiple tests over the weekend, correct?
That's correct.
Objection sustained.
What did you do this weekend?
This weekend, I performed multiple tests on a device matching the same make and model as Maggie Murdaugh's to determine whether or not the raise to wake feature would always enable the screen to come on whenever the phone is thrown.
All right. And Mr. Barber asked you several times about being an engineer, correct?
Correct.
And did you hear anything out of Mr. Sturgis last week that indicated he was an engineer?
No, sir.
All right. And do you testified you don't know exactly how the accelerometer works, correct?
That is correct.
Is that knowledge necessary to observe when a screen turns on and when it does not turn on?
No, sir.
It's necessary to know why it turns on.
Not further.
Anything further?
Is the accelerometer related to why the screen turned on? I don't know. Yeah. It has to be. Why?
How many times do you have to run this experiment for your results to be statistically reliable?
I'm sorry, say it again?
How many times do you need to run this experiment for your results to be statistically reliable?
How does he know? He doesn't have the
More than
expertise to
10?
answer that. That's a
your
number he
basis
just
for that
made up.
is?
It doesn't take that long to figure out that sometimes it turns on and sometimes it doesn't.
Do you know how to measure reliability using statistics?
I took statistics in college, yes, sir.
Do you know how to measure reliability using statistics?
Yes, sir.
How do you do it?
Well, you have to have to perform a sample. You have to have a default group that has no change to it, and then you have to have your sample group where you actually perform a change. You take the data, you put it into a formula, it gives you a degree of reliability.
Did you do that here?
No, sir.
No further questions.
Nice.
Step down.
What a waste of an what a waste.
Call your next witness.
I tossed the phone
Your Honor,
around
state calls
in my
Murdaugh.
office. I got some data from the website. Tell me some things. I'm an expert. Wow. Not a valid lay opinion, not a valid expert opinion. What the hell are we doing here, man? You got anyone else who knows
Do you swear or affirm
anything?
that any testimony you give today will be the truth, the whole truth, and nothing but the truth to help you God? I do. All right. Mark, you just-
And it's okay, guys. He works for the Secret
Proceed
Service.
with
We're in good
full name for the
hands.
record. Your last name, please, sir.
Help. Help.
It's Mark Ball. Last name B-A-L-L.
How you doing today?
Be doing better if I wasn't here.
I hear you. Well, we'll
I
get you
feel-
out here pretty
I think the
quickly.
jury
I
feels
wanted
about
to
the
just
same
ask
way
you
right about
a
now.
few very quick questions in response to the defense case. And first question I'd ask you is,
All right, guys.
prior
this is my-
to
Just killed a man. Why is my audio not working over here? Hello. Okay. Stop working. Don't work for no reason. It makes things super good as a streamer. You can't hear the court now? Ugh, kill me. All right, I'm gonna reset the stream or reset. Hold on.
That's what the real problem is. They root up your roads and fields and everything else.
have you ever known the defendant? You've known the defendant for how long?
34 years.
Is it better now?
And his family had a number of long
So
guns,
you can hear
rifles,
me
shotguns?
and the court at
Yes.
the same time. Wow.
Have you ever
things
known
have
him to
improved.
talk much about target shooting a pistol?
No, sir.
You know what Paul's weapon of choice was when shooting hogs?
Shooting.
Hogs.
The 300 blackouts were bought for hog hunting. I assume Paul would have shot him with anything he had, but that's what the 300 blackouts were bought for.
Did you have any conversations with the defendant when he was purchasing the original 2 blackouts as it relates to hog hunting?
I did. I'm not a big 300 blackout fan, and I told him that, and he bought them anyway.
While I was
And I think
resetting
his
the
cousin
browser,
actually
I
put
also
them
threw
together.
my phone around the room,
There's
and I
one
can
warden.
testify competently now about phone throwing.
In the
I'm
time,
available. I'm
after the
available
murders,
for the
did you have a
defense
number
team.
of conversations with the defendant about his activities that night?
I did. I had that night and then subsequent days.
And did you go over to those in fairly some sort of detail?
Yes, sir. You know, at times, sometimes it wasn't detailed. You know, it would just be checking on him to see how he was doing and to see, you know, if they'd come up with any leads or
Alex Murdaugh guns
where
down
things
hogs.
stood. I mean, everybody was
One time he called his wife a hog.
trying to figure this out. I mean, this is one of those lightning strikes in life that just jolts you and there's no rhyme or reason.
What, if anything, did he say about whether or not he checked Maggie and Paul before he called 911?
As I testified before, my recollection of it was that he testified, or
I'm
he
throwing in
told
an
me, not
application to
testified.
join the Secret
He told
Service
me
guys.
that he went to Maggie and then
Uncivil
he went to
law,
Paul,
Secret Service
rolled Paul
agent.
over. His phone.
I'm ready. I'm
I didn't hear the
qualified.
phone the first
Let's
time
go.
he said that. I think that was about the second or third time. But I also wasn't really listening. I was listening to what occurred. You know, who did this? Why would they have done this? But the second time he went, it was reversed, where he went to Paul and then to Maggie. And like I told you before, I don't know whether that's just a slip, you know, from one to the other or vice versa. But he definitely went, checked on him, then called 911.
When was the first time you heard his admission and claim now that he did go to the kennels around 8:44 p.m.?
Thursday, last
This past
Thursday.
Thursday?
Yeah,
And was he clear prior to that he did not go down there in his conversations with you?
never said anything about that or any reason for it. It just, he'd never been there.
You said you've known the defendant for how long?
34 years.
Knowing what you know now, was he able to look you in the eye and lie convincingly and effortlessly?
Objections overruled.
I mean, it's pretty obvious. I didn't know the stealing. I didn't know any of that. And, you know, it's not the way a plaintiff's practice works. You work on your own cases unless you're working with somebody else. And
Wow, that's deep insight.
so
you
wouldn't
work by
necessarily
yourself
be
unless
talking
you're
about
working with someone
his
else.
particular
Tell me
cases.
another
So,
thing.
it's sort of yes and no. I mean,
That's
obviously,
the kind of
a
insight
lot
you
of
get from
things
Mark Ball.
that I was told,
Not
a
as
lot of
great as the
things
insight from Secret Service guy talking about
just
phone tossing.
weren't there. I mean, the blue lights, the reasoning for the blue lights.
I toss
you know,
dwarfs.
money
I'm a
missing
dwarf tosser.
from our account when he cashed the 2 checks. All of those types of things. You know, obviously they weren't truthful.
And did you feel like you knew the defendant well prior to June?
Sure thought I did.
Did you know him? Did you really know him?
Good afternoon, Mr. Ball.
Good afternoon.
Just be clear, after the Labor Day weekend when Alex was confronted by the law firm,
Well, it was before Labor Day.
yeah, the
It was Thursday.
Friday or Thursday
Right.
before,
It was the Friday before we confronted him.
you ever talked to him since the day he was confronted?
I talked to him on that Monday when I believe that he and Randy and John were going to, I believe, Atlanta,
Okay.
to the facility down there. And I got a phone call, I don't know, 1 or 2 o'clock, whatever it was. I was coming from the office. I'd been digging through his files and stuff. And
Will the state rest today?
I got a call. It registered as John Marvin. I picked it up and said, what you need, John, and it was Alec.
We got to pay real money for this case to be
And
over at this
that would
point.
have been Labor Day 2021?
That would have been Labor Day 2021.
And since Labor Day 2021, you've not spoken with Alec?
I have not.
And since Labor Day 2021, Alec has either been in rehab or jail, is that correct?
He has been, to my knowledge. I mean,
So you've not had any opportunity, I mean, he's been represented by counsel as well, right?
sure. I mean, I wouldn't expect to if, he's being charged with crimes.
Right. So you wouldn't have any expectation that since September of 2021, that he would come to you, talk to you about whether he was on a video, whether he was at the kennels, or where he was, correct?
No, not since September.
Okay. You were asked questions about Alex distrust of SLED, and you testified that he had a good relationship with law enforcement.
He did. I never heard any mistrust of SLED or anybody else
Well, let's talk about that.
from him. I mean,
Well, did Alec take the position that his son Paul was wrongfully charged for felony boating under the influence, causing a death and serious
Stop
bodily
law and
injury?
crime. Please stop moving the thing around. That's
Yes,
really
he-
bothering me.
I mean, I think he disputed that and was planning a vigorous defense of that.
And that happened, those charges have been pending since 2019, is that correct?
4 years ago, a couple of days ago.
Right. And so he did express some dissatisfaction over that case, correct?
Well, over that case, but I don't know that it was directed at law enforcement or who it was directed at. It was just, it wasn't, he didn't specifically say or didn't say, I distrust SLED or I distrust Beaufort County Sheriff's Department or DNR or whoever. It was just, he thought that there was defensible, it was a defensible case, the criminal charges against Paul, and there was this back and forth as to whether it could have been one of two people driving.
And you were informed, I believe, sometime in the spring of 2021, that SLED was actually investigating Alec for obstructing the boating accident investigation, right?
No, sir.
You were not aware of that?
I was not aware of that.
Do you know whether Alec was aware of that?
I have no idea what he was. He never said that to me. I didn't know about anything to do with the investigation until the grand jury, when I went to the grand jury.
Were you aware that he and his father sat in on the criminal prosecution of his good friend Greg Alexander?
I became aware of that. Well, back up. Yeah, I knew they went over there. I didn't know much about the detail until after the SLED came in after the 3rd of September 2021.
And Chief Alexander was prosecuted after SLED investigated him, correct?
I think that's the case, yes.
And that Alec and his father thought that Chief Alexander was wrongfully accused. Are you aware of that?
I don't know what they thought about it. I know that they were close to Greg Alexander, and Greg Alexander ultimately got off on a jury trial.
Now we do know that the Colleton County Sheriff's Department, in this case, recused themselves because Alec was...
Let me correct something. I said that he got off. He was found not guilty.
Right.
I mean, I don't want there to be a negative implication. I know Greg as well.
Sure.
So,
well, thank you for clarifying that. And we do know that Sheriff Buddy Hill and the entire Colleton County Sheriff's Department recused themselves in this case because of Alec's close relationship with the Colleton County Sheriff's Department and law enforcement. Is that right?
I know they recused themselves, and I know they called in SLED that night. I wasn't privy to the reasoning, but I would make that assumption.
And there are different levels of law enforcement agencies, right? There's the,
Sure.
say, the Town of Hampton Police Department, Hampton County Sheriff's Department, and Alec had a really good relationship at that level with those folks, correct?
He did.
And he had a really good relationship with the Colleton County Sheriff's Department, to your knowledge?
He did as far as I know, yes.
Right. But I think I've covered that. So you mentioned that hogs become nocturnal when there's a lot of pressure on them?
They can.
They can?
It depends on a lot of things. Like right now, the swamp's up. They're much more on the hill than when times are dry.
Hog
they go
expert guys
out into the flat swamp and root up everything out there.
And the pressure that you're referring to is hunting pressure.
Yeah.
And are you aware that Paul put a lot of pressure on the hogs at Moselle?
I knew Paul hunted hogs a lot of places. At one point, Paul had hog dogs and would hunt on people's property. He came to my property. He went to Ronnie's. But how much pressure they were putting on them, I don't know because I wasn't over there. I mean, I'd ridden around their property several times, but I never.
Worth witness?
It wasn't about hog hunting.
Sure. And I want to ask you about the Moselle property
Has
tract.
anyone else gotten
So,
any other number than 4?
We've all seen drone photos of the house and
This
the
guy,
kennels and Moselle Road. That's sort of
Sheriff
right in front
guy.
of the residence.
Yes.
Very. And then if you're sort of looking from a drone and seeing some aerial photos, I guess if you're headed south, there's the Dove Field right adjacent. Is that south, I would think?
medical
yeah, at least
expert
east.
and person that
And
pursued
then
the medical expert.
back behind the Moselle residence, I think there's a river.
Well, there's a swamp.
The swamp
and then
again.
the big Salcahatchee is back in there.
So the swamp begins behind the house and goes, I don't know, is that west?
Sort of south.
Right.
If the runway's running east and west,
Okay.
then it would be
But
south.
But the swamp is behind the house.
It's behind the house.
Okay. And across the street from the house is duck pond and shooting range and no swamp.
Correct. And timberland.
And all the hogs are going to be behind the house.
They're all over. They follow. There's a watershed ditch in there. They follow wherever, but predominantly they seek refuge or whatnot in the swamp. But they can be anywhere. I have them. You know, there's gum ponds and every place else, and they just trample wherever they want to go. But you're right. By and large, they're in the swamp because it's wooded.
Right.
And thick.
And in the month of June, pretty warm, is it not?
It usually is here in South Carolina.
Yes,
Law
it is.
partner,
And do
medical examiner,
hogs
blue
like
light
to
sheriff
stay in the
confirmed
swamp
dude.
more in the
So this is
in the
5.
summer?
Oh, fair.
I haven't noticed that, and
Thanks,
I've
Sita.
killed probably well over 1,000 hogs.
All right.
And so we trap them.
There's hope. We might
all
be
the
done
way
today,
through.
guys. I can see it. I can see
got
the
2
hope.
traps and, well, actually I got 6
I
traps.
can
but
see
I mean,
the
I
light
trap them, I shoot them.
shining in
You know,
the
they're just a scourge.
darkness.
They eat everything. They root up your roads. They get in your pine trees when they're little. They'll root them up. They're a teetotal nuisance. I carry a gun with me most of the time.
Do you have a gun with a thermal scope so you can hunt them at night?
I do have a thermal, and then I have others.
Yeah, Mr. Murdaugh, is there ever a time when you don't have a gun with you when you're traveling around?
Only if I forget it.
Right.
But
that's what I thought.
Usually I have.
No hogs in Vegas that I was aware of, no.
And you understood that Maggie and Alec got 300 blackouts from Paul and Buster for Christmas one year, and they came with thermal scopes.
I do.
And are you aware that Paul had his lost or stolen?
I was.
And then he received a replacement without a thermal scope.
Right. My understanding was it had a red dot.
and that he didn't use that one very often. He used busters that did have the thermal scope. You've learned that?
I've heard bits and pieces. I haven't been watching everything, but I did.
Right.
Somebody told me that, or I heard it, one or the other.
And busters are sitting here in the courtroom. Were you aware of that?
I didn't. I assumed y'all had.
Okay.
I know that the black one was taken from the house because I was standing there.
Right. That's fair.
But you wouldn't use
if
the
they
thermal
say the hogs did it
in the daytime for the most part. I mean,
then
you
it
could,
just
I
proves
suppose,
that chicken power knows no
wouldn't serve
limits.
much purpose.
There's been some discussion about Alex emoting, being emotional during trials. He's an emotional person altogether, isn't he?
I think he probably is.
Hogs can be the size
You
of.
remember him speaking at when his dad got the order of the Palmetto, for example.
I do.
And he'd get
Two
emotional
legs
then.
good, or 4 legs good,
And
2
you
legs
remember him
bad.
speaking at the trial lawyers after he had finished up his term, and he got emotional then.
Well, I wasn't there for that. So.
Oh, you missed that? Okay. But you've seen him get emotional frequently.
Sure, everybody gets emotional.
Well, and he was extremely emotional after losing Maggie and Paul.
There's no question about that.
One last point. Do you recall reading or learning on the morning of June the 8th that statement was released through the Colleton County Sheriff's Office that says, at this time, there's no danger to the public. If information is received that dictates otherwise, we will immediately notify the public?
Yes.
Did that concern you?
Very much.
And why did it concern you?
Well, I had been over there that night. I left 3, 4 o'clock in the morning, came home, laid down for a little while, took a shower, and then I heard that. And I got on the phone with Sheriff Smalls on my way into work about 7:30 or so, and I asked him if he knew anything about what that was about, and he said, I don't know, I'll check. And then later that evening, the lieutenant from over here called me, and he explained
Did you leave? That's very kind.
that they
of you.
didn't have any credible threats
Really
against
enjoyed
anybody
talking
other
to so
than
many of you guys.
they didn't have any
That was really
threats.
cool.
Period. But they didn't have any. There was no knowledge, no information about anybody else being in harm's way, and we had probably a 30 or 45-minute conversation, and it didn't leave me any more. I guess I still had questions because we have 60 or 70 people that work for us,
Sure.
and the last thing I wanted was somebody coming in and blasting up the place, and so we made the decision to lock the doors, and we did that for probably a couple months,
Right.
and just like we're doing now.
Thank you. Indulgence. That's all.
Please let it end. Please let it end.
You were asked a little bit about Colleton Sheriff's Department recusing themselves. Are you aware that they continue to assist on the case?
I know they were out there, and I wouldn't. The internal politics of who's lead and who's not lead. I mean, I know that they were there because one of the deputies called me the next morning and asked me where Paul's truck was, and I called Alec and verified where it was, and told I had several interactions with them. So yeah, they were still involved. They weren't.
And for the first few months of the investigation, the local solicitor's office was still running the investigation, to your knowledge?
As far as I know, they were out there. Mr. Stone, his chief assistant were out there, and an investigator were out there the next day. And I want to say they were out there maybe 2 days, but to lend whatever assistance they could lend, I guess.
And that'd be the same
And
solicitors?
then I think it was August, I saw it like everybody else in the paper that Mr. Stone had recused himself.
And that'd be the same office for which the defendant had a badge, is that correct?
Correct. He was an assistant, and so was his father.
All right, thank you. Nothing further.
Just briefly, Mr. Gall, isn't it correct that law enforcement does the investigation, solicitor's office does the prosecution?
That's the way it normally works.
Thank you. That's all I have.
Thank you, Your Honor.
Could you get off the stand any faster? It's over yet?
We're going to break, excuse the jury now, till 2:15.
Okay.
Please
That's
do not
about an
discuss
hour.
the case.
That'll be good. That will give some time to do some Supreme Court review. Two decisions came down this morning. Why seem to have this weird shadow thing going on over here? What's going on with this? Okay. Anyways, no. As I was just about to say, we're going to do some Supreme Court review during the break. Two decisions came down this morning,
Seated.
so we'll see what that's all about.
How many more witnesses do you have, Mr. Waters?
I believe just one, Your Honor. At lunchtime, there's one more that I might talk about, but I believe just one, Your Honor. And that would be Dr. Kinsey.
What are you doing?
I received an email that want to have counsel look at. Let's see trying to figure who works here.
Trying to figure who works here? You don't know who works here? Lord. Random emails. It's always so much fun for the judge in any case. You know. Probably, if I had to guess, just guessing speculatively, it's probably saying some juror did something they weren't supposed to do. You know, some juror was talking about the case. I overheard juror, blah, 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 whatever. Which may or may not have any basis in reality, because someone trying to just throw this off for the lulz, you know, is not impossible. So you receive an email that happened. What was that happened on Reddit? Was during the Johnny Depp trial. That's right. It was during the Johnny Depp trial. Was that that Reddit post? I'm a juror.
Your Honor, very briefly, I know that there's been a request by the defense for
it wasn't a juror.
Jury view, and for planning purposes, I didn't know if Your Honor had if we had some plan for that, to do that, I guess, after this last witness, or at what point.
Secret McSquirrel's in the hospital?
All right.
Hard to hear that. I hope your rotator cuff
Depending
surgery
on
goes well.
What time you rest today, it might be this afternoon.
Oh, God, yes.
Just,
Your Honor.
Yes, sir.
And it could be now or after lunch, whatever the court prefers, but I would like to make a counsel motion for the record regarding the cell phone testimony we just heard.
Okay.
Your Honor, and the previous objection was that it was, which I was objecting to it being beyond the scope of the expertise with which it was offered, but the Supreme Court and counsel.
That wasn't your objection.
That was the objection. I'm now making a motion under counsel, Your Honor, for the record. And counsel, the Supreme Court said that when admitting scientific evidence, the trial judge must find the evidence will assist the trial fact, the expert witness is qualified, and the underlying science is reliable. The trial judge should apply the Jones factors to determine reliability, and then the case gives the Jones factors as Considering the admissibility of scientific evidence under the Jones standard, the court looks at several factors, including one, publications and peer review of the technique.
You know what the rule says beyond that?
Your Honor, the testimony we heard, which we had no notice of to make an earlier motion, there's no publications or peer review of the technique he described. There's no prior application of that method. He testified he's never done this before. Number three, the quality control procedures used to ensure reliability. No data was recorded at all, so there's none of that.
Your motion is late. You stipulated, you agreed that he was an expert. I gave you an opportunity to voir dire him, question him in any way.
Your Honor, we had no notice that he was going to offer this experiment. He was offered as a cell phone forensics expert, which he is. And there was no notice that he had done this engineering analysis throwing his phone around.
He did not do an engineering analysis. He said he didn't do an engineering analysis. And what was scientific about his testimony?
I think that's kind of the problem, Your Honor. That's exactly
yes, Your
the
Honor.
problem.
His testimony was not scientific. That's why moving under counsel that it is not reliable scientific testimony and should be struck.
All right. What says the state?
Your Honor, I think, again, as Your Honor's pointed out, there was no objection. This was in the nature of
You've got to be
fucking
fucking me. You can't be serious.
Again, there's a practical experience that is acceptable for opinions to be offered, and that's kind of what we're talking about. He understands the
It's
razor
outside
weight
the
feature
knowledge of a
and the
layperson.
manner in which it works and in which it doesn't work, and he offered his testimony based on his experiments in that
You can't bring
regard.
in his lay witness
Counsel will
testimony.
allow
You
him
can't
fully
bring in his
cross-examine the
expert
witness,
testimony.
and
You
it
can't
will
bring it in.
ultimately, go to weight, not admissibility, Your Honor.
Oh, wait, not admissibility. Oh, okay, that's
Noted for the
bullshit.
record, he did not provide scientific testimony.
That's the problem.
Conducted an experiment and told the jury about it. The fact that had the defense had any questions concerning his qualification to testify
What are
as an
you
expert
talking
witness,
about?
the defense had an opportunity to do that through voir dire or otherwise. Rule 5 does not apply to reply testimony in the sense that the state is not required to provide any advance report or anything. Your objection is noted for the record. The testimony speaks for itself, and that's that. Yes, sir.
Your Honor, one other matter. The forensic pathologist said this morning concerning some of her testimony.
It's a bad ruling.
About the white material that was noted.
It's a bad
she
ruling.
indicated that she had
You didn't
never
object in voir
put that in her
dire?
autopsy report. She'd never given this opinion before.
Really?
We propose in sur rebuttal to bring our pathologist back to testify when they finish
But we
their
discovered
case.
in the middle of it that he's not an
Allowing
expert.
his
He says he's not
survey
an
based on
expert.
what I've
So
heard at this point.
it's not.
Even though she said, wasn't in a report,
Yes, sir.
revealed it today for the first time.
Yes, sir.
Okay. I'm just gonna.
Thank you,
I'm
Your
gonna go
Honor.
to my
So you're
happy
denying that
calm
request.
place.
I'm not
I'm
inclined
gonna go to my
to
happy and calm place.
at this time.
Well, when would be the appropriate time?
Well, when it's time
I'm
for you
channeling
to
the witness from
offer
earlier.
it,
I'm not angry.
then I'll hear it fully, but I'm telling you now, I do not anticipate allowing any sur rebuttal based on what I've heard at this point.
Thank you, Your Honor.
Yes, sir. Anything else?
Lunch break, Your Honor.
Nothing from the defense, Your Honor.
All right, we'll be in recess till 2:15.
Bad ruling. Bad ruling, guys. You know. All right. So let's just talk about the basics rules. The rules that are supposed to be that exist, okay? So lay witnesses, that's just normal people, right? So you have two categories, a lay witness and an expert witness, right? So if you're not an expert witness, you're necessarily a lay witness, right? All right. So what opinions can a lay person testify? What opinions can a non-expert testify about? And basically a non-expert can testify about things that would be within the scope of knowledge of a non-expert. Example would be, how fast was the car traveling? Right? We're all familiar with cars. We're all familiar with driving cars. We're all familiar with cars driving, right? So how fast was the car driving? It was driving about this fast, right? Would be an example. What color was the light? Right. Well, I observed it. It was this color, right? Well, that's more of a fact question, not even an opinion question. So, like, but you understand the point, right? So, how far away was he from you? Well, he was 5 feet away from me. Or, for example, when I said earlier at the when I was talking about Vegas, and I said, oh, there's about 100, 125, maybe 150 people there. That would be an example of a lay opinion, right? I'm not a expert in crowd sizes. I'm not an expert in math, any technical subject that would allow me to say, hey, there was about 100, 125, maybe 150 people there, right? That is just a lay opinion. I just base it because I've been in crowds before, and that seemed to be about roughly the size of the crowd, in my opinion. Is my opinion good or not? Well, it's within the scope of a lay opinion. So if someone else said it was 300 and someone else said it was 50 and someone else said whatever, and then Nick says, well, it was exactly these many people because we counted, right? Then these would all be ways to get to it. But it's within the scope of a lay person. Like how good is my opinion is within your ability, but my ability to offer it is a lay person. So, okay, is this within the scope of a lay person? No, not really. Not in my view. Because, well, he's bringing it in as like scientific testimony, or he's bringing in as technical testimony. It's like, well, if you raise the phone, softly, it does this, but if you raise it fast, it does this. It's based on an accelerometer. I tossed the phone around 10 times and I observed this. So, but it seemed a little bit, seems a little bit questionable for a lay person. So, all right. So, like, he's not a lay person. Let's try expert witness. Is he an expert witness? Well, he says he's not. So that makes that easy. And as to this, he even says he's not an expert witness. So the defense is like, okay, I want to move to exclude this because it's some bullshit. So the judge's ruling seems to be centered on, well, you accepted him as an expert. You had the opportunity to voir dire him to see the scope of his expertise. And it's like, but we didn't have any reason to. We didn't have any reason to because we didn't know this thing existed. We didn't receive any reports. None was generated, incidentally. And he is an expert in cell phone forensics and cell phone extraction. He is an expert in that. So we agreed to the scope of his expertise. And now he's offering an opinion that we are now discovering in real time is outside of his expertise because he says it is. Right? So this portion of his testimony should be stricken because it is not within the scope of his expertise. And so the judge's ruling basically is like, well, you said he was an expert earlier, and so it's your motion is too late. You said he's an expert. You can't go back on that. But he says he's not an expert. And we know a particular reason to voir dire into this particular respect because we had no idea that testimony was going to be offered. So we've discovered this in real time and we should exclude. And the judge is like, no. So this is somewhat difficult to justify under the relevant rules that I have just laid out for you. The defense's motion is basically fundamentally correct. It's like, well, he's an expert in cell phone extraction, so yes, we think this is outside the scope of his expertise. He says it's outside the scope of his expertise. It's not, and the judge is like, but he's not testifying it was a scientifically done study. And the defense is like, this is our problem. Right, you've got it. It's not. It's some bullshit. And then the judge says it goes to weight, not admissibility. Bullshit. Bullshit. In scientific testimony in particular, because scientific testimony, as one would expect, is given some special weight by jurors as a matter of practical reality. So the threshold keeping role of the judge is somewhat important in this respect. Yeah, Kevin has it basically right. Your Honor, the expert says he's not an expert. It doesn't matter that the expert isn't an expert. We're going to call him an expert. So, yeah. So a questionable ruling, not for the first time. And I feel for defense lawyer. And defense lawyer over here is getting up and going through the standard. Judge like, oh, I know the rules. I know the standards. And I'm like, okay, well, we'll move on to something else, I guess. Defense counsel handled that just about as well as they could have with a hostile judge. And I felt like there was palpable disrespect almost, which seemed unwarranted. I might be overreading the situation, but it felt like the judge was being palpably disrespectful of the defense, who was making what seemed to be quite lucid arguments, even if you could come to a different conclusion about it. But, you know, yeah. So, okay. So some problems emerge as a result. Yeah, so I don't know what that was all about. I don't know what that's all about. The scope of expertise is important. That they're testifying within their expertise is important. Did you conduct any surveys or did you conduct any studies? Now, I don't know whether or not he's telling the truth about why he didn't record it or not. And also, to some degree, I don't really care. It's like, did you not record it because you knew you'd have to disclose it? I don't know if that answer is truthful or not. Also, I don't really care. It's like you didn't do this in any sort of methodological way. You just tossed phones around. And now you're an expert in phone tossing and how phones do or do not respond based on, and it's like, well, you know, it's the accelerometer. How do you know it's the accelerometer that turns the phone on or off? I mean, how do you know that? So there are problems. Can a judge refuse a jury nullification? Well, no, because they would have no reason to know the reason the jury returns a verdict of not guilty. They don't inquire into the reason. They inquire into the vote. So they'll ask if it's your verdict, but they don't ask why. So no. But you don't need jury nullification. The jury, I mean, you don't need jury nullification to get to this. Like, because, I mean, we are concerned that the jury is going to overly believe the expert, but they don't have to, right? Jury nullification, as a technical matter, is where the jury thinks guilty but votes not guilty, right? We're voting not guilty not because we think not guilty. We really think guilty, but we're really voting not guilty because we think the law is unjust is usually the reason, right? That's jury nullification. Jury nullification isn't we disbelieve the expert. The jury is allowed to disbelieve an expert. A witness's testimony can be disbelieved in whole or part. And a jury is allowed to disbelieve an expert in whole or part. So it goes to weight, not admissibility, right? Assuming that that's correct, the jury can say, okay, the weight we assign it is 0. That's not nullification. That's the jury doing their proper role. It's also the jury being smarter than the judge, which is distinctly possible. So yeah, that's not jury nullification. A jury can say we think that this expert is full of shit and we don't believe anything he says. That's fine. We think this expert is crap. We don't think this expert knows what he's talking about. Jury can do that. It's within the jury's role. It's not improper. If you think the law is unjust, does guilt matter? I mean, as a legal matter, yes. A jury is not allowed to think a law is unjust, or at least they're not allowed to vote based on that reason. So does it matter? I mean, legally, yes, it does matter. So I'll answer the question that way. A jury is allowed to, in terms of what a jury is allowed to do and what they will do, but what they're allowed to do They're allowed to disbelieve a witness in whole or part. So jury nullification is where they think proof beyond a reasonable doubt has been established, but they vote not guilty anyway. A jury is not allowed to do that. Or, as has been said by courts, they have the power, but not the right. They can, but they're not supposed to. It's an abuse of the jury's power. But of course, because of double jeopardy clause, it doesn't really matter very much, but it's still technically illegal. But depends how much you care about things. I think you should care about things. I think you should care about things because the judge making legal errors, right? I think it's a little bit difficult. I think it's a little bit difficult to say the judge is making legal errors, and those are bad because they're legal errors. But the jury should be allowed to nullify, which is a legal error, right? It's like either you support legal errors or you don't to some degree. It's like, it's not okay for the jury to make legal errors anymore from the judge to make legal errors. So, I mean, for me to say, okay, the judge is making these legal errors is like, yeah, the judge is making mistakes. And it's like, if you say, well, the jury should be allowed to nullify, you are saying a jury should be allowed to make legal errors. So you're supporting legal errors in the right situation. And then you're in this possible universe where now maybe the judge is doing the right thing, right? So maybe the judge is doing the right thing because, well, the fact that judge is committing legal errors is now no longer the end of the analysis. Now we have to go on and decide whether or not he has really good reasons for committing those legal errors. And maybe if his reasons are good enough, we don't care anymore. So, yeah, it's a dangerous proposition. All right, so let's talk about something else. Supreme Court released 2 opinions today. We will read them, and we will understand how the law has changed and improved for all of our mutual benefits, or not, as the case may be. Let's see. Ba, 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 ba. Let's see how this looks. Da, 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 da. Da, 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 da. That'll work, I think. That'll work. All right. The U.S. Supreme Court rules on whether or not states can keep money that has been abandoned within their state and which states have claim to the money that's been abandoned, how you determine the place of abandonment. Let's get started with this. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today is the day I earn that subscription. For today's story, we are talking about a United States Supreme Court decision that just came down. It is Delaware versus Pennsylvania, a case of original jurisdiction before the U.S. Supreme Court, which means the Supreme Court is the trial court, because that's how we roll. So there is a dispute between Delaware and Pennsylvania regarding how money abandoned is assigned to what states. How do you determine that? Which state gets to keep abandoned monies? So Western Union is a company that deals with sending money, among other things. You can get checks and money orders and send them around. And what if no one claims that money? Well, if no one claims that money after a while, then the state gets the money. But then the question is, which state? How do you determine that? And that is the dispute. So let's learn a little bit more about this. All right, Delaware versus Pennsylvania, case of original jurisdiction. On exceptions to the report of the special master. So as is common when the U.S. Supreme Court has original jurisdiction, they are the trial court. They don't typically really do it. They assign it to someone else, but they are still the case. They are still the trial court, which means they can do whatever the hell they want. So everything is de novo. So they can look at the special master and just completely ignore them, but they don't tend to do that. So anyways, the court has assigned someone to provide a recommendation, and the court has to decide whether or not to take that recommendation, but the Supreme Court can do as they wish. A state may take custody of abandoned property located within its border. This is known as escheatment. When abandoned property is intangible, however, the lack of physical location means multiple states may have claims. So if you're abandoning physical property, you leave your car on the side of the road for a long period of time or whatever it is, however you determine abandonment, or for that matter, abandon real property, you just leave your house and just leave. Maybe it's been abandoned, right? So, okay, at some point, through some mechanism, the state says, yoink, my property. But if it's not physical, what do you do? In these cases, the question is which state has the right to escheat two financial products sold on behalf of MoneyGram, agent checks and teller checks. Operating much like money orders, both products are prepaid financial instruments used to transfer funds to a named payee. When these prepaid instruments are not presented for payment within a certain period of time, they're deemed to be abandoned. And currently, MoneyGram applies the common law escheatment practices outlined in Texas versus New Jersey. So there are some rules, basically, how long does this money order-like instrument remain valid? How long do you have to do it? So you might be familiar with the idea of a stale check, right? Check beyond a certain period is stale. A lot of banks will refuse to cash a check that's more than 180 days old, for example. And so a similar concept, right? And in this case, if it becomes stale enough, then it's deemed to be abandoned. There, the court established the rule that proceeds of abandoned financial products should escheat to the state of the creditor's last known address, or where such records are not kept, to the state in which the company holding the funds is to be incorporated. Because MoneyGram does not, as a matter of regular business practice, keep records of creditor addresses for two products issues, it applies the secondary common law rule and transmit the abandoned proceeds to the state of incorporation, that is Delaware. Okay, so what we have going on is this idea of who is the creditor, right? Who is the person the check is made out to or the money order made out to? MoneyGram doesn't keep this information, or at least they don't have the address of the person. They don't have it, right? It's just made payable to somebody, and they don't know who it's made, who it is, which they honestly probably don't, right? When you go and you order a money order, they don't typically ask who it's for, and they certainly don't keep records, so they don't know. What they know is they have a money order that was issued. They know how much it was issued for. They know the date it was issued on, and they know whether or not it's been cashed, but they don't know who the creditor is. So the rule is, if we did know the creditor and their address, then it would be deemed to be abandoned in that state. So if we did keep a record and said, it's owed to Joe Smith. Joe Smith lives in Florida. Then the rule would be Florida gets the money. But they don't keep those records. So then I was like, okay, so what do you do? Well, if you don't know where the creditor is, how about the place where the instrument, how about the place where the business is incorporated? Right? It is money that the company owes, right? You give your money to MoneyGram. They issue this thing, they have to pay it out. So they're holding it for you. And it's on their books. It's on their books. And then after a while, well, it hasn't been paid. We don't know where it's supposed to go. So we'll just give it to, it's not our money, right? It was never our money. We were just holding it for someone else. And it's sitting on our books. But it's not really our money. So how about the state of incorporation gets it, which is Delaware? So Delaware gets all the money. Great for Delaware, if you're Delaware, because no matter where this MoneyGram is purchased, no matter where it's purchased, it's on the books in Delaware. So when the money goes abandoned, Delaware gets it all. Delaware likes money. So they'd like to keep all the money. Okay, let's read a little bit more. Multiple states have invoked this court's original jurisdiction, which is what happened when one state sues another. One state is mad at another state. They file in the U.S. Supreme Court as the trial court to determine whether abandoned proceeds of these instruments are governed by disposition of abandoned money orders and traveler's checks rather than the common law. So there was a common law rule, but Congress perhaps wrote a different rule. So let's go see if that applies. The relevant law provides that a money order or other similar written instrument other than third-party bank check should generally escheat to the state in which such instrument was purchased. All right. So now we have a different rule, right? So under the common law, how about the state of the creditor? The person who the money is going to. We don't know who that is. All right. Fine. How about the state where the company is based? Delaware. That's the common law. Congress comes along and writes a federal law because it deals with interstate commerce and says, okay, if it's a money order or a similar instrument, not a third-party check, right? So third-party check, like issued by a bank, different rule. But if it's a money order, we're going to modify the common law and we're going to say where the instrument was purchased. So Delaware is going to lose a lot of money. Delaware is sad. If this is a money order, because all those funds, well, now they have to share with all the other children. And they'd like to not do that very much. Okay. The court consolidated the various actions and appointed a special master, as they do. They appointed someone else to referee this because, they can't be bothered. In the initial report, the special master concluded the disputed instruments were covered by the federal law. These are money orders, says effectively the special master. Following oral argument in this court, he reassessed that decision and introduced a second report, concluding that many of the disputed instruments were or could be third-party bank checks. So are they money orders or are they third-party bank checks? He says some of them are third-party bank checks, which are excluded and would escheat to Delaware. All right, so that's the question. Are these third-party bank checks or are these money orders? So he says, okay, some of the time they're third-party checks. U.S. Supreme Court, being the court of original jurisdiction, says the disputed instruments are sufficiently similar to money orders to fall within it. So the U.S. Supreme Court just disagrees with the special master flat out, which they can do because they're the court of original jurisdiction. They are the trial court. So the recommendations from this would be roughly equivalent to a magistrate in a typical federal court. Magistrates often handle matters and they work for a federal judge. And if everyone's happy, then the magistrate can do lots of stuff. Not everything, not everything. They can't do all the things, but they can do lots of things. And depending on the nature of the case, sometimes the case can be completely resolved by the magistrate. Right? But, sometimes at least you can refuse to have a magistrate and be like, I want my case decided by a federal judge. And even where you consent to a magistrate, you can appeal, although strictly speaking, appeal is the wrong word, because it's not an appeal, because the district court is the court. The magistrate works for the federal court. And so many times the district court will say, well, I agree with the magistrate, but not all the time, and they don't have to, because they're the trial court. And they can be like, well, that's nice, magistrate, and all, but, no. And so very similarly, the U.S. Supreme Court's in basically the same position. They've appointed a special master, and special master's like, how about third-party bank check? And the Supreme Court's just like, no, they're not. They're money orders. Delaware just lost a lot of money. Delaware just lost a shit ton of money. Delaware is sad. But that's where we're at. Delaware is going to have to write some pretty big checks of their own here in about a second. The disputed instruments share two relevant similarities with money orders. First, they are similar functionally and operationally. Although the relevant federal law doesn't define what a money order is because that'd be way too convenient. A variety of dictionary definitions contemporaneous with the Act passage universally define a money order as a prepaid financial instrument used to transmit money to a payee. And this court's common law precedent, the backdrop against which the federal law was enacted, accord with that definition. So Congress, in their infinite wisdom, didn't define what a money order is, but, well, this court had talked about what money orders were preceding the act, and the dictionary definitions are in alignment with that. So we're going to assume Congress just wanted the definitions that were in existence at the time. So, fine. In addition, the features that money orders share with these instruments, the fact that they are prepaid, make them likely to escheat and thus implicate the law in the first place. So apparently, a lot of these things are abandoned. So, fine. Second, due to record-keeping practices of the entity issuing and holding on to the funds, abandoned money orders and the disputed instruments both escheat inequitably under the court's common law rules. Delaware currently gets all the money. That's not quite fair, is it? The federal law was passed to abrogate this court's common law precedent precisely because, for certain instruments because money orders, the entity selling products often did not keep adequate records as a matter of business practice, which meant that the law mandating escheatment to state of corporation always applied. So this was the reality before, as it is the reality now. MoneyGram doesn't keep records. Neither did anyone else. They don't keep these records as a matter of their business practice. They just don't. So Delaware always got all the money because all the businesses are incorporated in Delaware. So Delaware got all the money, and Congress thought that was a little unfair. So the federal law prevents this windfall to the state of incorporation by instead adopting the place of purchase rule that distributes the money as a matter of equity among the several states, which, when it's Congress passing law, as long as it's within their authority, it's not fair is a perfectly reasonable reason. Right? That's what Congress does. Congress does policy. So it's not fair. Okay. Because MoneyGram doesn't keep these records, application of the common law would produce the same inequitable results that the law was designed to solve. Delaware doesn't get to keep the money. Delaware's contrary arguments are unpersuasive. Their contrary arguments mostly being, we're about to have to write some really big checks. First, the state contends that money orders refers to a specific commercial product, labeled as such on the instrument, and sold to low-income individuals. So money order is only a money order if we call it a money order. If we call it something else, it's no longer a money order. Even though, incidentally, the law says money order or similar instrument, because Congress wasn't this dumb. But even if it literally said money order and nothing more in the federal law, the courts wouldn't be this dumb. Oh, we didn't call it a money order, therefore it's not a money order. Yeah, no. Unable to present a dictionary definition that cabins the term as described, lol, no. Delaware attempts to highlight the various way in which disputed instruments differ from money orders. Okay, they're not money orders because reasons. But Delaware never explains how these differences are relevant or how such differences undermine the similarities. They're not money orders because things. Yeah. In an effort to make these differences more relevant, Delaware asserts that the law was actually concerned with dissuading the states from adopting costly record-keeping requirements that would then be passed on to consumers. What? Delaware argues the disputed instruments are unlike money orders in that consumers of the instruments are typically more capable of absorbing the cost of record-keeping. What? The text, however, does not support this argument. No. Congress was really concerned with their record-keeping requirements. Well, what it says is nothing like that. So, yeah. Finally, Delaware's suggestion that the law be read narrowly to avoid creating surplus and sweeping in all sorts of unintended financial instruments goes too far. While there's some merit to Delaware's concern about a broad term, money order, this court not need actually define the term, as it suffices that the instruments in question be similar to money orders. So, first of all, yeah. First of all, if it literally said only money order, we'd still probably be making this exact same decision, by the way, because we're not that dumb. So even if, unless of course the language was more clear, right? So Congress could of course only make this so it would only apply to some strict version of money order, right? So Congress could do that, but probably didn't do that because, well, we just merely changed the label on the thing. It's not normally how we deal with this, but Congress thought one step ahead. Congress was a smart Congress and wrote similar. So are these money orders? We don't have to actually decide if these are money orders or not because the law itself says similar. So there's that. That makes our life a lot easier. Both Delaware and to some extent the special master claim that even if they qualify as an otherwise similar written instrument, they're also a third-party bank check. So let's give that a try. They're really a third-party bank check. The problem, of course, is that the law doesn't define that phrase either. Because why would Congress define things? Nor does the phrase have a commonly accepted meaning. So the Supreme Court's like, we're not really sure what a third-party bank check is. Delaware insists the term means a check signed by a bank officer and paid through a third party. But the state provides no theory as to why it matters to the escheatment rule whether a financial instrument is or is not paid through a third party. In the second interim report, the special master offered the view that third-party bank check was intended to exclude from the reach certain well-known financial instruments upon which a bank might be liable, specifically a cashier's check, certified check, and a teller check. And thus, to the extent a bank shares liability with MoneyGram or the disputed instrument, that product should be characterized as a third party. And thereby excluded. The special master did not explain why Congress would use the amorphous term to describe a well-known financial product, while also calling out other well-known instruments, such as money orders, by the name. Nor did the special master explain how bank liability relates to the rules in any meaningful way. Bank liability also doesn't seem to be the tipping point for exclusion from the law, given that banks can be liable for money orders. So banks issue cashier's checks, to be sure, and teller checks. But you know what else banks sometimes issue? Money orders. Some banks issue money orders. They call them money orders. They're money orders. So the fact that the bank is liable is not dispositive. Because whether the bank is issuing the money order or whether or not MoneyGram is issuing a money order, it's a money order. So it can't be because the bank is liable, therefore not money order. That can't be right. Yeah. Finally, legislative history on the law does not support the contention. Disputed instrument constitutes a third-party check. The well-documented circumstances surrounding insertion of the phrase support the conclusion that whatever the intended meaning of third-party check, it cannot be read broadly to exclude from the large swaths of prepaid instruments that escheat inequitably. So this is not a third-party check, is basically the bottom line. Judge Jackson issues an opinion for unanimous Supreme Court, and with respect to some other part in which 5 members join. So, yeah. So Delaware is sad because Delaware has to write some checks. Or I suppose money orders will also be fine. Somehow I feel like those particular money orders will not go abandoned when they're sent to their respective states. But yeah, that sounds about right. The law says money order or similar instrument, and these look suspiciously like money orders. So the special master said some of these things are really third-party checks because these money orders are also backed by banks. And the Supreme Court's like, no, they're not a bank check. They were issued by MoneyGram. MoneyGram is not a bank. So they're not a bank check. So, no. So, yeah. So that's fun. Delaware has to send some money. Lol. So, all right, that's the end of that case. Let us move on to number 2. Let me read this so I can do the cold open, because I'm not familiar with this case. I was able to do the cold open on that case because I was familiar with it. But this one, Bittner, I'm not sure familiar with. Uh-huh. I'm not sure how to cold open this one. Mm, 5-4 issued by 5-4 issued by well, 5-4 penny skips to parts 2C. Yeah, 5-4 issued by Gorsuch. Okay. For today's story, we talk about how much money you have to pay when you don't file the right reports at tax time. Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content. And today's the day I earned the subscription. For today's story, we're talking about a brand new U.S. Supreme Court case. This is Bittner versus United States and deals with tax liability and reporting on the tax liability. Now, this guy had some money overseas, and the issue is the federal government thinks that he hasn't reported the money correctly. And so they think that he owes some money as some penalties. And the question is, how much penalties? The federal government calculated the penalties at $2.7 million. So a little bit of penalties for the non-payments or the misreported payments on the taxes. So does Bittner have to give the IRS $2.7 million in penalties? Let's read more. All right. The Bank Secrecy Act and its implementing regulations require that U.S. persons with certain financial interests in foreign accounts file an annual report known as FBAR, Report of Foreign Bank and Financial Accounts. So the United States government has gotten wise to the idea of people having their Swiss bank accounts and Cayman Island bank accounts and so forth and so on, and said, okay, if you have these foreign bank accounts, you've got to tell us about them, because as a U.S. citizen, you owe us tax, and we want to know about the money so that you can pay us the tax. So you got to report your foreign bank accounts. So the Swiss may want to keep your bank account secret, but you got to tell us. The statute imposes a $10,000 penalty for non-willful violations of the law. So even though you didn't try to deceive the government, if you misfiled your forms, it's a maximum of $10,000 fine. So it's not that you tried to, it's not that you were deceiving us, it's not that you were trying to hide it. This is non-willful. You just screwed it up. So if you screw it up, even if you didn't try to screw it up, you owe us $10,000 penalty or up to $10,000 penalty for a non-willful violation. If it's willful, we want more. But $10,000 for non-willful. So I guess make sure that your accountant is really, really good. These reports are designed to help the government trace funds that might be used for illicit purposes and identify underreported income that may be subject to taxation. The U.S. government wants its tax money. The petitioner, Bittner, is a dual citizen of Romania and the United States, learned of these obligations after he returned to the United States from Romania in 2011. So he's a Romanian in addition to being an American. He's living overseas in Romania. And when he comes back from Romania in 2011, federal government's like, you got any money? All right. So he subsequently submits the required reports covering 5 years. The government deemed these late filed reports deficient because the reports had not addressed all accounts to which Bittner either had signatory authority or a qualifying interest. So he didn't apparently reveal all the accounts, perhaps because he misunderstood, or at least we believe he misunderstood because these are, again, non-willful violations. So he reported some of the accounts he owned, but not all the accounts to which he was supposed to report. Bittner then filed corrected reports, providing information for each of the accounts. 61 accounts in 2007, 51 accounts in 2008, 53 accounts in 2009, and 54 accounts in 2011. He had a lot of accounts. The government neither contested the accuracy of these new filings, nor suggested that the previous errors were willful. So we don't think that you were like, well, we're not going to at least say that you did, right? We're not saying that you did this willfully. You didn't report all the accounts you were obligated to, and he's now filing corrected reports, and we think, honest oopsies. But despite the fact of honest oopsies, because the government took the view, the non-willful penalties apply to each account not accurately or timely reported. And because of these 5 late filed annual reports involved 272 accounts, the government calculated the penalty at $2.7 million. So again, it's not that we think that you're deceiving us. You made an oopsies, but you made an oopsies 272 times. So that's $10,000 per time. So give us $2.7 million. Bittner challenges the penalty, arguing that the law authorizes a maximum penalty for non-willful violations at $10,000 per report, not per account. The Fifth Circuit said, give us $2.7 million. The U.S. Supreme Court says the $10,000 maximum penalty is per report, not per account. So how about $50,000 instead of $2.7 million would be the bottom line on that one. You filed 5 wrong reports. So it's not per account, it's per report. And so you owe $50,000 in penalties instead of $2.7 million in penalties. So $2.7 million break. So good for Bittner, I guess. I would also like to take note, just for the sake of pointing out what I hope is obvious, that yes, the IRS does lose cases. The IRS does lose cases. You can win against the IRS. It is one of those things that brings hope to my heart, right? Even the IRS does lose cases in its own courts. The IRS just lost a case. The IRS just lost $2.7 million. So I'm proud to be an American. It's a good time. The court begins with the terms of the most immediately relevant statutory provision. That's a good place to start, which delineates an individual duties under the relevant law, and a different section which outlines the penalties that follow from failing to discharge. The relevant law provides the Secretary of the Treasury shall require certain persons to keep records, file reports, or keep records and file reports when they make transactions or maintain a relationship with a foreign financial agency, think bank. although not necessarily because, again, Congress isn't that dumb. The statute states that reports shall contain information about the identity and address of participants in transactions or relationships, the legal capacity to which a participant is acting, and the identity of the real parties in interest, along with descriptions of transactions. The relevant law does not speak of accounts or their number, but rather the legal duty to file reports, which must include various kinds of information about foreign transactions or relationships. Violations of the law's reporting obligation is binary. One files a report in a way and to the extent the secretary prescribes, or does not. Multiple willful errors may establish a violation of the law, but even a single mistake, willful or not, constitutes a violation. So if you willfully violate it, that's bad. But if you non-willfully violate it, that's also bad. The only distinction the law draws between a report containing a single mistake and one containing multiple mistakes concerns the appropriate penalty. The relevant law authorizes the secretary to impose a civil penalty of up to $10,000 for any violation of the law. The non-willful penalty payments does not speak in terms of accounts, but rather pegs the quantity of non-willful penalties to the quantity of violations. The relevant law provides that a violation occurs when an individual fails to report consistent with the statute commands. Multiple deficient reports may yield multiple $10,000 penalties, and even a seemingly sufficient simple deficiency in a single report may expose an individual to $10,000. So even once. But penalties for non-willful violations accrue per report, not per account. So the secretary has a right to charge up to $10,000 for any violation. So even a small violation, if the secretary wants to, $10,000. That's a lot of penalty. Apparently Bittner over here, though, not as much with the 272 accounts. So it seems like he's doing okay financially. As his joint Romanian citizen, U.S. citizen life seems like he's doing okay financially. But, $10,000 for even one failure to report these foreign accounts. But the issue is the report, not the accounts. So, yeah. To be sure, for certain cases that involve willful violation, the statute does tailor penalties to accounts. The relevant law specifies additional subclasses of willful violations that include failure to report the existence of an account or identifying information required to provide with respect to the account. In such a case, the secretary may impose a maximum penalty of either $100,000 or 50% of the balance in the account at the time of the violation, whichever is greater. Ouch. So if you are willfully defying the law, how about $100,000 or 50% of the money in the account? So again, if you have foreign bank accounts, you might want to make sure that you're reporting that information correctly because, yeah. And if they find that you're doing it willfully, how about just give us half the money? This is the Joker. What do you want? Half. The government maintains that because Congress expressly authorized per account penalties for some willful violations, the court should infer that they meant to do that for non-willful violations. That doesn't make sense. That doesn't really make sense. Congress obviously knows, because they just did it just now, they obviously know how to say per account when they want to. So if they didn't say per account, then perhaps they meant something else. But the government's interpretation defies a traditional rule of statutory construction. When Congress includes particular language in one section of a statute and omits it from its neighbor, the court normally understands that difference to convey a difference in meaning. To express the one is to exclude the other. Yeah. So if Congress in some provision says per account, and then in a different provision doesn't say, then to exclude it is to exclude the alternative. or to express one is to exclude the alternative. I think I screwed that up completely. I'm just going to redo that section a little bit, because I think I said to exclude rather than to include. I said it backwards. But the government's interpretation defies a traditional rule of statutory construction. When Congress includes particular language in one section of a statute and omits it from its neighbor, the court normally understands the difference in language to convey a difference in meaning. To express the one is to exclude the other. Yeah. So if Congress says something in one section, they express something in one section, then they're excluding the other thing, right? Because Congress obviously knows how to write something when they want it to be true. And so if they express it and then don't, it's probably because they don't want that thing. These are standard rules of statutory construction, not that hard. Here, the statute twice provides evidence that Congress knows how to tie sanctions to an account level when it wants to. Congress said in one section and then a different section that various penalties for willful violations may be measured per account. And Congress said in some other section that a person may invoke reasonable cause exception only on showing of a per account accuracy. But Congress did not say non-willful per account. So Congress, when they write words, they mean those words, and then they don't mean it in other sections. So Congress obviously wanted per account. Well, they obviously didn't. Because when they wanted it, they said it. They know how to say it. They just said it just now. They know how to say it. So, and it also doesn't defy reason at all, right? Your report is wrong. Pay a penalty. You're trying to cheat us. Pay us a bigger penalty. It's pretty logical, so it doesn't even defy logic. The court finds a number of additional contextual clues that cut against the government's theory. First, the government has repeatedly issued guidance to the public in various warnings, fact sheets, and instructions that seem to tell the public that failure to file the report represents a single violation exposing non-willful violator. So the agencies agree. While the government's guidance do not control the court's analysis, courts may consider the inconsistency as a basis of interpretation. So your guidance could, of course, be wrong because the law is the law. So, if you screwed up the interpretation, then, fine. But yeah. Second, the drafting history of non-willful penalties provisions undermines the theory. In 1970, the penalties included only willful violations. In 1986, Congress authorized penalty on per account basis for certain willful violations. When Congress amended the law again in 2004 for non-willful violations, they could have, but did not, use the similar language from 1986 to extend it to the non-willful. So originally, they said penalties for willful. Then they said, how about per account penalties for willful? And then they said, how about the non-willful? So Congress obviously knows how to amend the law to say per account when they want to. So yeah, not so much. Still, other features from the relevant law and the regulatory scheme suggest the law aims to provide the government with a report sufficient to tip it to the need to further investigate, not to ensure presentation of every deal or maximize revenue for every mistake. Congress declared the law's purpose is to require certain reports or records that may assist the government in providing investigations. Now, when Congress explicitly in the law provides purpose, which they sometimes do, then it's perfectly proper for an originalist to consider it because Congress is the one passing it, right? If Congress says our purpose and intent is to do a whole bunch of things, then great. Congress passed the law. And then to the extent that the statute is ambiguous, then you can absolutely, as originalists, go to the purpose as being informative. Not necessarily dispositive, because there might be other factors, but if you want to know what's Congress's intent and they tell you, here's our intent, that's pretty good. Absent is any indication Congress sought to maximize penalties for every non-willful mistake. The Secretary's regulations implementing the law require individuals with fewer than 25 accounts provide details about each account, while individuals like Bittner with 25 or more accounts do not need to list every account, unless the Secretary wants more detailed information. So apparently, for whatever reason, if 25 accounts or less, tell us about every account. If more than 25 accounts, you can just tell us collectively. That's fine. I don't know how that really makes any sense at all. Like, why would you want individualized accounts for less than 25, but not more than 25? If anything, you would think it would kind of be the other way around, because maybe it's just like too inconvenient for people with only a few accounts to really keep track of them. But if you have a lot of accounts, then it shows that, you have the ability to keep track of them. So I'm not really sure why the regulations are written that way or how that makes any sense. But when did I have to understand why things made sense just to understand that that's the law? Congress, apparently the relevant regulations say if you have more than 25 accounts, then just generally tell us vaguely what it is. That's fine. Okay. Finally, the government's per account penalty reading invites anomaly on let me try that again. Me. All right. Finally, the government's per account penalty reading invites anomalies. For example, subjecting willful violators to lower penalties than non-willful violators. Yeah, I guess that's possible. Avoided by reading the non-willful penalties to apply to a per report basis. So yeah, I mean, the government's reply that per report interpretation risks the anomaly. The Secretary could formulate reporting requirements to require a separate report for each account, and that way effectively achieve the per account penalty. While what this proves is unclear, lol, as the Secretary's discretion to require more or even fewer reports is not the issue. And in any event, does not answer whether the Secretary may impose it on a per report or per account basis. So they're like, this doesn't make any sense. The federal government's like, this doesn't make any sense because the Secretary could just require a report for every account. And the Supreme Court's like, maybe, I don't know. I'm not here to decide that right now. You probably could require a report for every single account, but Best read, the law treats the failure to file a legal complaint as one carrying a maximum penalty for $10,000 per report, issued by Judge Gorsuch in an apparently 5-4 decision with a perhaps strange split. Gorsuch issues the opinion of the court in which Jackson, Roberts, Alito, and Kavanaugh join. Barrett, Thomas, Sotomayor, and Kagan dissent. So a perhaps non-traditional 5-4, but that is the respective vote of the court. And of course, I'm a Justice Gorsuch fanboy, so all things being equal, I'm going to back my boy. So that was exciting. Very interesting stuff. Justice Gorsuch and I have certainly disagreed at times, but that sounds about right. So I found this to be exciting, and I hope you did too. So those decisions both came down today. So Mr. Bittner over here is $2.7 million richer than he was this morning. So good for him. Let's see what else has been issued recently. Not much. Cruz versus Arizona we did before, I think. Only 5 decisions issued right now. Let's see what else is happening. We did the Veterans Affairs thing. We read that decision. Helix Energy suits. Overtime pay. Okay. Whether or not someone is due overtime pay, that could be interesting. And what is this one? Oh, the fraud on the bankruptcy thing was interesting. Steve Leto recently covered that. We haven't covered that yet. You want to do that one? Let's talk about that one. Okay. Let's see. Do I feel refreshed after my Vegas thing? I had people telling me for like 2 hours that they loved me, loved my work, and thought I would produce great content. So I'm going to go with yes. I love you, Kurt. You're the greatest. Thank you for your help. Thank you so much. All right. For today's story, we discuss, when are you responsible for someone else's debts? Hello, everyone, and welcome to No, let's try that again. I can do my own introduction. I know how to do it. It's only like I've done it like 1,500 times before. Castle Moyle says you produce great content. The way you discuss these things so well on a first read is a bit scary. Thank you. I'll take that as compliment too. Is there some kind of presidential cabinet position that deals with laws? All of them? The Attorney General? Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earn that subscription. For today's story, we are talking about making sure that you partner up with the right people. There was a partnership between Kate and David Bartworfer. They jointly owned a house. They bought it together. They were married. They bought the house. And then they wanted to sell the house. Well, there might have been some problems with the house sale, namely some disclosures weren't given. And as a result of that, the house value was not proper. And so there was a lawsuit over it. And they got some money back. And then the housewife over here is like, wait a second, it was my husband who did the frauds. I shouldn't have to pay for the frauds. It was my husband who did the frauds. So does housewife have to pay for the frauds that her husband did? Let's discuss. Kate and David Bartworfer decide to remodel their home. They jointly. Blah, 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 blah. Kate and David Bartworfer. No, Werfer. Bartenwerfer. I can do this. Kate and David Bartenwerfer decided to remodel the house they jointly owned in San Francisco and sell it for profit. David took charge of the project and Kate remained largely uninvolved. They eventually sold the house to Karen Buckley. In conjunction with the sale, Kate and David attested that they disclosed all material facts relating to the property. So they're doing a house sale and they have to say what the house is. Like if there are any problems with it, they have to, disclose things. There's a reason we create the disclosure requirements in the first place. So they have to disclose some things. After purchase, Buckley discovered that several defects After the purchase, Buckley disclosed several defects that the Bartenwerfers had failed to disclose. Buckley sued in California state court and won, leaving the Bartenwerfers jointly responsible for $200,000 in damages. So not so much with the right disclosures, didn't disclose some things, give us $200,000 back. Unable to pay the judgment or their creditors, the Bartenwerfers filed for bankruptcy. Buckley then filed an adversary complaint in bankruptcy, alleging the debt owed to him was non-dischargeable in bankruptcy because the bankruptcy code accepted or provided Okay. Buckley then filed a complaint in the bankruptcy completing, alleging the debt owed to him on the judgment was non-dischargeable in bankruptcy because the bankruptcy code provided that any debt relating to money to the extent obtained by false pretenses, false representation, or actual fraud cannot be discharged in bankruptcy. So when you file for bankruptcy, not all debts can be gotten rid of. Perhaps most famously, student debt, student loan debt is one of the debts that cannot be gotten rid of except under some pretty exceptional circumstances. And another kind of debt that cannot be discharged is money obtained by fraud. So the idea being, of course, you failed to disclose some things in the house sale, fraud, and so this is fraud-related debt. The bankruptcy court found that David had committed the fraud and imputed the fraudulent intent to Kate because they had formed a legal partnership to renovate and sell the property. Okay, so David is the one that did the frauds, at least according to the bankruptcy court. David did the frauds. Okay. Kate didn't do the frauds. David did the frauds, Kate didn't do the frauds, but they're in a legal partnership. And when you're in a legal partnership, well, that comes with some obligations and some liabilities, right? The partnership jointly grows and they jointly suffer, right? That is the nature of the partnership. Like you grow together or you suffer together. And so, yeah. The bankruptcy appellate panel disagreed as to Kate's culpability, holding the relevant law barred her from discharging debt only if she knew or had reason to know. So the bankruptcy appellate court said, well, that's not fair. You have to prove that she knew. On remand, the bankruptcy court determined that Kate lacked that knowledge and therefore could discharge the debt. The bankruptcy appellate court affirmed. The Ninth Circuit reversed in relevant part, invoking a U.S. Supreme Court that held that a debtor who is liable for a partner's fraud cannot discharge the debt into bankruptcy regardless of their own capability. So we went to bankruptcy court. The bankruptcy appellate court reversed. The bankruptcy court did its thing. We appealed to the district court, or we appealed to the Ninth Circuit in charge of the bankruptcy court, and they say, no, the bankruptcy court was wrong. So, held, the relevant law precludes Kate from discharging her debt obtained by fraud, regardless of her own culpability. So, yeah, the bankruptcy appellate court got it wrong, according to the U.S. Supreme Court, and according to the Ninth Circuit, incidentally. So it's nice that the Ninth Circuit gets one right. So then the bankruptcy appellate court got it wrong. So the U.S. Supreme Court says whether or not she knew or not is irrelevant. Whether or not she participated herself in the fraud or not is irrelevant. She's in a legal partnership. And so that means, guess what? You get to accumulate all that responsibility. So your partner did a fraud. I didn't know about the frauds. Well, too bad, so sad. Pay up. Where my money? Kate disputes the straightforward reading of the text. She argues that an ordinary English speaker would understand that money obtained by fraud means money obtained by individual debtors' fraud. This court disagrees. The passive voice does not hide the relevant actor in plain sight. It removes the actor altogether. So our reading of the law is money obtained by fraud. It's not your money. It's not your money. It is money obtained by fraud. It's not yours. Give it back. Congress framed the law to focus on an event that occurs without respect to a specific actor, and therefore without respect to any actor's intent or culpability. It's not your money. It's true that context can provide passive voice sentence to a likely set of actors, but the legal context relevant to law, the common law of fraud, has long understood that fraud liability is not limited to a wrongdoer. Understanding law to reflect agnosticism as to the identity of the wrongdoer is consistent with age-old fraud liability. Yeah, it's not your stuff. It's like possession of stolen property or something in the same respect, right? It's like, whether or not you are criminally responsible for possession of stolen property, like if you didn't know or had no reason to know, you might not be responsible in that sense, but it's not your stuff because it's stolen property. So give it back. Kind of the same idea. It's not your thing. You don't get to keep the thing. The thing was obtained fraudulently. You may be a completely innocent party, but it's not yours. The person who the fraud was committed again also, incidentally, is an innocent party in this situation. So, give it back. Kate over here points out that exceptions to discharge should be confined to those plainly expressed. The court, however, has never used this principle to artificially narrow ordinary meaning, invoking it instead to stress that exceptions should not extend beyond their stated terms. So if there is an exception, then they're understood by the way the exception is written. So, yeah. Kate also seeks for support from neighboring provisions, both of which require some culpability by the debtor themselves. Kate claims that these neighboring provisions make explicit what's unstated in that section. Yeah, we know how this works, by the way, right? We've discussed this before, right? If Congress writes something explicit in one section and then doesn't write it in a different section, well, Congress obviously knows how to include something and exclude something when they want to. Congress thought, for whatever reason, that someone's culpability in some other domain was relevant. That is a policy determination of Congress and their infinite wisdom, and certainly not for this court to do anything about. So Congress said, as to these people, their intent is relevant. Didn't say it for you, so sorry about that, but talk to Congress about it, lol. If there's an inference to be drawn here, the more likely one is that Section A excludes debtor culpability from consideration, given that B and C expressly hinge on it. Kate suggests that it would defy credulity to think that Congress would bar debtors from discharging liability for fraud they did not themselves personally commit, while letting debtors to discharge debt for potentially more serious fraudulent statements they did not personally make. But the court offered a possible answer for this disparity in a different case. Whatever the rationale, it does not defy credulity to think that Congress established different rules for A and B. So, it would be absurd, says Kate. The court disagrees. The court disagrees. Congress did a thing, and they did the thing, and that's what we're supposed to do. Any remaining doubt about textual analysis is eliminated by this court's precedent and Congress's response. In a different case, this court has held that fraud of one partner should be imputed to other partners who received and appropriated the fruits of the fraudulent conduct. You benefited from the fraud, right? That's the fruits. You got the frauds. You benefited from the frauds. You're not allowed to benefit from the frauds. Even if they're not your frauds, they're still frauds. The court so held despite the fact that the relevant 19th century discharge exception for fraud disallowed the discharge of debt created by fraud or embezzlement of a bankruptcy. And when Congress next overhauled the bankruptcy law, it deleted the phrase of the bankruptcy from discharge exception for fraud. The unmistakable implications that Congress embraced our prior ruling. So Congress did an amendment to the law in a way that tracks what we as the Supreme Court said, because Congress can overrule us on statutory matters, right? You can appeal a Supreme Court decision to Congress if it's statutory. Congress can overrule the Supreme Court if it's statutory. And they can also embrace the decision, and they apparently embraced it. So, well, we're certainly not going to change it. Congress embracing us Like, that codifies our decision. So we're not going to disrupt that. Congress literally codified it. It's code now, so there's that. Finally, Kate insists that preclusion Finally, Kate insists that preclusion of faultless debtors from discharging bankruptcy liabilities run up by their associates is inconsistent with bankruptcy's fresh start policy. But the bankruptcy code is not focused on unadulterated pursuit of a debtor's interest and instead seems to balance multiple, often competing interests. So yes, the bankruptcy code might want fresh start, but that fresh start does come at the expense of some people. And so the United States Constitution expressly allows the United States Congress to determine the rules for bankruptcy. It's in the Constitution, guys. I remember reading that provision about that. They can do that. They can discharge. They can determine the uniform rules for bankruptcy. It's right in the Constitution as a separate provision unto itself. So Congress can say, discharge of bankruptcy is kind of whatever they want to do, kind of really. It's because it's an express power of Congress. So they get to waive the things. Kate's fairness-based critique also missed the fact that another section does not define the scope of one's liability for another's fraud. The relevant law takes the debt as it finds it. So if California did not extend the liability to honest partners, they'd have no role. So if this debt didn't get extended under state law, then there'd be no debt. But it does. Because California said so, and Congress is cool with that choice. Congress can defer to state law if it wants to, or not, because Congress has the right under the Constitution to determine the uniform rules of bankruptcy. If the uniform rules of bankruptcy are go look at state law, then so be it. Congress can do that. And while Kate paints a picture of liability being posed on hapless bystanders, fraud liability generally requires a special relationship to a wrongdoer, and even then defenses to liability are available. Barrett issues an opinion if that's unanimous. So how about just give us the monies? Which incidentally is a lot more than $200,000 at this point, because there's been interest. So that's a lot of liabilities, because it was $200,000 of liabilities once in the long ago. But remember, they said they didn't have the money. So yeah. So where's my $1 million is probably more accurate at this point. So better have my money when I come to collect. So yeah. That's that. End of analysis. End of analysis. And, 3 decisions I agree with at the U.S. Supreme Court, which, is not exactly unheard of either. I disagree with the Supreme Court sometimes, but not on these occasions. These all seem correct. So, good times. To the 263 of you who stuck with me as we did a little Supreme Court review, thank you. And I will edit those up and release them later. So, get some content out of this. Let's see. Yeah. So, some good stuff happening at the U.S. Supreme Court. Students for Fair Admission might be coming up soon. They're issuing opinions from, they're starting to issue opinions now from October, November, December. Students for Fair Admission was October 31st. So we might get a decision pretty soon. in that case. That should make everyone really happy. There's going to be opinions issued on, let's see. There are no opinions currently scheduled on the calendar. So we'll see. The court's coming back late, isn't it? By the way, because it was supposed to be back at 2:15 and it is currently 2:20. So the court's late. Court's back in session. I don't know. Whenever they come back in session, I guess. Okay, what's this coming up on Vox? On Monday, the Supreme Court announced it will review a decision of the Fifth Circuit as to whether the Consumer Finance Protection Bureau is unconstitutional. Dealing with the funding. Yeah. The funding mechanism of the Consumer Finance Bureau is different. Vegas was fine. Vegas was fine. I really enjoyed meeting people. I pretty much spent the entire time of the event just meeting people and talking to people, and them buying me drinks, which was nice. I didn't have to buy I didn't have to buy a drink the whole evening because people kept buying me alcohol. Can I take a picture? Can I get a drink? Yes. Excellent. No. It was fun. It was great. It was just validation. It was 2 hours. It was like 2 and 3 hours of validation. It was just validation. It was just people telling me for like 3 hours that I'm great and they love my content and can I have a picture and I'm so happy to meet you and you're great and I love you and don't mind the haters. So, pretty nice. 3 hours of being told you're great. It's like, yes, I like this. I like this very much. I did not go to Hoover Dam, no. I didn't sleep well the night before the event, so I spent most of the day just resting and getting ready so I'd be, pretty good during the event. So the day before I went to the shops at Caesars, the Forum shops. Really cool. It's nice. It's an interesting indoor mall, like upscale. It's got the roof. It's got the roof. It's got a arch, no, like an arched roof that's painted like it's outside. So it's like a daytime sky and it's got lighting. It's interesting too, because the way my eye perceived it, I perceived all the shops as like being miniatures because the sky's in the wrong place. Right? If you go outside in the real world, right, the sky is like way up there somewhere. It's way up there, right? So the buildings When you're used to seeing buildings, when you're used to seeing shops, you're used to seeing them with the sky in a certain place. So it was interesting because for me, at least, and I don't know how other people perceived it, but like, because the sky is just above the buildings, right? So the sky is in the wrong place. And the way that my eye interpreted that is basically all the shops look like miniatures. It's off, or the scale doesn't look right. Miniature might imply like this tall, which is what I mean. The scale looks wrong. So the shops look too small, even though they're normal size. So that was kind of interesting. I enjoyed having my perception actively challenged by the sky being in the wrong place.
Is a worksheet showing steps and time steps were taken, along with some calculations about how many steps per minute. It's come to my attention that there's a math error contained in the previously submitted exhibit, and I think the error bled over into the defense's exhibit. I think it's 156. And so at this time, with the state's consent, the state would like to just simply substitute a worksheet with the correct math for the previous incorrect worksheet.
The defense would also ask you to do the same.
Okay.
The event in Las Vegas, Nick Rekieta basically had a meetup. It was just a meetup, basically. You've come to hate this judge on principle alone? It's kind of funny. I don't hate the judge. I just disagree with him a lot. And I think he's committing some legal error along the way. And if Murdaugh's convicted, I think there are some ripe grounds for appeal. I'd much rather him win now, to be honest, and laugh in the state's face. That'd be hilarious. At least the judge's calls are consistent, so you got that going for you. He lets in everything. So it doesn't seem to believe in limiting people. I also had overpriced pasta at the shops at the Forum. Went to this Italian restaurant there. Supposedly homemade spaghetti and meatball, which was acceptable at best. And it was, it's a small little plate of spaghetti with one kind of largish meatball, $24. I need more super chats to help pay for these incredible expensive meatballs.
So bring the jury.
So please super chat a poor uncivil law today. And the arms of angels. Uncivil law had $24 pasta. Away from here. It wasn't that good. Also, there wasn't very much of it. And the earth that you fear. Uncivil law needs to pay his debts. Angel. Solid relief. Thank you, Adam, for your $20. Mamma mia, that's a spicy meatball. Well, that almost pays for it. I'm just kidding. I'm just kidding, Adam. Thank you very much.
Jury is present, sir. All right, thank you. Your next witness.
Thank you, Your Honor. The state calls Dr. Kenny Kinsey.
Thank you, RGK. Oh, Lord. I'm sorry. Who are we calling Dr. Who now?
Do you swear the testimony that you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you. If you'll have a seat to adjust that microphone for me. If you'll state your name and spell your last name for the record.
Kenneth Lee Kinsey, Kinsey. Welcome back, Dr. Kinsey.
Welcome.
Feels like a year since you were here. You were qualified last week as an expert, correct?
Yes, sir, that is correct.
What I would like for you to do right now is just to remind the jury, give them a little bit of background on your education, your work history, your credentials that made you qualified to be an expert witness.
Yes, sir. I've got a degree from Clemson University.
Go Tigers, baby.
Degree, that's undergraduate. A master's degree from Troy University, a PhD from Walden University. I have formerly been certified by the International Association for Identification 2 different times for crime scene investigation and reconstruction. I've worked approximately 800 death scenes
Thank you,
in
Chris,
my
for the 10
career,
gift memberships.
and I've handled and processed countless evidence in crime scene and the crime scene related disciplines. I have completed and passed proficiency in those disciplines as recommended by the International Association for Identification, which includes oral exams, research, technical work, and also I worked under a qualified examiner for a determined amount of time. And I've been a police officer for approximately 30 years in various capacities.
And just to remind the jury, you were qualified as a forensic or crime scene forensics expert in this particular case.
Yes, sir, I was.
And real quick, what other types of qualifications as an expert do you possess?
I'm also a firearms instructor for handguns, shotguns. They call them patrol rifles, but that includes subguns, fully automatic and semi-automatic platforms. I have endorsements through the South Carolina Criminal Justice Academy. I'm also a SLED concealed weapons permit instructor, and I'm formerly a law enforcement firearms instructor through the NRA.
Now, you've had an opportunity to review the case file for this particular case, correct?
Yes, I have.
And you have actually been out to the crime scene, correct?
I have.
Beg the court's indulgence. I would like to show you what's been previously marked as State's Exhibit 526. Do you recognize this map?
Yes, sir, I do.
And what is it?
That's a satellite map from the Moselle property.
I would like to offer this into evidence. I assume no objection?
No objection. Submit it.
Dr. Kinsey, we're going to keep our testimony today narrowly focused and tailored to a few witnesses that the defense put up this past week. Did you have the opportunity to observe one witness named Michael Sutton, who was a forensic mechanical engineer for the defense?
I did.
Now, do you recall any of his conclusions or what his main conclusion was regarding the size of the shooter?
I do.
What was that conclusion?
5'2" to 5'4".
I would like now, Doug, if you would, I would like for you to publish or cut on Defense Exhibit 140. Go to page 49. Okay, now what I want to do is we're going to get into this in just a moment, but they published this into evidence last week. And do you recognize these green lines coming out?
Yes, sir, I do.
Okay. And what do those green lines represent?
Those green lines represent a predicted static angle or I don't know what you would call it, trajectory for possible shooters.
And Doug, if you would go to page 74 of this presentation, please. Do you recognize this photo on page 74 of the defense exhibit?
It was a shot.
I do.
And what is it?
It is Mr. Sutton pointing a pump-action shotgun into the feed room at Moselle.
Okay, and did Mr. Sutton develop his conclusions as to the height of the shooter based on math that he did in this particular case?
He said it was trigonometry, but yes, sir, he did.
Based on your many years of law enforcement experience, education, and training, what is your overall opinion on his conclusions?
I think his intentions are well, but I think his methods were flawed.
So what I want to do is I want to go back, and there were 3 previous angles that we just looked at in the previous slide, correct?
That is correct.
And then he also determined an angle here in this photo, correct?
That is correct.
And those are the angles that he used to determine the height of the shooter, correct?
That is correct. And Mr. Wilson, I don't know the totality of what he considered, but that was one of the elements, one of the criteria he used.
Okay, just to refresh the jury's recollection, Doug, if you go to page 4, it should be State 62. It's a picture. What is that a picture of?
That is a picture of what's been described as a quail pen.
Go to page 5, please. And what is that a picture of?
That is a close-up of that quail pen, and it has weathered cardboard on one end.
Okay, and that, for the record, is Exhibit 63 that is a picture of. And go to page 6, which should be State 64. And what is that a picture of?
That is a close-up of what appears to be a bullet defect or bullet damage in that cardboard.
Okay, now, they base their angles, of at least 2 angles. Well, let's back up. There were 2 angles taken from this particular one bullet hole. Why is that?
There were. I believe the original crime scene agent gave a possibility of 2 angles of the angle of impact in the cardboard.
Okay, and what are some things that someone can determine from examining a bullet hole in this cardboard?
Well, the first thing is direction. It lets you know that you had one or at least one projectile fired from that direction. It's a pretty good indicator for direction.
Okay, what's another thing that you can determine?
Sometimes you can determine the angle of impact and whether that bullet was affected before it struck that object. And what I mean is, was it deflected by flesh, or did it hit its target, or is there an internal problem with the weapon that would cause that bullet to be off-center?
Are you comfortable with the direction that was determined by Special Agent Worley in this particular photo?
I'm very confident of that direction.
Okay. The defense determined that there were 2 potential angles. How confident are you that the methodology used to determine those angles are accurate?
I have zero confidence from this piece of evidence as far as establishing angles.
So that's interesting. You feel good about the direction of the bullet going into the quail cage, but you have a concern about the angle, correct?
That is correct.
Do you have a concern about the angle?
The angle of impact, yes, sir, that is correct.
What are 2 things that could affect the angle of impact on a surface like this cardboard?
As I mentioned before, you could have, that bullet could have hit an object, which we don't know, or it could be an internal problem with the firearm that causes it. When you think about, if I could explain,
yes.
When you think about a quarterback throwing a football, they spin that football and it makes it stable in flight. Well, a projectile coming out of the muzzle of a firearm, a single projectile firearm, works the same way. You've got little lands and grooves in that barrel. And as that propellant pushes that projectile down the barrel, it twists. Now, there's different twists depending on the firearm, but that twist, called rifling most commonly, that's what my grandfather called it, but it makes that bullet stable in flight. Anything that can throw that projectile off of battery, whether it be striking something or a firearm problem, maybe fouling too much lead in the barrel, those kind of things will make that bullet off-center. Now, it still may go the general direction, but the rotation of that projectile could be off just a little bit when it strikes the target.
This
So a
sounds like
good
some
analogy
bullshit.
would be a lineman getting his hand on a football and making it go wobbly, but it keeps going, correct?
That would work, yes, sir.
This sounds like it's some absolute total bullshit.
Doug, could you zoom in on this hole real quick? Dr. Kinsey, I'd like to ask you to step down here, and for demonstrative purposes, I'd like you to demonstrate how an angle of impact can be affected in cardboard with a dowel.
Yes, sir.
Describe to the jury what you've done with this box.
What kind of fouling would you have to have to impact the bullet trajectory that much?
Cardboard.
What is going on in this firearm?
As a crime scene investigator, we use dowel rods to help determine direction and angle of impact. Now they can be as simple as a wooden dowel rod like you get at your hardware store, or they make some real complicated ones made out of fiberglass. If you can afford it, you know, most agencies and most crime scene teams will use a fiberglass rod, but the wooden rods, as long as they're pretty straight and true, they work just the same. So if this represents a projectile defect in cardboard, and may I say weathered cardboard, because this has been out there at least a year and a half since this incident took place, you place that dowel rod in that defect, and then you can get an approximate angle or angle of impact on it, but you can definitely get a more confident direction.
Could it possibly
if your shooter's over here and you shoot in this direction, or over here, or up
on
or
the
down?
barrel of a standard rifle?
But it's not the end-all, be-all, and I can explain that to you also.
Okay.
How much?
So could you
How
demonstrate
much
how?
could it possibly deviate?
Back up a second. And step away so the jurors can see
Especially
this photo,
given
if
the
you would.
amount of the distances we're talking
You saw
about.
the.
Like,
I might need you up here.
I mean, it's not like I'm doing a long-distance sniper shot. I'm trying to shoot a guy
You saw
a
the
mile
defense
away.
expert's testimony, Mr.
Where-
Sutton, I believe, last
How
week,
much
describing
fouling
this
do you
hole.
think is
Can you
possible
explain
in a
to them
barrel? Shit.
how he determined the angle of impact based on what he was observing in this bullet entry?
I can, Mr. Wilson.
Please do so for the jury.
What Mr. Sutton did with geometry and trigonometry and a whole lot of tools, but basically a protractor, as we use when I testified previously, if you had a confident bullet defect, you can run a string and then put a level or it's a type of protractor, it's a bullet angle finder on top of that rod, and you can get a general angle of impact in a fixed object.
Am I trying to
However,
shoot
this isn't
a
a
guy
fixed
at 1,000
He referred
yards?
to that little
Then
mark
yeah,
around
little
3 o'clock.
changes are
What did
going
he
to
call
make a
that?
pretty
I think
huge
he
difference
called it a
along
bullet
the way.
wash.
But like,
Could it be a bullet wipe?
Bullet wipe, yeah.
what the hell are you talking about?
Okay.
I'm familiar with it.
And what was he assuming that bullet wipe was caused by, based on the testimony you heard?
From the angle. He's assuming
The angle of what?
The angle of impact.
What else could cause that?
As we mentioned, striking the surface beforehand, fouling in the barrel, something internal. It just throws the bullet off course.
Striking
a little
the
bit. It's
firearm
not
would change
spinning
the
way
bullet
it
trajectory?
normally spins. So when it strikes, it doesn't strike. It doesn't enter the way it normally would. It wallers a little bit, like that football we talked about.
What about the dowel rod?
Well, the purpose of
sounds like some
inserting
bullshit.
the dowel rod is to try to get the best angle or the best direction you can. And in a perfect world, the angle would be fairly confident, like another bullet defect we're going to talk about. Remember, this is weathered cardboard. So once that examiner, and these rods are not caliber specific either, because a crime scene investigator or an examiner can't look at a bullet hole and guess what caliber it is. That's nonsense.
Yes, you can.
So you try to pick the one that fits the hole the best. And with some of the fancy
that's
kits,
what
you
she
get a little shim kit with some little rubber grommet that you can place in there, make it fit a little bit better. But more typically, you just pick the dowel rod that's closest to the hole.
Could a dowel rod affect the angle of impact?
Upon me inserting this dowel rod, I can do damage to that bullet defect, but more importantly, when I remove it, I could do damage. And it's very deceptive damage. It's not intentional, but it can damage the angle of impact, especially in a soft, unreliable object like cardboard.
You can return to the stand. Thank you.
Yes, sir. This all sounds like some real grade A bullshit.
Please, go ahead.
What I'm saying, once a crime scene investigator gets what they need, they get their photographs, their measurements, their direction. So now this dowel rod's here. And none of us know this unless you've got a video of the examiner taking that dowel rod out. So we don't know what direction he or she might have pulled that dowel rod out because she's got her measurements.
So,
she or he is not considering someone coming behind them and measuring again for something.
How's the state's evidence reliable?
In a piece of cardboard. And we're not talking about in wood or sheetrock, we're talking about cardboard. If you pull it to the right, you cause that same bullet wipe that we got in the photograph. Likewise, if I pull it to the left, now it looks like that projectile has entered from a left to right direction. And you can go on and up or down. That'll influence the appearance of that bullet defect because you've got
how is this not sabotaging
an object like cardboard, something
exactly?
that there's no confidence in.
Thank you. You can set that down.
So
do you recall what the defense expert testified to the direction and angle of that particular angle of impact?
I do.
And what was it?
I think 1 and 3 degrees.
But do you remember, like, was it left
Going
to right,
up.
right to left?
Going up.
And from what way to what way? What direction to what direction?
Left to right.
Are
Or
you
right
trying
to
to
left.
signal
Right.
to him?
Yes, sir. Right to left. I have to think about the quail pin in my head.
Are you confident that the direction was correct on this?
Yes, sir. I have no reason not to believe the direction. I mean, that would have to be a huge defect hole for it to throw the direction off.
How confident are you in the angle of this?
I have zero confidence in that angle.
Why?
Of the bullet entry.
Doug, if you could go to page 21, which I believe is State's Exhibit, a picture of State's Exhibit 38. Can you describe for the jury what that is right there?
Like the first defect, this is also a defect in a wooden, it's been described as a doghouse.
Now, you can also determine the angle of impact and the direction here, correct?
I can.
What degree of certainty do you have that they were right in the angle of impact and the direction in the doghouse?
I place a lot more confidence in this angle because that wood is fixed. It'll show a much truer projection of the angle of impact.
But
can you hold on one second. How is this particular, I think you just described it, but real quick, how is the doghouse different from the quail cage in determining the angle of impact?
Well, the doghouse, if you look at it, is at least a ½ inch to 3/4 thick. So, like I said, you've got a stable, dependable bullet defect. The cardboard is 2 pieces of brown paper with corrugated paper in between to cause, for strength purposes. But as I mentioned, not only is the cardboard, in my opinion, not a good substance to shoot into, it's also weathered, so that makes it even weaker.
Doug, can you go to page 42 on this exhibit? All right, can you, it doesn't have an exhibit number at the top, but this is page 42 on Defense Exhibit 40. Can you describe what this photo is?
Yes, sir. That is a computer animated drawing of some potential trajectories into that quail pen.
And the 2 gray boys here, what are they?
They are, they're 2 figures that were placed in that CAD presentation to represent shooters.
Go to 46 of the same exhibit and describe what this is.
This is one animated suspect, I guess, or shooter placed in a similar CAD drawing, photograph, animation.
Okay, now go to page 49. And what what is, sorry, go back, that's the picture I wanted. So there's 3 angles represented in this picture, correct?
There are 3 angles.
2 of them are from the same hole, correct?
Yes, sir.
One of them is from the doghouse, correct?
That is correct.
You believe that the doghouse angle is fairly reliable?
I do.
You question the quail house angle, correct?
I place no confidence in that angle from the quail pen.
Explain for the jury, and you observed the defense expert last week talking about this, how did they come to determine, based on these lines and where these gray figures are placed, how did they come to determine their heights were between 5'2" and 5'4"? We'll get to your opinions about that in a moment, but just explain for them how the defense expert got to that decision.
The defense expert said he tried plugging in different heights, and he had to place those animated figures on a plane, that line, that laser line, and he determined that they go back and forth on that plane to achieve the defects that are documented by the original crime scene examiner.
Doug, go to page 51 real quick. Let's see if that's the... So, there's some yellow placards here on the ground. You see them?
I do.
And what do those yellow placards represent?
Cartridge cases that were found on the ground. They're markers, so once you find the cartridge cases, you put them there for documentation purposes, photography, and sketching purposes.
And why? Explain to the jury what the defense has determined that their angle is based on those static lines, those green lines, correct?
That is correct. Back and forth on that one static line for one angle and one static line for the other angle.
And they placed them right there at that particular location. Why?
I think the defense expert was taking into consideration the location of the cartridge cases, and he was showing how it would fit those 5'2" animated figures that he placed in that presentation.
Is it your understanding, and I'll demonstrate, the gray figures are holding the firearm, and those gray lines represent like a string. They would run up and down, correct?
Yes, sir. That was the testimony. You go back and forth on this green line.
Okay. And that they would be right here because this is where the shell casings are. The shell casings are ejecting, correct?
That is how I understood his...
What?
Restate the question.
I'll restate the question. Why would they be placed right there in that particular location along that static green line?
Because they were in proximity to some of the shell casings.
Okay. Can you explain for this jury why their assumptions on the math they did are incorrect in determining that the shooter had to be between 5'2" and 5'4"?
Well, there's a bunch of variables. Variables do matter. There are a bunch that you would have to consider. First, you'd have to consider this to be a static crime scene. Very little movement, and when it is movement, it's controlled movement. Second, you would have to place some confidence in that angle of impact on that cardboard. Third, as I testified in my previous testimony, we're not able to test fire or with confidence what we know to be the weapon used in this situation with the same ammo. And they don't throw the ammo the same place every time. It may be in the general vicinity, but as I said, I believe in my previous testimony, if you knew exactly where it was going to throw that cartridge case, you could carry a bucket with you and sit that bucket and all your cartridge cases would go in the bucket. But like we see in the sketch and in the animated drawing, those cartridge cases are throughout. They're in a pretty large little area. And what I also saw that I noticed from this CAD drawing is there's cartridge cases to the left of these animated shooters, which means that sometime at least 2 of these shots were fired with the shooter far to the left and not on this static green line.
Could you come down here real quick and point out what you're talking about as it relates to the location of the shell casing?
Yes, sir.
I'm not sure if this is a shell casing here, Mr. Wilson, but right here, that is a shell casing, and it would not eject this direction in any situation depicted here in the presentation. It's not a left-handed, nobody's ever testified it was a left-handed AR-15, and like I said, they're kind of uncommon, and if it is, and that's a left-handed, then we couldn't explain the majority of them being to the right. So that's what makes this static line flawed.
Thank you.
And in another photograph, you can actually see a larger area of cartridge cases back here.
Thank you. Let's assume for a minute that the angles are correct. And they very well could be, correct?
They could be.
Why is the defense's theory as to the height of the shooter represented in this picture still wrong? What else could affect it?
Distance and height.
Would you like to take a moment to demonstrate for the jury what you're talking about?
Weapon position. Yes, sir. Will you tell me which angle you'd like me to demonstrate first?
Let me ask you this question before you step down. Can a person be on their knee and get the same angle and be standing and get the same angle?
Yes, sir.
Can a 6'4" person and a 5'4" person still shoot the same angle, just at different distances?
Absolutely.
Can you demonstrate for the jury why that is one way that this could have changed their math?
I can.
Please.
I measured this depth on the witness box during the break. It's 8 inches. I used to be 5'11", but as I get older, I'm about 5'10". But if I'm here, or I could be 5'8", or 5'2", or 5'4". Here I'm 5'10". Here I'm 6'6", and here I'm even over 7 foot, and I've still got the same angle. I have just added a little bit of distance to it. And as far as the quail pin angle, I'm 21 inches from the floor to my knee. I measured it. I believe it was testified that the defendant is 25 inches between the floor and his knee. So there's 4.5 to 5 inches difference in our heights. Here, I'm probably at 4'10" if I'm shouldering this weapon. And I don't know the mechanics or how it got this way. I'm just saying it's possible. Here, I'm at 39, 38 and some change. Or I can even take it lower or higher. And please don't ask me to demonstrate that twice, because I don't think my knees can do it again.
I think I heard him crack.
Yeah. But that takes me to 36 inches, 37 inches. With the defendant, it would be about 39. So it's definitely possible. Even from a shouldered weapon, it's possible. And we do not know how the weapon was being held.
From what you've observed in this crime scene, was Maggie moving at the time she was shot?
This was a very dynamic crime scene. I believe everything was moving. The victims and the suspect were moving.
And how do you know that?
Well, suspect would be the different firearms evidence, the cartridge cases. Like I said, there's no absolute. They're not going to throw them the exact same spot, but they will throw them in a similar direction. We've got cartridge cases in a pretty nice sized perimeter. We've got them at different locations from where Miss Maggie Murdaugh's body, the final resting place, and different angles and different positions in different directions. So that tells you it's very fluid and it's very dynamic.
So if I'm holding a gun and I'm moving and shooting, what is happening with those shell cases as I move?
They are moving as they're ejected.
Where was Maggie's head pointing when she hit the ground?
Miss Maggie Murdaugh's head was pointed in the direction of Paul Murdaugh, where his body rested, back toward the feed room.
What is your opinion of the defense's expert that says the shooter could not have been 6 feet 4 inches tall like the defendant, Alex Murdaugh?
I think that's a flawed opinion.
Could it have been a 6'4" person?
It could have been a 5'4", 6'4", or in my opinion, a 7'4", as I just demonstrated.
Doug, let's go to page 59 in the Defense Exhibit 140. That should reflect State's Exhibit 57. Dr. Kinsey, can you describe that picture for the jury?
Yes, sir, I can. That is a shot from inside the feed room, that back window pane where the buckshot exited Paul's left arm and then continued and exited the feed room.
Please go to page 67. Should be State's 45, I believe. And what is that right there?
That's a pink string from the window to a pine tree.
And then go to page 69. And what is that a picture of?
I don't know if it's the same pink string, but it's also a pink string coming out of a window.
Okay. And go to page 74. And that is labeled Exhibit 54. And what is that a picture of?
That's a picture of Mr. Sutton with what looks like a pump-action shotgun pointed down into the feed room.
And what do you notice about the angle that he's holding the shotgun and the angle of the string?
Well, the string is parallel.
Let me correct you. I'm sorry. Let me rephrase that. What is the defense's theory right here, represented in this picture?
I've heard so many theories, but I really believe Mr. Sutton was trying to show that the angle wouldn't match if it was a taller shooter shooting into the feed room.
Okay. Doug, I'm not quite sure what page it is, but I think it's 2 back. Go back one more. There you go. That's it's labeled Exhibit 53, and what is that a picture of?
That's a picture of Mr. Sutton holding, I believe, the same shotgun, more parallel to the floor.
And what is he trying to demonstrate in this photo?
I believe he's trying to follow that pink string to that pine tree, or whatever got him to that pine tree.
Do you recall from his testimony how he got that angle?
I do, sir. I do. Mr. Sutton testified that he got to where he believes Paul was standing, and he got down and he peeped through the hole in the window, the one that he thought would match that corresponding defect in that pine tree, and he ran a string to that defect in that pine tree.
Are they trying to determine the angle of the shot is exactly the way the shotgun's being pointed?
Well, I believe they were trying to determine trajectory path of that projectile.
What is flawed about this?
Guys, with a rifle, you're talking about a single projectile, and most people understand the distinction. If you can find where it was fired and you can get a perfect impact, sometimes that'll give you an idea of the path of that projectile. With a shot shell, you're talking about 9, 12, or 16, in this case 9 buckshot pellets. They're packed in a shot shell with filler, it's like a styrofoam material. They're packed in a shot shell. When that cartridge, the primer of that cartridge is ignited and those pellets exit the muzzle of that firearm, they start to spread. We've heard a lot of testimony about that. They start to spread, and they spread in a cone. Okay, you got some at the top, some bottom, some left, and some right. And the more the distance becomes, the greater they spread. They're not like a mother duck with the ducklings right behind it and all the buckshot are in line. So you can't get a true trajectory on this shotgun. You can't even measure a true pattern, not even close to a pattern, with one pellet. So it's my opinion that that pellet that definitely impacted that pine tree, that's the top of the cone. So you've still got a bottom and you've got two sides of that cone, and unfortunately none of those pellets were located.
So, in your professional opinion, can you exclude a 6'4" defendant like Alex Murdaugh, or anyone for that matter at that height, from shooting that shotgun at that angle?
Absolutely not.
When the defense expert says that the shooter has to be between 5'2" and 5'4", do you disagree with that?
I do disagree with that wholeheartedly.
With what degree of certainty do you think they're wrong in their conclusions?
I just think it's an unknown. I mean, there's many more variables you have to know. How the shooter was holding the gun. How his proportion to legs matches up with body. I mean, that's something that we're all a little bit different. And unless you've got a video of that or someone tells you how they held a weapon, I think the notion that being able to look at this evidence and determine that is unscientific.
You said something a minute ago. You said there's so much we can't know. Could the shooter have been running laterally?
Certainly he could have.
Could the shooter have been
You mean there's a lot you
toward
don't know?
Maggie?
You don't know a lot
Certainly.
of things?
Maggie was certainly
You have
moving.
doubts?
Correct?
In my opinion, she
You have
was.
doubts about the things you know?
Could the shooter have been on their
You say those
knees?
doubts are based on a reason?
Could have been.
But there's no way to know for sure, correct?
That's an unknown.
No way to
Yes,
know
sir.
for sure. So
And
you say you
because
have
there's
doubts?
so many unknowns, there is no way the
Have doubts
defense
about-
expert
doubts about the
can
angle?
definitively
See those
exclude a
reasons?
6'4" person from shooting the rifle and the shotgun, correct?
The defense.
Cannot be the witness.
In your opinion, can the defense, based on what you just testified to, exclude a 6'4" person from being the shooter, and with either weapon?
In my opinion, no. The defense witness is relying on math and absolute. And in crime scene investigation, sometimes there are no absolutes.
Sometimes there are no absolutes. That's very insightful.
Dr. Kinsey, have you ever observed a contact wound to the head by a shotgun?
Yes, sir, I have.
How many times have you observed a contact wound to the head by a shotgun?
After the fact, I've seen several dozen, maybe 3 dozen. But I also had a gentleman that committed suicide in front of me, probably from me to you.
How many times have you actually seen either photos of a contact wound to the back of the head with a shotgun in your professional career?
Probably a dozen. Out of that 3 dozen, probably 24 of them were suicides or someone taking their own life. Probably a dozen execution killings.
Can you describe for the jury what kind of trauma a face, and I know they've heard from a pathologist, but in your experience as an expert in crime scene forensics, can you describe the kind of trauma you have observed in your career with contact wounds to the back of the head or any part of the head?
Yes, sir, I have.
And specifically to the face?
Generally speaking, whether it be a shotgun or a large caliber handgun, the result is similar. You feel as though the forehead and the facial features have went away, and that's a kind way to put it. They're actually there, but they've been shredded, and the pathologist can actually put those features back in place, or the majority of it. But looking at it, it looks like from the teeth up, the person went away. It's just a mess.
Dr. Kinsey, I would like to show you what's been marked as State's Exhibit 486. Can you look at that and say if you've seen that picture before?
Is this witness number 6 now? Are we close to the end? I'm really ready for this trial to be over right now. I'm telling you what,
And what's
guys.
the picture of?
It's a picture of Paul Murdaugh at autopsy.
And what part of Paul Murdaugh is
I'm going to go out tonight and get some Olive Garden.
His face and his forehead.
Get myself some pasta Italiano and some breadsticks. Lol.
Does his face look like it suffered the kind of trauma you have observed in the past from a contact gunshot wound to the back of the head or any part of the head?
No, sir. Other than some red features from, falling on the cement after the fatal shot and some blotching to his skin, his face looks fairly normal to have gone through what he
They
suffered.
said 1, maybe 2, right?
And I'm not going to publish the photo again because I think people are tired of seeing it. But
We
I
are
do
tired
need you to
of seeing,
describe
and I'm tired of
what kind of things you've observed with the eyes.
I want you
and
to
the
stop
bones,
talking. Like,
with
please,
people that
forever.
you've seen that have been struck or shot in the back of the head at point blank.
Some people feel that way
Yes,
about
sir.
me.
Well, it's not always the back.
But if you
now.
feel
I've seen some
differently,
from the
make sure to hit
side
that
also.
subscribe button.
Yes, sir. Generally, like I said, it looks like the facial features have gone away, or they've at least changed drastically. A lot of times you will get large blood pockets or contusions under the eyes if the eyes don't pop out. A lot of times the eyes will pop out and they'll be on what's left of the cheeks. The facial bones, you can grab them with a gloved hand and you can move them around. And you will actually have pellet exits in the skin flap. If you pull the skin up, you can see where the pellets, whether they be buckshot or close distance birdshot, you can see the actual defects from those pellets.
Based on your training and your many years of law enforcement experience,
We're at 123,400 and change, by the way. So I need
contact shot to
could
the
use
back.
1,600 more subs. Get that 125,000.
Absolutely not, in my opinion.
Tell 1,600 of your friends to hit the subscribe button.
Okay, Dr. Kinsey, we'll move on from that for just a second. You were here yesterday, correct?
I was.
Did you have the opportunity to observe, I want to say his name correctly, I believe it was Tim Pombach?
I did.
He was a crime scene investigator who was qualified as an expert for the defense. Isn't that right?
Yes, sir.
Okay. I would, he came up with two significant conclusions, you could say three, about how Paul was shot at the feed room. Do you remember what those were for this jury?
The big one that I recall is that Paul was shot in the back of the head with a contact wound. And the other one, the strikes in my mind, I don't know, the shooter passed him and shot him from inside the feed room. Those are the two big ones that I recall.
There was another one regarding the number of people there. Was there?
The thing about two shooters, yes, sir.
Okay. We'll get to that in a minute. I would like to... Doug, can you get the Elmo up? I'm showing you what's been marked as Defense Exhibit 182. What's that a picture of?
That's a picture of that expert with his hands cupped opposite the hinges on the door frame.
Okay. I want to leave this picture up for a moment because what is the direction that the picture was taken from?
From inside the feed room.
Facing what direction?
Outside the feed room.
Okay. Now, you had an opportunity to hear the defense's theory on how Paul was shot, correct?
Yes, sir, I did.
I would like to demonstrate that with you right now.
Yes, sir.
Can you walk us through the defense's theory as you understood it to be?
Yes, sir, I can.
Your Honor, for purposes of this demonstration, I don't know if the court would allow it, but it'd be nice if we could open this door. I want to make sure that there's security here, but if we could have that door open just for a minute or two. Thank you, Your Honor.
If you have him demonstrate this with an actual gun, I'm going to lose my fucking mind.
I'm grabbing what Smart States Exhibit 4, which is a camo, Benelli, Super Black Eagle 3 shotgun 12 gauge.
God.
We'll use this for the demonstration, so step down.
We are not doing this, are we? Dude. No. Dude. Dude, no. Dude, no.
Now, is this door the same width as the feed room door?
It's a couple inches wider than the feed room door.
And of course, the feed room door doesn't have this, this inset,
Holy
correct?
shit.
That is correct.
So this is not exactly a replication of what happened at the feed room door, correct?
No, sir, it's not. The door swings the same direction, though.
Now, you have given me permission. I'm very careful about muzzle velocity. Muzzle awareness. But you've given me permission to point this at you, correct?
I have.
Okay. You actually asked me to, correct?
Yes, sir, I did.
All right. So go in there and stand a couple of feet back. It doesn't have to be 5 feet. But you have since testified that Paul was 5 feet inside the feed room, correct?
Can we demonstrate the first shot out here?
I am.
I believe they
Wait, stand back a little bit because you got to stumble toward me.
Yes, sir.
So I'm going to point like I'm pointing at you.
Yes, sir.
Paul is shot Where's the shooter approximately outside the door?
The breech face or the ejection port of the shotgun is just past the door frame.
Okay, Paul has just been shot.
Yes, sir.
And in the defense's theory, you tell me what to do, and you act this out, and I'm going to do what you tell me to do based on the defense's theory of the case.
The defense agreed with the assessment that Paul stood there for a moment, bleeding down his injured left arm, and he slowly walked toward the door.
Okay, and what does the shooter do?
The shooter's coming in the door.
And then what does the shooter do?
He shoots Paul in the back of the head after he passes him.
Oh my
God! And then shoots Paul in the back of the head like this. And where does the blood spatter go?
The blood spatter, the pellet defects, and one that I didn't know about that the expert collected was in the door frame at the top of the door.
Now I understand this is a little different than the feed room door. That's the best we can do. So what did you find odd about the theory, first of all?
I think the theory is preposterous, in my opinion.
Can you walk me through why you think it's preposterous?
Absolutely. Number one, that dry lock number 2 shot shell fires a projectile at 1,450 feet per second once it leaves the muzzle of that weapon. As was mentioned, that's a millisecond. That's fast. To think that the pressure from flesh and bone will cause that pellet, those steel pellets now, we're not talking about lead. Lead's a little bit more giving. Lead is malleable. It will crush or flatten. We're talking about steel, BB pellets. They will turn around because of the pressure, go back the opposite direction, 180-degree direction at enough velocity to dent a steel exterior door and embed in the door frame. That doesn't happen. That doesn't happen, in my opinion.
I don't know if you mentioned this earlier, but can you talk about, make sure I get it right.
And can I add?
Please do.
Also, there's no defects to the OSB or the T111 siding in the bottom of the room.
All right, wait a second. You said a lot right there.
Yes, sir.
TS what?
TS111. It's like a exterior paneling that people put on their buildings. That's what's on the building.
For all us city boys, we appreciate you describing that. Thank you.
Yes, sir. It's a whole other paneling. There's no defects at the bottom, and if that theory is correct, if this is an entrance and this is an exit, the shot still had to go somewhere. There's no defects down there on anything. The door frame, as I mentioned in my previous testimony, the door frame has a clean void. That would be perfectly in line with those shot from that shot shell. There's no cracks, chips, pellet holes in the cement.
So if you really want to see
there's nothing in the OSB. That's cheap plywood. That's man-made plywood. There's no defects in the plywood. There's no high-velocity blood spatter on the floor. What was pointed out to you is medium velocity, and that's from coming out of the wound and gravity bringing it down to the floor. You would see a pattern on the floor just like what you can see in the photographs at the top of that door. None of that's there. So I have to look at the science, and I have to look at inertia, and I have to look at that shot shell and how fast that shell is propelled out of that barrel, and I know that it can't turn around 180 degrees and go back the other direction. It's not like blood and tissue. We're talking about steel pellets.
Dr. Kinsey, are there studies on percentages of blowback when you're shooting into someone?
There are.
And based on your expert opinion, what percentage of blowback would come back at a shooter if they were able to shoot at that angle?
Well, I don't think there's any definite, but what I read is 8 to 10%, except in, like I said, it's not an absolute every time, but 8 to 10%. Remember, the most of your force is going out the front of the barrel.
And a moment ago, you were just talking about the defects and all of the trauma that would have happened to the paneling and the floor. Can you point on this photo with the dowel stick behind you for the jury? I just want them to see in this photo.
Right here.
The void, as I documented in my original testimony, the void was from here down, other than one stray satellite drop of blood. That was fairly clean. From here to at least right here. But there's no defects here. There's no defects in that cement outside. There's no defects in the inside cement and none in this OSB right here. And that was still there when I did the tour. They ripped out all the shelving and some of the insulation, but this was still there.
Dr. Kinsey, you may have covered this a little bit, but explain for the jury, if someone is shooting down, as we just demonstrated a moment ago here in the doorway, you're leaning out, the shooter is shooting down, how do pellets get embedded into the door frame up here? How is that possible?
I think it's impossible myself. Physics don't work that way unless you're shooting into a trampoline or a huge piece of steel, and then you may have a pellet deflected back on you. It happens many times, especially when we're shooting steel targets, but not at that velocity. It will not sink into the door frame, and it definitely will not dent that door with what I documented, in my opinion.
What is the restate for this jury what the defense's theory based on that blowback that would have exploded into the shooter's face here behind Paul? Explain for this jury what the defense's theory is about how that shooter would have been injured.
The defense expert testified that that shooter would be most probably incapacitated from blood, bone, and body fluid, and there was a high likelihood that he was injured by those pellets.
Dr. Kinsey, in your expert opinion, is there anything awkward about a shooter standing outside going into an enclosed area to turn around to shoot someone from enclosed? Is there something weird about that to you?
I can't figure out the methodology of a shooter. I've never done any crime like that, Mr. Wilson, but I don't see, if we talk about common sense and everybody's mentioned the totality when they don't have an answer for something, it's always, I looked at the totality, but I don't see any reason for someone to squeeze up past one victim in this doorway to go inside to shoot him back out. And if he did, if that scenario did happen, that doesn't explain all the pellets that are in the floor of the feed room that we've heard testimony to as to why law enforcement didn't clean those pellets up. If it happened the way the defense expert says those pellets would be out here in the yard, they would not be inside that feed room.
Dr. Kinsey, you have a chance to review the case file on this particular case and observe the defense testimony from last week?
It's two separate things. Yes, sir, I have reviewed our case file. All crime scene or what I felt was crime scene related evidence. I didn't look into the videos and a lot of that other stuff. And I have witnessed the testimony of the defense experts.
Are you familiar with what the investigation has determined about the tool marks found on the 300 blackout shells found around Maggie's body and the tool marks found on the weathered 300 blackout shells found way up by the house in the flower bed? Are you familiar with that?
I am familiar.
And what do you know about that?
The examination.
Scope of our case, it's going into completely new information. Their ballistic experts already testified. We didn't present a ballistic expert, and now they're parading him as a ballistic expert.
Response.
Your Honor, their expert said yesterday, about an hour and 9 minutes into their testimony, that it would be impractical for one shooter to bring in two long guns. It has always been the state's theory that the shooter owned both guns and had them on him. So we're rebutting what the defense expert said.
The objection overruled.
Please answer the question.
Can you ask me again, Mr. Wilson, please?
Are you familiar with what the investigation has determined about the 300 blackout shells found around Maggie's body and the 300 blackout shells found up by the flower bed that were appeared to be several months old and weathered? What relationship do the shells have to each other?
According to the firearms examination, those cartridge casings were loaded and ejected from the same weapon.
So a family-owned weapon is what was used to kill Maggie.
Leading.
What do you infer from that information?
I would infer that this is a family-owned firearm.
There was some testimony yesterday, Dr. Kinsey, about, well, it was from the defendant's brother, Mr. John Marvin Murdaugh. And it related to the following day, he came upon the crime scene. It had been cleared, and he saw how the crime scene was left. Can you explain, you've been in law enforcement for how many years?
30 years. Well, over 30, but 30 years getting paid.
And you're the chief deputy at a sheriff's department?
Yes, sir, Orangeburg County Sheriff's Office.
Just to clarify some things, can you explain normally or traditionally how crime scenes are cleaned up for this jury? Is it the responsibility of law enforcement, in other words?
No, sir. There are private companies that are contracted through SOVA. Well, it used to be SOVA. The name's changed now, and I'm sorry.
What does SOVA stand for?
It's Victims...
State?
It's a State Office of Victims Assistance, but it's now changed. I can't tell you what the new acronym is, but it works through our victims advocates, law enforcement victims advocates. Almost every department has them, and there's funding provided from taxpayer funds to work through your victims advocates, and you go out and you clean these crime scenes for the families so they don't bear the burden of cleaning those crime scenes. Law enforcement in particular cannot collect and dispose of and transport body parts or body fluids. That's something the coroner has to do because it's actually by permit through DHEC. But to make it easy on the family, these companies can collect those items and then they will turn them over with a chain of custody, or they will properly dispose of those items.
Dr. Kinsey, is it your expert opinion that a 6'4" shooter cannot be excluded from the murder of Maggie and Paul?
I see nothing that could exclude a 6'4" shooter.
In your expert opinion, can you tell this jury, is it right for the defense to say that there had to be two shooters based on the testimony you heard yesterday? In your expert opinion, can you exclude two shooters?
I cannot include or exclude two shooters.
Can the defense include, to the exclusion of all other possibilities, two shooters?
Absolutely not.
Beg your court's indulgence. Please answer any questions the defense has for you.
Mr. Griffin.
Thank you, Your Honor.
Good afternoon, Dr. Kinsey.
Hey, Mr. Griffin.
And anyone who has a doctorate degree, I want to call doctor. It's all right if I call you doctor?
I'll answer to anything you call me, Mr.
I
Griffin.
understand.
I appreciate that.
Now, your degree, though, is in criminal justice. Is that correct?
That is correct, yes, sir.
You're not a doctor of pathology?
Absolutely not.
And you have no medical training?
I have training in pathology of gunshot wounds, yes, sir. I've attended several courses, classes, and seminars. It was also included in the criteria for the certifications I mentioned for the International Association for Identification. I've also conducted extensive research on police officer use of force cases and the injuries that result from therein.
Your doctorate is in criminal justice, and I believe your
Thank you, Ron, for the
dissertation
super chat.
research is in use of force and perceptions of public attitude held by police trainers?
That is correct.
What was that?
Well, with the current atmosphere or what's been going on the last 5 or 6 years in our country, I was just trying to help. I wanted to figure out something that would assist with, because we've seen some law enforcement officers do some terrible things on video. We've also, we've got a segment of our society, the minority segment of our population. A lot of those citizens are in fear of law enforcement, and I wanted to study if the media perception as held by the three types of law enforcement trainers, if the media perception and the way they portray law enforcement, if that affected the way we train our officers, if we're too hypervigilant, or if we tell them, look, there's death waiting for you around every corner. Is that going to make law enforcement more prone to use force or use less force, or those kind of criteria? And that's what I was interested in. I was laying the groundwork with a scientific quantitative study to allow someone to come behind me and do some further research just to expand that topic.
Right. But you've said you also have done some gunshot wound training as part of some certification?
Yes, sir. The IAI, as I mentioned, I was formally certified 2 different times. I think it's a 5-year certification. And I did let it lapse in 2015 because that's when I started my PhD and I couldn't study for both. But that is an extensive process where you do research and you have to do a written test, and then with my proficiencies throughout SLED, and then I still do some with our sheriff's office now where you have to pass proficiency, and that is practical examinations, testing, and that kind of thing.
Okay. Now, in this case, that the state did have a pathologist, Dr. Reamer, correct?
Yes, sir, they did.
And you reviewed her autopsy report as part of your work, correct?
Not so much as reviewed her report, but I went and spoke with her in Charleston at her office.
Well, did you review her report?
I have access to her report, Mr. Griffin. I can't tell you I looked through the whole report.
And you understood that her opinion was it was a shoulder shot through the neck and then up out of the top of the head. Is that correct?
Yes, sir. I believe we agreed on that. Yes, sir.
And your reconstruction opinion is that's the exact same angle that Paul was shot by the shooter. Shoulder, neck, out the top of the head.
Yes, sir, but I didn't just rely on her information. I also looked at the crime scene photographs, and I went to the scene myself.
I understand.
Yes, sir.
But, and then did you hear Dr. Eisenstadt, his testimony?
I did.
Now, you worked with SLED, did you not?
I did, yes, sir.
Dr. Eisenstadt worked for GBI, correct?
Yes, sir.
SLED does not have its own in-house division of medical examiners, do they?
No, sir. There are several fine medical examiners throughout the state. I've done autopsies in a lot of the bigger cities in South Carolina.
Dr. Eisenstadt worked, and he was the chief medical examiner toward the end at GBI, correct?
That's what he testified to. I don't know that doctor.
You didn't know of him before this case?
I did not, no, sir.
Okay. Now, he says, his opinion is, it was a gunshot wound, contact to the back of the head. Is that correct?
That is what he testified to, yes, sir.
And if he is correct, then your opinion is incorrect. Is that right?
I don't share the same opinion as that doctor. But yes, if he would be correct, that would make me incorrect.
Okay. Now, in your training, are you familiar with Mr. DeMayo's book on gunshot wounds?
I have read DeMayo. I've heard it described as the Bible. I don't consider, no do my cohorts consider that as the gunshot Bible. There's 4 or 5 different versions out. There's one called Terminal Ballistics by Dobb, and there's also one Gunshot Wounds by Doherty, and those are the ones that I'm more familiar with. But I'm not saying it's a bad textbook, and I'm not saying that the information in it's not correct.
Okay. Now, and we'll get to more of that in a moment. What I'd like to do is first address Mr. Sutton's work that you had criticisms of.
Well, I didn't have criticisms. We just have different opinions. He's an engineer, and I'm a crime scene investigator, okay. Mr. Griffin.
Well, I just seems like you said that the angles of the to the quill pen were unreliable.
Absolutely.
Okay. And
I have several more criteria that I didn't mention earlier, but I mean, if you want me to go into those, I will.
Well, I want to ask you first, what's your understanding as to how those measurements were taken? Who took those measurements in the quill pen?
The original angles were the original SLED crime scene agent that responded to the scene,
right,
and took those angles.
And you understand that Mr. Sutton relied upon Agent Worley's measurements?
I do.
Okay.
I do.
Now you were putting a dowel, shoving it in a box and taking it out of a box as if Mr. Sutton went back and tried to remeasure it.
No, sir, that's not what I was insinuating. I said when the original agent removed her dowel, it wasn't nefarious, but depending on how she removed that dowel, she could have altered that impact.
Well, let's take a look at that, Doug. And this is Defendant's Exhibit 140. And can you pull that up? The one you were showing with the state. Excuse me. Just go to the second slide to start with. There you go. So you understood from this exhibit that Mr. Sutton relied solely on the shot trajectories measured by Agent Worley.
As I said, it wasn't his intentions, Mr. Griffin. It was his results that I disagree with. It's not absolute. And he gave, in my opinion, an absolute opinion to this.
Well, why would Special Agent Worley take measurements if someone should not rely upon them?
I can't answer that. You'd have to ask Special Agent Worley. But in my opinion, the direction, even though she can't obtain a perfect angle of impact, or even if that weathered cardboard was damaged, it's not a good substance to depend on because it's just not hardy enough. And she was showing direction. I'm not saying the direction's wrong. I'm just saying I wouldn't put confidence reviewing this case or work in this case. I would not put confidence in anything that angle of impact tells me because it's cardboard.
All right. So if you can go to slide number 7, I believe I've numbered them correctly. And do you recognize that as being one of her measurements?
I do. Yes, sir.
And do you think she took the dowel out and then put it back in to put this measuring device?
No, Mr. Griffin, I didn't say the angle. I said the angle of impact when he was talking about the bullet wipe and that part. That's what I was referring to, and that's what I'm saying. That hole can be altered when you remove those dowel rods. That shows direction, but that direction, I don't place a lot of confidence in it because we have more cartridge casings and we have injuries on Miss Maggie Murdaugh. We don't know if this bullet struck Miss Maggie Murdaugh. If it struck anyone else, we don't know that the defect in that doghouse struck Miss Maggie Murdaugh. Those are unknowns that we don't know. So all this proves to me is that the shooter was moving and more than likely Miss Maggie Murdaugh was moving.
All right. Hang on. So, Doug, if you'll back up one to number 6. So, are you suggesting that this photograph, number 6, taken by SLED, Agent Worley, that was taken after the dowel was removed or before a dowel was put in there?
Mr. Griffin, I don't know. That's what I'm telling you. I don't know how it was altered when she removed the dowel. I wouldn't place confidence in this before inserting the dowel because it's paper. It's not something hardy.
Well, would your opinions be different if you knew she took the picture first before inserting the dowel?
It would still be irrelevant except for direction because we know we had a moving shooter, we know we had a moving victim, and we can't prove one way or the other whether the projectile that caused this defect struck Miss Maggie Murdaugh.
All right. So if you'll go to slide 8. Again, this is Agent Worley's measurements of a dowel in the hole. Is that correct?
Same picture. Yes, sir.
Well, let's go to number 9. It's a little closer. And is this measuring up and down or left and right? Horizontal or vertical?
That is up and down.
Okay.
And I wasn't going to mention this, but the actual protractor or level finder is backwards. It would be a much more confident angle if the flat edge was up against the substance, but I wasn't going to bring that out.
And SLED did this, not...
SLED did that, yes, sir. But I don't know what her intentions were. Like I said, she could have just been trying to show direction. I don't know that, Mr. Griffin.
Well, this is direction, but it's up and down direction, right?
Yes, sir. It's showing angle of impact also.
Right. And if you had confidence in the angle of impact, you could do, whether you're doing it with a ferro system or just, the old-fashioned way with some sort of colored twine. I mean, it's a legitimate way to determine shot angles.
I don't know what it would prove, and I've run it through my head a million times. I don't know what more it would prove other than you've got a moving victim, you've got a moving shooter, and that at some point in time, Miss Maggie Murdaugh was over there in the vicinity of that quail pen, and we know that because we identified that tire tread impression on her leg as being from that Polaris or another tire just like it.
Okay.
So I know that already.
So if you go to slide 12, please, which is Exhibit 70. So you know that this shot angle through the quail pen also went through the feed room. Through the shed, through that wooden wall. That wooden wall there, correct?
I don't think I observed a photograph of the inside of the shed. I may have, but I don't believe I ever observed that.
Well, do you see number 12 going all the way through? This is the dowel that goes from the outside, the inside, and then on through the back side of the quail pen.
I see it being held up by the cardboard and the rabbit wire, but I don't know what's behind that cardboard.
You're unaware that it actually went through the wood there. You didn't know that?
I do not know, and like I said, I don't see what it would prove. I don't see any more that it would prove than you've got a moving suspect and a moving victim.
Well, if the measurement included going through fixed wood siding, that would give you more confidence that the angle is accurate, would it not?
Yes, sir, but the angle itself will prove no more for me than direction, because what this proves to me is at some point in time, Miss Maggie Murdaugh was close to this quail pen. If this shot is related, and I have no reason to believe it's not, and my shooter was moving, my victim was moving, I don't know forensically what else that can prove.
Well, you can certainly measure the angle of the bullet entrance to the quail pen and calculate backwards to see where that shot was fired from.
You could, yes, sir.
And that's what Mr. Sutton did he not?
He did, and I never disagreed with his direction. I'm disagreeing with his final analysis or his final result that you can judge how tall a shooter is without knowing a whole lot of other variables.
Well, you understood that Mr. Sutton said that the gun, the barrel was somewhere on that line at to make the shot angle.
Moving back and forth on that line, yes, sir. Yeah. I heard his testimony.
And that he picked a spot and said if you put the gun at a hip level to get on that line, he used a 5'2" person as an example. That's
exclusively, yes, sir. I do.
But he did not say the person had to be 5'2", did he? I mean, we all know it could be dynamic. A 5'8", 6 foot person can get low.
What I gathered from his testimony is it was his opinion that only a person in that height range could have fired that weapon. That was my opinion.
Well, his opinion was that it would be a shooter at 6'4", it would be an unnatural position for them to fire at that low of a level.
And that's the part I disagree with. I don't know how Mr. Sutton could publish an opinion about what's natural or unnatural.
Well, if it's someone's 6'4" and the the muzzle of the gun is being fired at 28 inches off the ground. I mean, the 6'4" person either's got to get down on the ground or hold it down below their knees. Isn't that correct?
I have demonstrated several different ways, depending on distance and height, that a shooter can shoot. We don't know. We don't have a video of it, Mr. Griffin.
Right. But Mr. Sutton's methodology, I think what I'm hearing you now is you don't have a real dispute to his methodology.
He's an engineer. Yes, sir.
Okay. What you dispute is the accuracy of the angle coming out of the quail pen because of the construction being cardboard. Is that right?
Yes, sir. I said that if I was investigating that and even reviewing that case as a consult, I put little or no confidence in that angle of the impact of that cardboard. Now, I put much greater confidence in the one for the dog kennel.
Okay. Well, let's see if we can. You mentioned you had a fair amount of confidence in at least one of the angles coming out of the quail pen, right? Left or right?
The direction, yes, sir.
The direction. And so let's take a look at that right quick. And Doug, if you'll go to
Time. Please go to the jury room. Please do not discuss the case.
What are we doing now? What's happening? Does the judge need a break? What's happening?
Court reporter needs a break. We'll take 15 minutes.
Court reporter wants a break. Fine. All right, guys. Court reporter's taking a break. I know someone in chat was displeased with me not displaying the gunplay in court. It's like, we don't want to see your face, just your face on screen. Well, first of all, congratulations, you get to see just my face on screen because the court's not in session. But second of all, I made a judgment call because, well, I think arguably it technically is terms of service violation on YouTube, and YouTube may or may not do anything, and also it's just made me super uncomfortable. So if you disagree with that decision, I understand, but it made me pretty uncomfortable. So if you really want to go see it, you can go to Law and Crime's feed and see it for all of its glory. But, I know they just checked the firearm just then, but dude, no. Dude, no. Get a blue gun. They make blue shotguns and blue rifles. Get a blue gun. And do that. Shit. I mean, come on. Fuck. So. But I saw someone in chat was upset with me for some reason. Anyways. Pressing on. The decisions you make and the decisions that people do or do not agree with, And I don't know if any other YouTube channel went away from it or not, so you probably can see it on Emily D. Baker or Joe's stream or anything else, but yeah. But you also saw the horror look on my face, which pretty much captured the mood anyway, so I think you got the gist. Why don't they just use the Dow to demonstrate? Yeah, that'd be good. I remember when they did that murder trial where the prosecutor gave the defendant the gun and had him fight. The defendant himself was holding the gun and pointing it directly at the prosecutor in court. Because the prosecutor's like, let's play act this. Because it was self-defense. It was a self-defense case. So the guy was admitting to doing it. He's like, he shot the guy at the lodge. They had this lodge, and they played acted with a real gun, and the defendant was holding the gun and pointing it directly at the prosecutor. And then it turned out that they actually had a blue gun. They had a blue gun, and then it's like, well, let's switch to the blue gun. Oh my God. Dude, people are not taking this seriously. New Mexico? Yeah, New Mexico, that sounds all right. Yeah. Oh, and it was great because it was only after the defendant did this. At the request of the prosecutor, by the way. Prosecutor's asking them to do that. Can you please point the gun at me like you did them and like all the rest of it? It was only after that we saw the sheriff come in and actually check the gun to make sure it was cleared. And also, he like pulled the thing back and he caused the like, because it had some sort of safety thing in there, and he pulled the breaching charge back and caused the thing to snap off. And so it's like, oh, it's a live gun now. That's good. That's good news. So yeah. Yeah. It doesn't create prejudice at all. Dude. It's like what we're not doing in my courtroom. If I ever become a judge, like what we're not doing is we are not pointing the gun at anyone. It's for the cause of justice. Fuck you. No, it's not. Figure something else out. No, get a blue gun. Get a blue shotgun. They make blue gun. They make blue pistols. They make blue shotguns. They make blue rifles. Get a blue gun. Make it work. We are not playing with real guns in my fucking courtroom. No. No. It's in the interest of justice. No. No. We are not doing this. No. Anyways, let me read some super chats. Well, I got a minute. $1.99 from DS this morning said, missed you, Kurt. Thank you very much, D. Dark Logic gave $10. Say, please tell me this BS expert is a point of appeal. Should they be on the losing end via jury? For fuck's sake, this is a stain and a mockery of our system. There are definitely issues on appeal. Dark Logic. There are some notable issues on appeal. This of recent cases we've seen together, this case has more grounds of appeal. The only case I thought was stronger was arguably Kim Potter, which had only really one issue on appeal, but it was a really fucking good issue. So the only case I thought was arguably stronger on appeal was Kim Potter, but this is pretty bad. Patricia Del Bell says, best food and drink you had in Vegas. Well, we talked about the pasta thing. So Adam Trapp said, for $20, said, Mamma Mia, that's a spicy meatball. RGK86 said, keep up the good work. Just Me said, here's a bribe to stop singing, not juggling, just bribing. Mackenzie Homey said, the singing is what sets you apart from other lawyers. So Rose Tyler said, Kurt is here for the rest. Here's for the rest of your spaghetti dinner. You got me with the song. Some people like the singing, some people not so much. Dark Logic gave $10 to say, how's this witness in any way help the state? The man basically said no trajectory could be definite, which means anyone of any height could shot the rounds if you believe him. And Ron White gave $10 to say, hello, Kurt, welcome back. Following your stream and Joe's, trying side for side, both great. Fantastic. And Joe did eventually send me a link to join a stream 4 hours after I asked for one. So, way to go, Joe. I still love you, buddy. Yeah. That's...
Now we're willing to...
So, yeah, there are definitely several grounds of appeal in this case, if he's convicted. But I'm still kind of hoping no, just because it'll be fun to laugh at the state. Because this case has problems. That'll be fun to laugh in the state's face. Daryl Brooks is currently pending trial for witness intimidation in a different court, and I don't know what's happening with that case, but fun times. Rumor was he might represent himself again, so we might get more of the stylings of Darrell Brooks. Hazmat responding to a train derailment in Florida. Darrell Brooks, yeah. The judge was running for state Supreme Court. I think that might have already happened. She came in third, so she lost for the Wisconsin Supreme Court because the top two advanced to the general election, so I had to check her status. So unfortunately, not going to make it for state Supreme Court. At least unfortunately for her. Didn't Brooks already get like 6 consecutive life sentences? Yes. Plus like 700 years. Yes. So, yeah. Darrell Brooks has no grounds of appeal at all, even a little bit. So, no. Am I going to cover the Manson trial? If it ever happens, sure. She went out of her way for Darrell Brooks, though. She went way out of her way for Darrell Brooks, which was a little annoying. How far she went out of her way for Darrell Brooks. I appreciate that she wanted to cover her bases, but dude, she went way overboard. Vallow, if they stream it, that'd be nice. They keep. First of all, I don't know that the Daybell Vallow trial will ever happen. I'm not convinced there will ever be a trial at this point because they keep making motions to like delay and reschedule and things. So I think the Daybell Vallow case is an illusion in all of our minds collectively, and it will never happen. But if it ever does happen, it's not being broadcast. So probably next trial I'll wind up covering is probably the OnlyFans murder trial. I would imagine. Chad J. Bell trying to distance himself from Lori. I feel that for sure. Idaho does not allow live cameras in the courtroom. They do. This particular judge has not, for whatever reason. But it's not categorically prohibited. It's just this particular judge likes to keep everything sealed and private and stuff. That's in December? Did they move it off to December, really? I thought it was. Did they move the OnlyFans murder trial over to December? Courtney Clenny? You're right, apparently. December the 19th. Wow. Okay. No. This article's from last year. Okay, this article's from last year saying December. I'm like, that doesn't sound right at all. I don't know if they have a date scheduled for this right now. I was under the impression it was coming up relatively soon. I can't find date right now, but I was under the impression it would be relatively soon. April sounds right. April sounds a lot more right. She is in jail. Yes, she's in jail. Club Q shooting trial. I don't think I know that one. But we'll cover major trials as they happen. In addition to Supreme Court analysis, in addition to other stuff, we'll cover major cases as they happen. It's good. It's good for the live streaming. We'll try to figure out how we can bring more people into the live streams. Nice for the 300 of you who are here, of course. But I would like to try to figure out how we can get up to, a couple thousand people joining us for live streams. I know this particular stream was kind of last minute. I was planning on joining Joe until he failed to invite me, and I asked repeatedly for an invite, and then he didn't invite me for 4 hours. But do I think Andrew Tate will be charged in the U.S.? I'm not aware of any allegations that are U.S. based. So I'd have to say no right now. I'm not aware of any causes of action in the U.S. What the business? What the business is a great question. It's a great question. Yeah, thank you very much, A2TWX. It's very nice of you. I'm glad that you like me being here. I'm going to cover Jack Daniel versus Bad Spaniels. Hell yes. Trademark case, Bad Spaniels is going to win. But I'll definitely cover it. I love Jack Daniels and all, but they're not going to win that case. Easier to chat with everyone. It is a little bit easier to chat with everyone because I don't have so many people here as some of the other streams. But I mean, this is a business, this is an enterprise for me. This is my full-time job, and so live stream, the numbers matter. So it's like, how can I make it better? How can I appeal to more people? How can I get more people watching, the more people engaging? Is a perfectly reasonable question for me to ask, and especially since it's my business now. DS says, I think you should appear on non-law tubers channels to expand your audience, as you're all fishing in the same pool. I try. Recently, I tried to appear on Grizzly True Crime for partially that reason. Didn't work out, but we try. The Club Q shooting was a mass shooting that happened at a gay bar in Colorado Springs. I don't know if that's really quite my speed, like a mass shooting. It would totally depend on, it would totally depend on people, if people wanted to see it, to be quite honest. So I'd have to make a prediction as to whether or not I thought it would be a good use of the channel's time. Colonel Kurtz. Colonel Kurtz is very good on the Manson stuff for sure. Thank you very much, Lorraine. Use polls more often on YouTube to get a better idea of what the chat likes and wants. They're modestly helpful at times, but the engagement is nice. Look to you first. Thank you. I appreciate that. Why aren't they back? I don't know. RGK says, what's the actual point of having a firearm in the courtroom? I mean, it's evidence. It's evidence, and it has to be available, but I'm not going to allow you to point it at people. The community posts help me do me out. They very well do. Which why you have to have me try to clear. Just do a single opinion on it there? Like just do a single opinion?
Jury is present, sir. All right, thank you, Mr. Griffin. Yes, sir.
If you can give me a copy of the opinion itself, you can get me a copy of the opinion you want me to review.
Dr. Kinsey, I'm still talking about the quail pen.
20 pages?
Do you remember how tall off the ground that defect is?
I do not from memory, Mr. Griffin.
My sound is screwed.
If I would,
could you
show
help
you Agent
clarify
Corey's
that a little bit
report.
more? In what way is my sound screwed?
Take a look at it. We don't. It's already in evidence somewhere, but if you could just tell the jury, and if that's consistent with your understanding of how high that defect is.
$4'2".
Yes, sir.
Okay.
And did you inspect when you were out there? Did you inspect the entry in the quail pen or the damage to the shop behind the quail pen at all?
I looked at all of it, but I did not run any angles.
Okay.
If you give me the opinion,
I did.
itself that
Yes,
you
sir.
want
I
me to
did
review,
interview
I guess I'll do it
Agent
for
Forley
$50.
about her work on the scene.
Where was
Seems reasonable.
Back the first or second week of December at the New Sled Laboratory.
If you give me an actual copy of the opinion,
I can give you an exact date if I look back through my notes.
I don't need that. But are you being compensated for your time?
I am. Yes, sir.
And how much have you been paid thus far, and how much you hope to get paid before it's all said and done?
Well, I'm a Baptist, so if I didn't charge something, my friends and family would talk bad about me. But my retainer is $2,500, and I have a flat $100 an hour rate. And when I added it up, I was up a little over 100 hours. But I ended my retainer myself without anyone asking me to do a little over a week and a half ago. And I'm now working off of a mutual aid agreement that my sheriff's allowing me to do that, Sheriff Leroy Ravenel from Orangeburg.
Sure.
So I'm not charging anything from a little bit before last week on.
So 100 hours, $100, is that?
That's roughly, I have expended.
So the Baptists will talk bad about you now.
Roughly,
You're not charging.
not all of it was daytime, but if I take off, I have to use personal leave from work to do this work. So roughly 75, 80 hours I have used of time from work.
Okay. So you've made $7,500, $10,000?
Well, I've spent way more than that running up and down the highways, Mr. Griffin. I've probably been to 20 meetings or so, but yes, sir, if you look at it that way.
Okay. Now, Doug, back to exhibit.
But I will be going up next week.
Exhibit 140, and if you'll go to slide 31, please. I think it's the right number. Yeah. So this is from Mr. Sutton, and it's got, let's just focus on the angle going in the quail pen. This is not a height issue. This is the angle. Do you have any disagreement with this angle?
I don't. The only problem I have with it, I know there was a side-by-side there, and I don't see the side-by-side depicted on this photograph. So looking at it, I could not tell you how that would play into that angle.
Okay. But, and the quail pen's 4 feet, the defect in the quail pen's 4 feet, 2 inches off the ground, and according to Agent Worley, the shot angle is rising either 1 degree or 1.5 degrees or 3 degrees. Is that consistent?
That's accurate. Yes, sir.
Well, let me ask you, do you believe the shot angle is rising? I mean, you may not agree with the exact angle, but do you believe it's rising toward the quail pen?
Well, I believe it could be. Yes, sir, I do.
Do you believe it could be a downward
I do not
trajectory?
believe, looking at it, that it could be downward. No, sir.
So we can eliminate downward.
Well, if you're going by my results, I'm saying that I don't believe it's downward.
Okay. And so if it's going upward, and then you take that line back that we see, this line, at some point in time it's going to go into the ground, will it not?
It should, yes, sir.
And do you know where that terminal point is, roughly?
I have no idea, Mr. Griffin. As I said, I know I've got a moving victim. I know I've got a moving suspect.
Okay.
I know there's a lot of movement. I don't see where that's worth 25 cents or a quarter, one way or the other. It gives me an idea that this is a fluid and dynamic crime scene.
Well, if you had confidence in the vertical angle, then you would be able to determine depending on where along the way, you would be able to determine the height of the muzzle of the gun, if you had confidence in the angle.
Well, I'd have to know a bunch of unknowns also. How the shooter's holding the gun, how tall the shooter is, the
Would you?
distance, did he move a shell casing, did he not? I mean, I don't know those things, and I'm not going to make them up.
No, I mean, would you have to know all those things to know how high the muzzle is off the ground at any point along that line?
If you give me a fixed point and I knew that I had a strategic fixed position I was shooting, I could run a tape measure and know where they were at.
And it doesn't matter whether it's a 7.4, 6.4, 4.4 person, the muzzle's going to be at a fixed spot, right?
That's the way angles work, yes, sir.
Okay, thank you. Now, on this Faro, and Faro is the SLED does Faro work, do they not?
Yes, sir.
And it is the state-of-the-art technology of scanning and getting measurements?
It is the new thing. We use the sketch pad and a pencil, but I do understand the technical part of it.
And would you agree with me that the feed room would be about right in here? Can you see that? You want to come down and point out where the feed room would be on this angle? Excuse me, on this Faro? And I'll give you I thought I would.
I believe it's right here.
Right there at the end of the structure?
Yes, sir.
Okay. All right, thank you.
Yes, sir.
And I guess you don't have the measurements, but do you know roughly how far this line, this angle would be away from the corner of that structure?
I have no idea, Mr. Griffin.
You've not done that math?
No, sir, and I saw no need to if all the shell casings are up here by the shed.
Okay. All right. Now, I want to go back to Paul and his injuries, and and I guess first I want to talk about your analysis. We've been critical of, y'all have been critical of Mr. Palmbach and Dr. Eisenstadt, but under your analysis, the shot of the gun was up through the left shoulder, jaw, and out the top of the head. Correct?
Yes, sir. That is my opinion.
And you, I'm going to come up here, and this is the feed room door here. I just want to understand where you have Paul under your analysis. Is Paul on this side?
Which shot, Mr. Griffin?
The last shot.
The fatal shot?
Yes, sir.
Well, as I mentioned in my report, I would assume he's closer to this wall because I've got a void 6 inches below that light switch. If you look at the outside photograph of that building, there's a silver light cover on the wall. And about 6 inches below that, I've got one stray satellite drop of blood, and then it's fairly clean. You've got some outliers, but it's fairly clean going down.
Okay. So you think Paul is closer, and this would be the door and it's swung open, so you think Paul is closer to this side?
Well, I think it would have to be Paul because the angle wouldn't match up if the shooter was here and Paul was over there. It wouldn't match up either way. Whether it was down in the head or up in the head, it still wouldn't match up either way if Paul was against the hinge side of the door.
And Paul was standing roughly how I'm standing?
No, sir. As I demonstrated, well, we tried to demonstrate, me and Mr. Harpootlian were kind of dancing up here, but I believe he come out with his head down. He's drooped on the left side, and he come out on this side with his shoulder just outside the room. Yes, sir. About like that.
Okay. And then the shooter is off to Paul's left?
Yes, sir. From this side. Yes, sir.
And the shooter has a shotgun, right?
Absolutely.
And he is some 2.5 feet away?
Well,
I mean, the barrel is 2.5 feet away?
That's what Dr. Reamer said. Yes, sir.
What do you say?
I don't believe it was that far away. But I'm not, like I said in my earlier testimony, I'm not going to contradict a pathologist. She knows more about the human body than I do.
All right. But you don't mind contradicting Dr. Eisenstadt?
Well, because I've been to the scene and I've reviewed all this evidence. Yes, sir. That is correct.
Okay. Well, that's what we're doing. Mm-hmm. So if you say, let's take 2.5 feet from the end of the muzzle, is that what we're talking about?
Yes, sir. That is.
And then you've got to back the shooter up to hold the gun. And I guess if you got it 45 degrees, right?
Well, as mentioned a dozen times so far, I don't know how long this shotgun is.
Okay.
Okay? But it would be here. And I don't know where he's standing, most probably behind this wall, because Paul is stumbling toward him. So here.
So the shooter's shooting left-handed, you think?
Well, I don't know if he's left or right-handed, Mr. Griffin.
Okay.
I don't know that part.
Right.
But that angle would match up despite all the...
That matches up?
Yes, sir. That would match up.
Now tell me, in that angle, and this dials the gun, where's that shot shell going if it ejects?
If I'm pointing into the room, it could go inside the room.
Well, you just raise it up to... I mean, that's under your angle.
But I'm behind the gun. I'm behind the gun, so that's going to push the weapon out a little bit. The ejection port's on the right, so the shell could easily end up in that room.
If Paul's standing there and the end of the muzzle is 2.5 feet away,
yes, sir.
You're saying could eject in the room?
The door is this wide. Yes, sir. Absolutely.
At 45 degrees?
Yes, sir.
Okay.
It's doable. Yes, sir.
And then under your analysis...
Your analysis?
Your analysis.
Oh, my analysis. Okay.
Your analysis.
Yes, sir.
We're not there. We're not there. We're still in court. The shot's going up through Paul, chest, jaw, out the top of his head.
Yes, sir.
Number 2 bird shot.
Number 2 steel shot, dry lock, 3-inch. Yes, sir.
And you counted, and I think you said 150, 156. I can't remember.
Well, the literature says 156. I was like 150, but I kept getting tired of counting, and I think I kept messing up. So I'm going to say the literature is probably correct.
Okay. And I think there were some 60 to 70 that were found in his body, at least.
I have no reason to doubt that. No, sir. Okay. I didn't go 1, 2, 3, 4 and count them on the X-ray, but I believe that.
Okay. And And Doug, if you'll pull up, please, Defendant's Exhibit 188, which is in evidence. Well, I don't want to do that one. Hang on. Let's do crime scene photos. And folks, this is going to be a sealed exhibit, so please cover your monitors. Turn on. And this is Defendant's 193 as soon as we're ready. So you tell us, you recognize this photo?
Yes, sir.
And this is the door?
Yes, sir.
And this part of the door is blood spattered?
Yes, sir, it is.
And then there's hair?
There is hair, there's a little bit of bone, and there's some other body tissue.
Okay. And there, you think, where is Paul in relation to the door at this
He
point?
would be right where I showed you, off at 135-ish, give or take a few degrees, closer to this side, so you could make that angle. You can look at the directionality in the blood and tell which direction it's going.
Okay.
What?
And coming out of the top of his head would be 75 steel pellets?
Who's the girl in the mustard jumper?
Yes, sir. That's no other way for him to get out. Yes, sir.
And you went out there and you found one indentation.
Well, it's an indentation, but that is a little deceptive because you can see the paint damage to the top of the door. One indent is what I found, but I said bullet defects. The S got dropped from that. But if you zoom in on that, you can see where the paint was
Chanley Painter from Court TV?
Disturbed around that
Oh, she
indentation.
looks
But
familiar.
one proves it didn't go back the other direction, Mr. Griffin. It doesn't take a lot.
So if you'll pull up 188, Defendants in evidence, 188, and this is not under seal.
As beautiful as ever, I see too.
188, please. And zoom in on the indentation.
There's actually several if you,
All right.
you're cutting in on that one, but.
So you say there are more defects on the door?
Yes, sir.
Did you document any defects that you observed on the door?
I got them in a photograph. I can show you. I mean,
Okay.
what other documentation did I need to do it to verify that that's the same door?
No, I'm just talking about other pellet marks on the door.
There are other pellet marks on there. Yes, sir. You just cut that one down, but if you move up a little bit, you can see the little indentions right there in the paint.
All right, back it up, Doug.
Right above the hinge, right here. 1, 2, 3, 4, 5, 6, 7.
Okay.
There's several of them there.
And then you see this pellet here in the,
I did not see that, but I'm vertically challenged, and I wish I could have looked up and saw that pellet, but I did not see that pellet lodged in that door frame. But I'm glad, Mr. Maybach, Pombach, however you say his name, I'm glad he found it because that even proves my point a little bit more.
well,
Does it
I'll ask
really
you,
now?
Mm-hmm.
According to your shot angle, how would a pellet get there?
It's really, I mean, the cone, it's a cone, Mr. Griffin. I've already described how a shot pattern works. It's a cone.
So this missed his head, you think?
No, it come out of his head.
Okay.
And the ones in the floor in the feed room probably also come out of his head. They bounced off that door, the OSB, and in the feed room.
Okay. And so you believe that this pellet that's in the door jamb came through his shoulder, through his neck, out the top of his head, and ended up at that location?
Well, it didn't turn around and come back out the top of his head. Yes, sir, I do believe that.
Well, now, you said there's blowback, 8 to 10%. What do you mean? You testified earlier there's blowback about 8.
If someone is behind the stock of a long gun and you shoot someone within distance to have high velocity spatter come back at you, it's going to be 8 to 10% of what's in front of the gun is going to come back at you. And a lot of the literature supports that.
Well, were you, let me show you, and this is under seal. Please cover up, and it's Defendant's Exhibit 192. Under seal, 192. Do you see that?
What?
This photo.
Yes, sir.
Now, this blood spatter down here where you say Paul would be standing, what's your explanation for that?
What do you mean, what's my explanation?
What is it?
That is medium directional blood spatter.
From what injury to Paul?
Probably his brain hitting the sidewalk would be my best guess, but that's not high velocity.
Now, you understand what Mr. Palmbach said was that that's more consistent with Paul being shot from the top of the head, going through his neck, out his shoulder, and producing that stain.
I also understand Mr. Palmbach said there's no damage over here from those shot pellets, and you can't have one without the other. I disagree with that result.
So you believe this is from Paul's brain landing
Either his
where?
brain landing on the sidewalk, bouncing off the door, or either his body falling in body fluids outside. That's low velocity, low to medium velocity. That's not high velocity blood spatter. That's stomping in a puddle of blood or something moving in a puddle of blood. That's not the projected blood like you'd have a millimeter or less in high velocity blood spatter. That's large. It does show some directionality. It's coming from the door frame or either right outside the door frame, but it's large. That's way too large to be associated with the exit hole of a gunshot.
I think I tuned out about 20 minutes ago. What are we talking about now?
Outside.
I do understand, Mr. Griffin, but I also know his brain made contact with that door and the top of that door frame before it landed. And I know gravity works and brings body fluids back down to earth. Okay. You got one or the other, either that or when he fell in existing blood. That is low velocity. Like I said, that's associated with something in a puddle or something large. That's not associated with a gunshot or high-speed machine.
Can I go back to the Supreme Court or
Now,
something?
would you agree this is a voiding area over here on the door?
Instead of whatever this bullshit is,
I wouldn't agree it's a void area because I don't see the outline of shoes,
Let's
or
talk
I
about
don't
the
see
case
the
with the
outline
guy
of
who's getting $200,000
implement or the outline of anything else. I would say there's more concentrated blood droplets over here on the side opposite the hinge, but I would not necessarily agree that's a void area. I see downward spatter on the door right here. For it to be a void, that would have to be absent blood.
Well, you see a little bit.
I do, yes, sir.
But you don't see very much blood on the door.
Not compared to the other side. You're correct.
Okay. Now,
but if there's something there, Mr. Griffin, blocking that spot, you're not going to see a little bit. You're going to see none. If you're standing there and I splash you with blood, there's going to be two perfect bloodless footprints there. So that's why I'm not considering this a void.
Unless it goes up and comes down.
Gravity brings it down. That is right. And if your person had time to move or whatever, I guess that could count for it. But I don't consider
it. The person and came down.
And that would do what?
Lower the court volume?
Body matter went over, brain went over, hit the top of the door, and then bounced out, and blood came down.
Trying to bounce the volume levels is always fun and interesting over here in streaming land.
Here or there, but like I told you, the majority of that force is applied upward.
Right.
Upward. That's why you got the hair on the ceiling. That's why you've got the demarcation line on the containers. That body fluid was directed upward with force.
Okay. And you mentioned there's no footprints here. was any effort
I
made
appreciate that you
to
guys want to hear me.
eliminate
It's just in my own ear, I can't
footwear
hear the relative
impressions
volume levels, which is
through
in the
any
ass.
protein enhancers?
I didn't see any of that, Mr. Griffin, if they did. I saw no evidence of that when I went back to the scene. Generally, when you use dye stains and that kind of thing, it's just going to be there forever.
Dye stain would have picked up perhaps stained footwear impressions you can't see with the naked eye, wouldn't they?
It may have, if someone had stepped in blood and left a footwear impression.
Right. Well, there's a shooter somewhere, inside or outside the door, correct?
Yes, sir, I agree with that.
And there's no effort to determine footwear impressions of the shooter.
Mr. Griffin, obviously,
Was there?
I don't know. I don't know what the process was. I know they examined some partial footwear impressions,
You can take this down, Doug.
but I don't know how far they went beyond that.
Well, they certainly should have gone further than they did. Would you agree with that?
Mr. Griffin, I can only judge what I would do, and sometimes I would, sometimes I wouldn't. If I saw evidence that I had something that I needed some more detail, I
You didn't realize being an
would use
expert witness
chemicals,
was easily
but it
sounding
just
confident in
depends on the
making shit up. Not too far from the truth, my friend. Not too far from the truth.
Kenzie, I'm going to show you what we marked as Defendant's Exhibit 197 and 196. And I'll ask you first, 197, do you recognize that as essentially a picture outside the feed room door?
Yes, sir, I do.
And Your Honor would move 197 into evidence this time without objection, I believe.
Without objection.
Are you offering both of them?
Yes, sir.
Any objection to either?
No objection, Your
They're
Honor.
both admitted.
All right, 196. Dr. Kenzie, what would you make of those pock marks on the concrete outside the feed room door?
I don't know, Mr. Griffin. I don't know what they are.
Could they be pellet?
I guess they could be.
All right.
They could be from a pressure washer also.
Oh, you have these? Okay, great. So we're seeing for the jury 197, and then, can you zoom in there? Doug, go to 196, please. So those could be from a pressure washer, and those could be from a number 2 birdshot pellets, correct?
Well, I don't know. I have to see the cement everywhere else to see how it's weathered.
Okay. All right. Fair enough. Now, last few questions, you mentioned that that you had seen some 12 execution-style killings with contact wounds to the head.
I said I've worked about 3 dozen total. Probably 12 of them were homicides to the head. The execution thing, I don't know if it's execution or just contact, but I would say it's self-inflicted as opposed to someone else doing it.
Well, so let's get it right. 36 total. I thought
Probably 3 dozen total, yes, sir. And 2/3 of that was probably self-inflicted, so that would leave 12.
Self-inflicted are usually under the chin and the mouth, on the side.
Well, the one that I witnessed was to the forehead.
To the forehead.
Yes, sir.
Now, of the 36, how many were shotguns?
No, I've worked a lot of self-inflicted gunshot deaths. I was saying shotguns, about 3
so
dozen.
36 shotguns.
Yes, sir.
Roughly 12.
And a couple of them were accidents too, but yes, sir.
Okay. And and how many involved number 2 birdshot?
I don't recall. I had some with birdshot. I don't recall if it was number 2, 4, 8, 9. I don't know.
And how many were to the back of the head?
A dozen, probably a dozen were to the head. Contact either the back or the sides, or the one I told you about in the front.
Okay. And any of those to the brain? evacuate from the skull cavity?
I have seen them. I have seen the brains come out. Usually that was from one here. I'm not going to say I haven't seen it. I probably have seen it. But most definitely, like I said earlier when I described it, it looks like it goes away. It's really still there. It's just not something you can quantify. I mean, it's just a mess. That's the only way I can explain it.
In your career, have you ever worked a case where a victim's brain had been evacuated the way Paul's was in this case?
Yes, sir, I have, and tongues also. Tongue and brain, I have seen them. Yes, sir.
And were those self-inflicted?
Both.
Okay.
Yes, sir, both.
And you're talking about shotgun?
Yes, sir.
Okay.
Shotguns.
And I think you described those as execution-style killings.
Yes, sir. I would. If you put it on somebody's head from the side or the top, I would. That's how I would describe it.
Well, let me ask you: would you describe Paul's murder here as an execution-style killing?
In the context that someone executed him, yes, sir. But it wasn't in the top of the head.
I understand.
Yes, sir.
And that, and there was no signs of struggle. You agree with that?
I saw none. No, sir.
And would you agree with Mr. Palmbach that it appeared that Paul got caught by surprise?
I've said that from the start. That would account for his arms being down. Okay. Yes, sir.
And
or someone he was real comfortable with.
And even under your analysis, the shooter would have blowback blood on them. Is that correct?
I believe they would. Yes, sir.
It's just a matter of the quantity between you and Mr. Palmbach as to how much blood would.
Well, as I mentioned in my report, as you get closer to the muzzle of the gun, I think proportionally it's going to increase. You know, when I said 8 to 10% is what most of the literature says, that's behind the stock. But as you get proportionately closer to the muzzle end of the gun, that's going to increase because you're down at the business end where those pellets are coming out doing damage.
And in this case, you're talking about brain matter?
Yes, sir.
Blood?
Bone, yes, sir.
And getting hit from some skull fragments?
Yes, sir, that's possible.
Under your scenario as well?
Yes, sir, absolutely.
And lastly, how many murder have you worked where one person brings a high-powered assault weapon that has a magazine capacity of 20 or more rounds and a shotgun with maximum capacity maybe 3 shells?
Well, I have worked multiple murders where the available weapons there were used and several calibers were used, but I can't tell you from memory the other ones.
Logically, it would make sense that if you're going to go kill 2 people and you have a high-powered weapon with a high-capacity magazine, that was all you need to do the job, right?
Well, if the weapon's available, Mr. Griffin, if it's there and it's available and maybe it wasn't something that I put a lot of thought in, I'm probably going to use whatever's available.
Well, here we know there were 2 weapons available. There was a 12-gauge shotgun and a AR-15 style 300 blackout.
Yes, sir.
And both were used?
Yes, sir.
And there was sufficient capacity in the 300 blackout to kill both Maggie and Paul, correct?
Well, in a perfect scenario, a shotgun is what I would want at night with moving targets. But in a perfect scenario, a young man doesn't take a double-aught buckshot to the middle of the chest and walk away from it. So I don't know. I don't think like that. I don't know. But in the dark, I'd rather have a shotgun than that rifle.
Of course, and build it. Just a second. One more line of questioning. You demonstrated Mr. Palmbach's shot from the top of the head with Attorney General Wilson a moment ago.
Yes, sir.
Now, that was Mr. Palmbach never put anybody inside the door the way y'all demonstrated in his testimony, did he?
That is the way I understood it. Yes, sir.
Well, I mean, he said that. Well, can you come up here, Mr.
I mean,
Harper?
with the void, you're talking about the void. He said there's a void here, and this is where I believe the shooter would be, if I'm not mistaken.
Right. So if you'll come up here, Mr. Arbutlian, and let me find the dowel.
Let me bend down. Don't let him bend down like that.
No, I don't. Come on. No, I don't. So if you're coming out of the threat, you're going to get down.
Okay, what are we doing now?
Yeah, get down. Almost to the ground.
Bend over like this.
We're doing this again? Oh, he's actually going to use a dowel instead of an actual gun
You probably
for
can't do
this.
that. But the shot to the head as it's coming out, right? Or boom.
He'd have to be twisted this way for it to work out with the arm if that was the
Okay.
Yes, sir.
But that's fine. That's fine. But Mr. Palmbach never said that they passed in the doorway, did he?
I don't think I can do that one,
Might not have
Bobo.
said those
I don't think I
words,
can
but
get
that was
them to
my
grounds in the
inference,
next
that
15
there's a
minutes.
void there, and when he's in the picture holding his hands here, I took that to be Paul's head. So that's.
All right. Well, okay. Did you not understand when he was in the picture there? He was demonstrating what your angle had to be to make it work.
Well, I wasn't in the door with my angle.
I understand. I
Yeah.
understand. Okay. All right. Thank you.
Yes, sir.
That's all we have.
Thank you.
Correct.
Briefly, Your Honor.
Briefly, Your Honor. Briefly. Raising Cane's has
All
pretty
right,
good chicken. I agree with that.
Dr. Kinsey, you've had an opportunity to
Most just
speak
chicken
with
is nothing special.
with Dr. Reimer, the pathologist that actually examined Maggie and Paul, correct?
Yes, sir, I have.
And you had an opportunity to observe and listen to the testimony of Dr. I think it's Eisenstadt, who was the pathologist that did not examine Maggie and Paul, correct?
Yes, sir, I have.
You've also had an opportunity to go to the crime scene and observe the feed room, observe the areas where both Maggie and Paul were murdered, correct?
That is correct.
You've had an opportunity to observe all the brain matter and tissue and the defects in the doors and the wood and everything and get a complete context for what happened that night, correct?
Yes, sir, that is correct.
Is Dr. Reimer or Dr. Eisenstadt's conclusions about the trauma to the bodies, which one of them is more consistent with what happened at the crime scene as you observed with your expert background?
Well, I'll start by saying I don't know either one of them from a can of paint. This was my first time ever meeting Dr. Reimer, but my opinions are consistent with hers. I vary a little bit on the distance, but like I said, I'm not going to argue with a pathologist. That's not I'm not that kind of doctor.
Real quick, you differ with her a little bit on the distance of what?
Of the fatal shot to Paul's shoulder, I believe it was a little bit closer, and I can't account for that lack of stippling. But other than that, her opinions and my opinions are fairly consistent.
But that would not change, that difference of opinion would not change your conclusions either way?
No, sir, they would not.
For the sake of this redirect, let's assume for a moment that the angle of impact and the direction that the defense posed were accurate. Are there other variables that the defense expert didn't account for that could change the height of the shooter?
Well, as I demonstrated, positioning, distance, height, the way you're holding the weapon that could place those cartridge cases there, it's nothing uniform about it. As I said, it's static and dynamic.
So the shooter is running around and the victim is moving, correct?
Yes, sir.
It's chaotic.
Yes, sir.
It's crazy.
Yes, sir. I would imagine it was.
There's no way to know, unless you were there, how the gun was being shouldered, where it was being held, the angle. There's no way to know that.
I have no way of knowing that.
You were asked about how much
Lord.
you were being paid to be here today. Do you recall what the hourly rates of the defense experts were when they testified?
Well, it doesn't matter. Let
You
it
go over what
go.
those were?
Some was $350 an hour, some was $650 an hour, and I think one was $5,500 a day, if I'm not mistaken. Oh.
Jim, pictures you just put into evidence? Oh. I got them right here. I just found them. Thank you.
Is it over?
Okay, I'm showing you what's marked as State's Exhibit 197. Do you know when that picture was taken?
I have no idea.
Okay. Sir. I'm showing you what's been marked as Defendant's Exhibit 196. Do you know when that picture was taken?
I have no idea. No, sir.
Is there anything about the defects of that photo that stand out to you other than just concrete defects?
They're not very uniform, but no, sir, other than that.
Does that photo tell you anything?
It tells me nothing, no, sir.
That's all I have. Thank you.
Thank God.
Further. Thank you. You may step down.
Please be over.
Any further witnesses by the state?
Your Honor, in the rebuttal case, the state rests.
Oh.
Ladies and gentlemen, the state has rested. I'm going to have you go to the jury room for a break. Please not discuss the
Yes! It's over! It's over! There's no more testimony! Thank God!
Everyone, be seated. Any comments you want to make, Mr. Harpootlian or Mr. Griffin, about Sir rebuttal?
Sorry.
About Sir rebuttal. Sir reply.
No.
No, thank you.
All right. So we run out of time today as far as the jury view. We're going to take a recess for me to confer with counsel.
All right, court's out for the day. Meeting with counsel. We're doing jury instructions, I guess, privately in chambers or whatever. The court's done for the day. I guess that'll be it then. So, judges meeting with the attorneys to do jury instructions. So I would imagine that we're going to charge the jury and do closing arguments tomorrow in the morning. The jury will get it at lunch. So that's where we're at. Tomorrow's Wednesday, so they get it Wednesday at lunch. So we'll see. I'm just glad it's over. At this point, at this particular moment, I'm happy. So I don't know if they charge the jury first in South Carolina or not, but they'll have closing argument and then charge the jury, or I suppose the other way around. There will be a closing argument by the state, then the defense, and then, of course, the state gets the last word. So very exciting. So that's it. We now have all the evidence submitted. Now it's just the closing argument. State could still put this all together in a closing argument. They didn't really do anything in the opening, but maybe they can do something in the closing. We'll see. We'll be on tomorrow, I suppose, for closing argument. So we'll be on tomorrow, I suppose, at 9:30, 8:30. And yeah. We'll take a hell of a close. Yeah. Goth prosecutor single, we learned. So there's still hope for uncivil law out there. Goth prosecutor, if you're watching this, holla. Thank you for the gift memberships. As always, Ice Lee C. Thank you. The field trip thing, yeah, I don't know if they're doing the field trip or if they're just gonna say to the jury. Like I don't know that they're gonna do it unless the jury asks. So I think at some point they'll be like, and if you want to go to the scene as part of your deliberations, you can let us know and we'll arrange that or whatever. But I don't think they're gonna do anything unless that's what they're talking about now. Unless they're gonna do a field trip in the morning. Do it that way. And then we'd have closing arguments and instruction after that, which means the jury would get the case presumably in the early afternoon. Going to Moselle in the morning. Yeah. So that will take the morning. That's the morning. So the judge they won't get the case till tomorrow afternoon. So there might not be any court in the morning at all. It might not be till tomorrow afternoon. So we'll see how it all pans out. Unless they're going to do it right now. I suppose they could do it right now. So, I mean, it's 5 o'clock. It's a little late, but you know, stranger things have happened. How come they're not doing it on the record? I mean, it is on the record. It's just not going to be televised. But there will be some kind of record taken of some variety. But they're not going to bring TV cameras there and stuff. So, Chicken Invaders. What is Chicken Invaders? Free on Steam. What is this? Let's take a look. Closing arguments won't start till after lunch. I think that's quite possible. Chicken Invaders Universe. Free to play. What is this? A deliciously addictive core finger blistering shooting action surrounded by delectable morsels of galactic exploration, spacecraft customization, community competition. What the hell is this? I'm not even 100%. Okay. It's shooting chickens in space. Okay. Well, it's free. Free's good. So I guess I'll install that and yeah. Chicken wings plus Galagas plus Space Invaders. Okay. There you go. When's my next trial? I don't know. It just depends on what looks good, to be honest. So I suppose I have some time now to cut up the video from earlier. So I'll try to cut up the video from earlier where I did the Supreme Court cases. And then I'll have some stuff to post over the next couple days, and that'll be good. Mukbang plus cheats, Space Invaders. Okay. Well, I now have Chicken Invaders Universe installed on my computer, so exciting. Twenty Minutes Till Dawn. Yeah, 20 Minutes Till Dawn was a good game. Basically beat it a couple times, so but yeah, it was a good game. All right, well, I guess I'm going to sign off for now. Do I miss Vegas? Not particularly. It's a fine town, but I'm happy to be back home in my own home. Living in Vegas would be interesting. Shows and stuff to do. That'd be cool. Lots of conventions come through town. That's cool. Well, I'm happy to be in my own home in any event, so that's nice. Redirect? Who's around? Let's see. I could direct you over to Good Logic. I suppose I'll do that. Let's see. And I got to work on an appeal for a YouTube community guideline strike for one of my many Capitol Riot videos. One of my Capitol Riot videos got again flagged for a second time this has happened. The last time it took me a long time to get the community guideline strike removed. But one of my Capitol Riot videos got flagged for a community guidelines violation for encouraging and promoting violence. So I'm gonna work on that. You have an idea for me? What is your idea? Too late today? Probably is too late today. Will the court reporter go? Yeah. Do we record the same as actual court? I'm not sure how they go about recording it, to be honest. So I got to write an appeal and basically say to them, once again, I'm not encouraging or promoting violence. Dress up like defendant whenever you're covering the trial. That sounds like a dumb idea. Does Alex go to the scene? Yes, he would, because he's a defendant. He's entitled to go. The hotel was lackluster. Stayed off the strip at a kind of a motel, to be honest, to save money. It was adequate, but certainly not nice in any real respect. They didn't even have cable. That was annoying. Did I see footage of people pulling people into the building? I haven't really watched any particular footage from the day. All right, I'm going to sign off for now. All right. I love you guys very, very much. All right, bye-bye.